May I mention a death row matter, Your Lordship? He's been a death row matter. He's been incarcerated for more than 30 years. He's been on the death row for about 19 years. I'm requesting for listing, Your Lordship. It is to be listed before a 3-judge bench. We had moved an early hearing application in which an order was passed.
Give the particular.
Yes, Your Lordship. Your Lordship is also sitting in a 3-judge bench this week, Your Lordship.
My lords,
Much obliged.
may I mention item 25, my lords? This is a bunch of civil appeals. Mr. Kapil Sibal is leading Meta Platforms in the matter. He's taken ill, so we are seeking an accommodation of another week, my lords.
Just give your note, please.
In fact, my lords, I am also mentioning on behalf of Mr. Kapil Sibal for a matter which is.
We have informed.
In the Meta matter,
Mr. Sibal is not well. He spoke to me. He is unable to speak.
no objection. No, obviously no.
You don't want to be taken up today.
But it's listed today. He is mentioning it not for next week. Sibal is not.
Well, if none of you have any objection, you can take up next
No,
week.
no, I've also filed an intervention application on behalf of All India Small Industries Forum, because we're all using WhatsApp business accounts. So we have got to say something.
Anyway, your lordship
Here,
will-
4 crore users are there.
You are seeking impleadment in that.
Yes,
If they have no objection, we can implead. You
but
also,
WhatsApp business is very important.
well, let's say application for, say, ISO and so allowed, to the extent that the applicants are permitted to intervene and assist this court.
Yeah.
The short affidavit, if any, may be filed within, by Friday.
Your lordship will list it not Friday week.
We will actually
He
take it
will
on.
not come without for a week, 10 days. So not Friday week, not this Friday, but next Friday,
The 20th.
Precisely.
20th. If it pleases the court.
Then should we take up on 23rd, Monday?
No problem.
Very well.
And we on 24 then, because too many SLPs will be there. That's why I'm suggesting.
23rd, the only advantage, Monday is miscellaneous day.
And your
So at least
No, let it come on a Monday, then your lordship take a call.
lordship, your lordship has listed this only
we
for.
will accommodate you, if you are busy in the other course, we will accommodate all.
That's
And your lordship has listed right now only for consideration of interim. For
Correct.
Friday, your lordship has given another date.
correct.
So, what is the main date in the main case then?
Your lordship has given in April. Yes. 15th April in the main matter. In the main.
So 23rd will only for that.
Consider me not on 23rd.
Whatever proceedings were to take place today,
Yeah.
those will now take place on 23rd February. That's all.
Obliged.
With your permission.
My lord, with your permission,
per-
my lords, may I mention item number 33 in tomorrow's list, my lord. Same Mr. Sibal is appearing and he's he's not well and we'll be seeking.
What happened to Mr. Sibal yesterday, the day before? I saw-
His voice, he's not well and I think he won't be, it's a like very bad viral fever he has got and.
Because of the change of weather or might be.
Yes, my
Yesterday
lord.
I saw him appearing in some function, you were there. So I just thought that he's fit and fine.
No, he is.
But anyway, that throat problem, he must take some rest.
Yes, my lords. My lords, I've informed the other side. It's for listed for tomorrow, my lords. I'll be seeking an adjournment.
The lawyer's
just-
problem is otherwise. They are good only when they speak too much.
Yes, my lords. That's also the.
A silent
We
throat
need
for a
a
lawyer
voice, my
may be
lords.
it can become a cause of ailment.
Well, I was just one request. This matter has been pending for substantial amount of time.
Please
And the
convey our
process has,
warm wishes to him for, we pray for his speedy recovery. Throat is something that, yes, one has to take rest. There is no way out of it.
Yes, my lords.
well, it's just a simple request. If a short date can be given, the matter has been posted for long. And I'm appearing in this matter, ma'am.
This very matter.
Yes,
In this very matter, we have informed
just
him.
a
this-
small request.
Oh,
If
you are
this matter
opposing.
can be taken up on a short date.
Are you opposing?
Yes, my lord.
No, she's
Just-
not
I'm
opposing.
proposing just
Opposing the
if this can be
cause
kept
of
for a short
settlement,
date.
But you are opposing a longer date.
Sorry, my
What are you opposing then?
my lord's not opposing. I'm just simply putting a request. If my lords can consider to put it on a short date.
We can accommodate you with the date of your choice, that's all.
Yes, my lords.
Provided that we too have some space on that day. If already there are sufficient matter listed, then there is no use of adjourning condition.
Yes, my
Right,
lord.
my
Keep on waiting whole date and might not come. So have a date when we can also accommodate you. Give it shortest date.
With your
Obliged.
permission, Lordship,
Obliged.
please mention WP Civil 13381 MC Mehta matter. I am the applicant in that matter. I have filed my compliance affidavit.
It's
The
all right.
report is.
MC Mehta matter I can't take up every day. But I have fixed a schedule. It will be taken up and all the pending applications we are taking one by one.
Your Lordship, the project is getting delayed. I have filed my
So
compliance
like,
affidavit.
make out a case of urgency, we will take up. When we list, we prioritize it. We do that homework and then only we list it. So we'll see that if.
Lordship, it is a task-related matter situated in.
Thank you very much. We will give it.
My lords, in the same,
Mentioning out.
my lords, in the same matter, the difficulty is that my application for the
You are
army,
making the same mentioning, then why two mentioning?
my lords, the application is different. I'm representing army.
All right, thank you. We are listing MC matter. Will not.
My lord, just a humble request, my lords, the date was showing like 10th, 9th and 10th, but it wasn't listed. My lords may fix a date and my lords.
Whatever the reason, whatever the ground, we will see it when to be listed. Thank you. Thank you very much.
My lord, may I mention one matter which is very urgent? My lord, while I was appearing on the last Saturday in the 30,000 court, in the court of ADJ Harjit Singh Pal, in the court of ADJ Harjit Singh Pal, where I was appearing on behalf of the accused, and my lord, the opponent, the complainant's advocate, along with many goons, entered into the courtroom. In front of the judge itself, they immobilized me, hit me, and all the accused inside the court were two.
Hit you as a counsel or they hit the.
I was a
client?
counsel. I was a counsel of the accused person.
You were assaulted.
I was also assaulted along with the accused person also assaulted. And thereafter, they locked the door inside the courtroom. Judge was sitting right there. All the members of the courtrooms were there.
Tell us
Police
first one
officials
thing.
were there.
You are bringing this matter to, when it happened?
Last Saturday on the 7th,
On Saturday. That means day before.
day before, my lord.
Today is Monday.
Today is
Have you brought to the notice of the Chief Justice of Delhi High Court?
No, my lord, actually nobody is supporting. Police is so scared, they are not even ready to provide
Forget
the
about police.
security.
If you can make mention before me, why haven't you made mention before the head of the state judiciary, Chief Justice of the Delhi High Court?
My lord, I have seen that due to the past incidents in the Tisazari, nobody is touching this matter because it is against. So I'm the member of the Supreme Court Bar Association.
Don't decide you are you make mentioning so that media can catch up it.
No, my lord.
Then have you made any written complaint to me?
No, my lord, this is a written
Please
complaint.
go make a written complaint to the Chief Justice of the Delhi High Court during the course of day and send a copy to me, inform my PPS that you have made a complaint, then let me deal with on administrative
My
side.
lord.
Nothing to be done on judicial side. I will deal with it. But first you go and make a complaint. Let the Chief Justice take cognizance of it.
My lord.
If the police is not, that means that there is no rule of law. You make a complaint, give a copy to me and tell the staff that you have made a complaint there.
My lord.
How can they misbehave like this? This kind of Gundaraj is not acceptable to us. Go and make a complaint immediately to the High Court. Yes, let us start.
May it please your lordship, my lord. May I request your lordship may take up the paper book of item 20, which is a.
Yes, item 120 and 41 are same.
Your lordship, may I see the paper book of item 20, because this is a case where.
You have already dismissed it. No. Notice in a similar matter, issue notice. What is the next date in that matter? It was on 29th January.
20 is
My lord,
also
it is
listed
in
today.
fact listed
It is listed today, my lord.
today.
Item 20. which
All
has
the
come up
pleadings are
after notice.
completed.
It is
All the
item
pleadings-
12.
Yes, my lord, because.
Are you appearing?
Yes,
So then please, would you like to file any counter in that matter or what?
we have, all the pleadings are completed from all sides. And my lord, in fact, we are ready with the note.
So then wait, we'll take up this matter along with item 12.
So notices will have to go in item number 1, 1.1, 1.2, 1.3.
My lord, issue is one and the same. Issue is one and
Issue
the
is
same,
the
my lord,
same.
on all the matters, 1 and 20 and 41. It is only, my lord, 2023 notification
The
of.
issue is very simple, that even if it pertains to the recruitment to judicial services, can the High Court assume the role of the subject experts? That is the issue.
And
Am I right?
That is one. That is one, my lord. Number two,
Ah.
my lord, when the
There's nothing like number 2, only number 1.
High Court is 134 is the total control of the entire judiciary recruitment and malad. Then how the malad public service
So
commission is agreed.
if a learned judge, suppose he masters in mathematics, And tomorrow the question of some mathematics question comes, why you should not review that also? Because he knows that subject, like law. The other brother or sisters can be maybe that he is BSc in biochemistry. So the question of biochemistry may come. Why not that also? Because he's a High Court judge.
A question of law, constitutional issue, my lord, now we are.
So we are only on the question of law. If you want us, we can remand the case to the High Court. If you want us to decide, we will decide it. But we have hinted you what is the question in our mind.
Your lordship, my prayer would be.
अरे भाई आपकी फेवर में बोल रहे हैं ना अभी तक तो आप थोड़े 2 मिनट चुप रहिए. So sir, please guide us. What is to be done?
But it can be heard, my lord, my lords may.
We have heard it. You answer it. Question is very simple. That under the law
Yes.
and whatever the precedents this court has laid down, should the court assume the role of super examiner
My lord, it is like this. My lord, the,
only on the presumption
yes,
or assumption that the question paper pertains to law, recruitment pertains to judicial services, and therefore the High Court, as anybody would like to assume and presume, High Court is in a well equipped as compared to the examiners. If this is the principle you want to lay down us, then sir, it becomes very dangerous.
my lord, it is the Public Service Commission, my lord, after issuing the revised key, my lord, sent it to, my lord,
The High Court can
administrative
always
side.
say, the High Court can always say that this question seems to be incorrect, the answer key, and therefore we refer the matter back to the Public Service Commission. Public Service Commission may constitute another independent body of expert. They may revisit it. This is the only law.
Your lordship. Your lordship.
This is the legal principle well settled.
Your lordship.
If you want, we can do it immediately. Let's not, because unnecessarily, otherwise it will delay unnecessarily.
Lordship is well.
All right, right. दोनों item का है. Item 12.
Your lordship.
Lordship, there is an intervention application in this matter, item 20. Counsel is appearing online, Lordships.
120.
Is my lord referring it to independent committee?
Independent of this.
That can be closed? Matter can be.
Lordships,
Yes.
Lordships, there is an intervention application on behalf of High Court.
We are allowing High Court on behalf of the High Court.
High Court of Jharkhand, kindly, and counsel is appearing on.
All right, all right. You are the counsel before us. You argue.
Lordships, the
We are a bit conservative. We are not very fond of online. So you argue. Now, give the mic. Give the mic to the young lady.
Lordships, there's an intervention application on behalf of Honorable High Court of Jharkhand. Honorable High Court of Jharkhand is a necessary party in this matter, Lordships, as the answer key was finalized from the High Court of Jharkhand for the judiciary examination, which is in dispute, Your Lordships. So kindly allow Your Lordships to High Court of Jharkhand to become a party in this petition, Your Lordships.
So if the answer key was prepared by the High Court, in that case, the direction can be to both to the High Court as well as to the Public Service Commission. Both will examine it. Both will revisit it. And High Court as a neutral umpire should be in the middle, not on left side or on the right side. Because courts are normally always on the right side, they have never on the wrong side. But in such like matter where you are a litigant, it is always ideal that you are the neutral umpire in between.
Obliged. Kindly make us a party, Your Lordship.
But are you right? This is the legal position.
Yes, Your Lordship.
Do you agree with the observations tentatively we are making with respect to the settled principle of law on this subject?
Your Lordship, High Court will make its submission in due course.
We will say High Court has also been heard. ये allow कर दो भैया. I335854 allowed. The High Court. You want to now respondent or you want petitioner? You want a respondent.
Precisely, that is the difficult part.
So you said middle point here.
High Court is not saying anything on administrative side. Well, in fact, on administrative side.
Micus. Say IAS once were allowed, the High Court of Jharkhand, through its Registrar General, is ordered to be included as a respond number 1A. Or say, both are stage 1 and 2. Then say 2A as respond number 2A. Say leave granted. The issue that falls for consideration is whether the High Court of Jharkhand, in exercise of its power of judicial review, rightly interfered in the key, answer key, published on 13 May 2024 in relation to, for the answer key of the preliminary entrance test held on 10th March 2024 for recruitment of civil judges in bracket junior division. The aforesaid preliminary examination was held pursuant to advertise number 22/2023 dated 14th August 2023. How many? 3 questions or more?
Yes, 3 questions. Question 8, question 74.
Well, in fact, I have prepared everything, notes and the dates and the events. My lord, so please explain and I'll finish.
The High Court, through the impugned judgment, has opined that answer key in relation to question number 8,
74 and 90.
question number 74
And 96.
and 96 was erroneous and as such
And paragraph 36. Paragraph 36.
Finish.
the impugned judgment, has concluded in para 33 that the key answer given by the appellant publisher distribution to questions number 8, 74 and 96 in booklet capital A are incorrect.
It's about 36. 36.
The High Court has directed to give 1 mark to the candidates who answered to option in bracket capital A in question number 8 in booklet A and delete question number 74 and question number 17 and 96 in booklet A from consideration. Next paragraph. The High Court, however, while the impugn judgment has held that in the absence of an express provision in a statute, rule, or regulations governing the examination, re-evaluation of the answer sheet is impermissible. Next paragraph. We have heard National Council for the Appeal and Public Service Commission, Common Council for the High Court, as well as National Council appearing on behalf of the candidates who approach the High Court under its jurisdiction. Next paragraph. It may be true that the subject examination pertain to recruitment to judicial services, and as such the honorable judges of the High Court, in the very fact, keeping in view their vast experience on bar and bench, are expected to have a better understanding and appreciation of the legal, the questions that were put to the candidates in the examination. However, even while accepting it as an undisputed fact, the question remains that the power of judicial review in the matter of re-evaluation, reappreciation, or reconsideration of the answer key would apply uniformly irrespective of the nature of examination. In this regard, it seems to us that the High Court cannot assume the role of super examiner, stroke subject expert, and such an exercise should ordinarily be left to the domain experts. It appears from next paragraph. It appears from the stand taken on behalf of the Public Service Commission is that the answer key was duly vetted by the High Court on administrative side. It may or may not be side also. If that is so, it is more than necessary that the High Court, while exercising judicial power, ought to have referred the matter to the committee of the High Court as well as to the Public Service Commission to constitute another committee of subject experts, enabling such experts to revisit the answer key in respect of question number so and so so and so.
May include one professor.
High Court ought not to have taken this responsibility onto itself while exercising the power of judicial review. Consequently, we allow this appeal in part to the extent that paragraph 33 and 36 of the interim judgment, 36 and other operative part of the judgment is set aside. However, the High Court has rightly restated the settled legal position that there cannot be re-evaluation of an answer sheet unless the rules, regulations, or policy expressly provide so. Then, for the reasons stated, we allow this appeal in part and set aside paragraph 33, 36, and other operative parts of the impugned judgment. The matter is referred to the committee constituted by the High Court on the administrative side to re-examine the answer key in respect of the disputed questions, and thereafter disputed questions and send its opinion to the Public Service Commission for necessary follow-up action. The needful shall be done within 2 weeks. Within 2 weeks. Next paragraph. It is clarified that we have not expressed any opinion on merits of the disputed question or the answer key.
May I only make a request where your lordships have indicated para 36. My lords may kindly include para 39 also.
When you said so other property, but you can 33, 36, 39 or any other.
Obliged to.
Malad, the
This
committee,
will apply to item 1, 20 and 41.
committee may consist of Malad, a professor and also Malad, subject expert on laws.
जहाँ पे committee लिखा ना, the committee comma, the committee may also associate some eminent law professors as domain experts for its assistance and guidance.
Because Malad, the entire contention is, one of the counters Malad says, that judges are not experts in English, so they are experts only in law. Malad may also say expert on English side also, a professor in English side, because they say, Malad, all the boys was in the room. Malad, this
One question pertains to
more than one boy.
On English professor also.
We have said subject experts, so that will include the English.
Well, they may not, your lordship may say English Malad because they
Such
specific.
expert in bracket, one of whom will be a professor in English. Huh?
Deeply blessed, deeply blessed.
One of whom will be a
So glad,
professor
my
in
lord,
English.
because already 2.5 years, my lords, already 2.5, my lord.
That's why we have said 2 weeks. We are only giving 2 weeks. Right? We request the High Court to conclude the pending selection process expeditiously.
My lord may say the process of the entire recruitment, because my lord, from September.
Same word we have said recruitment process. You are saying process of recruitment.
The entire process of recruitment.
Entire.
Well, maybe by the 3 months for that.
High Court and.
Because subordinate judiciary, they don't have from 2.5 years, there is no appointment. Already in 2023, it was 138. 2024, 25,
My worry is entirely different. That is one High Court where there is no elevation from the bar since 2017.
larger issue.
And neither any designation, madam.
Deeply blessed.
Yes, item 2. I think similar matter is pending, madam.
Yes, my lords.
But you are coming after such a long delay. Notice, issue notice returnable on so and so date, notice recondonation delay. Then after condonation delay, or tag with SLP civil diary number 28480 of 2025.
Obliged, ma'am.
Lordship, after the election has been declared, the date of election has been declared, substantive rules have been sought to be withdrawn.
What is that change in rule? What is that change in rule?
Yes, Lordship. Lordship, you kindly have page 80. Page 80 is a reproduction of the rules of Bar Council of India Uniform Rules. Now, this is an extract.
By mistake, it was not mentioned, so it is not a change of rule. The rule was already existing.
Kindly.
All right, thank you.
Anything? Point out, Lordship, what's the difficulty
Yes,
here?
yes.
Lordship, will kindly have page 80. Page 80 is the rule. Reproduction of the rule.
Yes.
16. it says that the returning officer shall reject the nomination paper of any person who were or are office bearers of any bar association on the date of notification of the election. Now, this was the rule. Now, after that, on 17th of January, Lordship, we'll find page 81. They sought to withdraw the rules. Now, Lordship finds what is the mandate of the election officer. The mandate which was, which the court directed was to conduct the elections and to facilitate
Sir, why that was withdrawn? Because the notification is as per 2023 rule. The rule that was in.
I'm sorry, Lordship.
Come to page 76.
23. Yes.
Come to page 76.
Yes.
Read the first line.
Yes. Notice is hereby given under Bar Council of India rules for qualification, disqualification, and produce for election. And so, Lordship, see, this was a notification, Lordship, does not stipulate.
Sir, the notification is in terms of the latter rules. By mistake and clause of the earlier rule which stood over supervened by these latter rules was incorporated. This error was corrected. This is not changing the rules.
Please consider, Lordship. Please consider for one moment, Lordship. 23 rules did not stipulate this condition. This was in the 2016 rules.
Correct. 2016 rule has been overridden by the 23 rules. So the notification having been issued under the 23 rule by incorrectly referred to 22 rules, that was corrected by the corrigendum. Where is the change of rules?
So Lordship will at least consider, Lordship, that
Nothing.
after the election was
Thank you very
notified.
much. No question to be made of dismissed. Item 4, there is a letter circulated.
Please.
Milords, in item 5, Milords, the Maharashtra Pollution Control Board, Milords, issues us a direction to undertake the assessment, Milords, the damage assessment for an accident that had happened at our premises.
Yes.
Milords, in terms of that direction, they only give us 3 institutes where we could go and get the damage assessment from. One was NEERI, IIT or VSI. We go to VSI, and in terms of this direction, we appoint VSI for the purposes of.
So one of the expert body has assessed the damage, sir. We are not the mathematician or we are not the super experts here.
No, Milords,
An expert body, all of you agreed that there are 3 institutions of prominence who can do it. One of them has been picked up by the tribunal. Assessment has been made. Lossy accident, you don't deny.
No.
The molasses spread it over so many areas, spoiled the
Yes.
agricultural land. That is also an admitted fact.
Milords, may I just say, Milords, 2 points. Subsequently, Milords, there is a joint committee report of the Pollution Control Board itself, which shows that I have done the remediation work at there, Milords, in the area, Milords. I have done substantial compliance of the remediation of the accident, Milords.
Yes, sir.
Thereafter, Milords, the expert authority or the expert body goes. All I am saying is, Milords, the sampling was not in terms of section 21, Milords. Please, sorry.
Follow the guidelines and then only
No,
assess.
Milords, those guidelines also, Milords, do not ask them to take away section 21 of the Water Act, Milords.
Yes.
All I am saying.
You have been given opportunity by letter dated 23/2/2023, after the samples were collected on 5th and 6th of February,
Please.
notifying you, if you wanted one of the samples to be sent to the central laboratory, you could have. You have missed the opportunity. Now,
No, Milords,
cannot
all I
done.
am saying is the sampling was not done in accordance with law.
it was done in accordance with law. The only thing is,
Please.
your case under 21(2) or 21(3),
Please.
you had an option to send one of the samples to the central water laboratory or the state water laboratory. You were intimated of the drawing of samples. You were intimated of the fact that this specialized body, which was chosen by you, was analyzing. You did not opt out
The water.
of that.
Show the conclusion of the body, Milords, just for a minute, Milords, just one page, Milords. Just if your lordships should kindly come to page 200, Milords. And if my lords may kindly see at the bottom of 200, they have given a finding in my favor, Milords, of the water.
The authorities will consider that.
No, Milords, but with that, Milords, they've also imposed a damage assessment of 2 crores, which will now.
Very right action. That just immediately.
Remediation being done, Milords.
Remediation and environmental damage costs are different, sir.
Because we have completed the entire remediation. If your lordships will come to page 200, at 200, the report gives the finding that the sampling has been done and it is correct, my lords, and there is no difficulty in that. The entire remediation has been mitigated, my lords. That's the finding, my lords. Only on this point I was before.
No, please, let's not, because we also know our scope of interference in the law.
Lords, may I then just request, my lords, this may not come in my way to raise the challenge because they are still considering the report on the next date of hearing. Because as far as the amount calculation of 2 crores is concerned, my lords, there
Better
is some
than
kind
you,
of an ambiguity.
better you withdraw, with the liberty to raise whatever your contention there.
That's right.
After arguing the case for some time, non-counsel for the appellant seeks and permitted to withdraw this appeal, with liberty to raise all the contentions before the tribunal,
Please, my lords,
before the tribunal at an appropriate stage.
I'm so grateful.
This is a larger policy decision on behalf of the state of Himachal Pradesh to decongest Shimla. Two, my lords, in this case, we have a much larger premises available in a ready building in Dharamshala. There are a large number of other offices also in case of other commissions and boards which are being shifted. My lords, from the demographic aspect, people find it very difficult because the largest concentration of, my lord, the backward communities are in the Kangra district. That is also admitted by the petitioners, my lords, and in the employees' representation. And there are a handful of employees, they are not going to be moved, my lords. The class 4 employees and the lady employees, my lord, my instructions are they are not going to be moved. This particular office in Shimla is going to continue functioning as a camp office where some hearings will be held. But, my lord, there can't be a blanket stay.
This order,
Your Lordship, with regard to the fact, my lords,
the High Court will decide where publicity commission should be there, where backward class commission should be there.
Your Lordship, my humble submission is that basically they have not.
Anything you shift from just Shimla to Dharamsala, we understand that when the tribunal was shifted, this state administrative tribunal, you people will go on strike. Why not continue in Shimla? Everything continue. Shimla, there is space crunch. Dharamsala is an alternate place. Assembly also takes place. Your summer, your winter session also takes place in Dharamsala. So what is the problem if some of the offices are shifted?
It's not about some of the offices, my lords. They have also shifted some another offices. With regard to that, with regard to those offices, the Honorable High Court has not issued an order of stay, my lords. In these two matters, my lords, the Honorable High Court has taken a specific.
Was this petition filed at the instance of this landlord whose premises has been taken on rent for 22 lakh something?
No, my lords, because.
Then who is the person behind it?
Your Lordship, he is the ex-member of this aspect.
What is their problem? If they are ex-member, they are not supposed to go there.
My lords, they have not even filed
And who are they to dictate an elected government that where should the office be? It is their prerogative. If you have any problem, when the next election takes place, oppose them on the ground. How this issue becomes justiciable?
With regard to the decongestion, my lords, there are only 11 employees, and out of 11 employees, 6 are class 4 employees, my lords. And the building has been leased out, my lords. And there is.
Building has been leased out. When they will shift it, they will vacate the building.
My lords, one
or they will utilize the building. There is a lot of other offices which require building.
On one hand, they are sealing
Why the High Court is unnecessarily indulging in these things?
Your Lordship, because basically why this relocation order has been passed on 3rd December. My lords, in December, the new chairman was appointed. Subsequently, on 24th December, he floats this proposal for relocation. So this particular relocation order, it is on the behest and for the facilitation of the chairman, my lords. It is this commission is working since 1998, my lords, over there.
Are you aware of you are practicing there?
Yes, my lords.
You know very well.
Yes, my lords.
This your state administrative tribunal has been in Dharamsala? Has been in Dharamsala for all the times? as and when the state administrative tribunal is constituted, it is in Dharamshala only. अरे भाई आपको पता है मेरे को पता है.
Shimla,
I was the chief justice when I abolished it.
it was circuit bench
And
used to
since
go
then the tribunal has not been constituted.
circuit bench used to
Lawyers in Dharamshala have been agitating it.
Yes, ma'am.
I went there when Palampur court was inaugurated. The lawyers were raising all the demands. Sir, we have been having at least the tribunal, you are not constituting the tribunal. I said, no, as a matter of policy, I don't want a tribunal because a litigant has to go to two platforms. First he will go to tribunal, then to high court. So why burden the consumer of justice for that? So they agreed. They didn't go on strike. They were happily. They had some reservations, but agitation, but they never go on strike. So today, if some of the offices like winter session of the assembly is being shifted to Dharamshala, what is the problem? It is not a court that lawyers will oppose.
Your Lordship,
It is an administrative office of a commission, a backward class commission. The commission will operate, they will have to make assessment in the state. They can do it while sitting in Dharamshala. They can visit other areas also. And Dharamshala is not something in Kinnaur district or where you can say accessibility is poor.
that is why
Dharamshala has better accessibility.
that is why, my lords, the Honorable High Court has cautioned the state that the offices which are having a larger strength, they should be shifted rather than the offices with minuscule strength.
High Court should refrain itself. We are not experts on these things.
My lords, basically this.
High Court, we understand. Near the High Court, there is a government building. You suppose have space currents. High Court say this building is lying unutilized or underutilized. Please give it to. We require it. High Court requires for expansion of the courtrooms, expansion of the establishment or anything. Understandable that you raise your demand. How are you concerned how the backward class commission will work?
But if it is for the benefit of only one individual, my lord, it is only for the chairman. Chairman gets appointed on 3rd December.
What is your problem? Yes, why not? If the chairman wants to, as per his convenience, let it be. People will answer it in the election.
In the meanwhile, he has also communicated that a camp office will be started at the same premises. On one hand, they are assailing this order. On the other hand, they are communicating that they.
Is required in the original office, but because the demographic, Malad, overwhelming, the backward classes are from that area in Malad Kangra. So they will find the access, Malad, much better in Dharamshala.
But they know very well it's not so easy to it's not so easy to travel in the remote areas in Himachal. Some of the villages still you can't go in a car. You can't go in a bus. You have to climb down. Then only you can reach there. So for the purpose of accessibility, but when we talk of access to justice, when we talk of court at the doorstep, when we talk of ease of justice, are we not these factors taken into account?
But my lords,
People who are actually backward class, don't they have a right that somebody will come to them, find out, yes, they are living in these conditions, therefore they are entitled to certain benefits of the social welfare schemes.
but with regard to that fact, my lord, from Shimla, they are doing certain other exercises with regard to the elections also.
All right. Anything else?
My lords, they have issued one communication wherein they are saying that the proposed office, which they have earlier allotted for the purpose of this backward commission, now they are saying in this communication that it will be for the camp office. So once they are opening a camp office over there, my lords, so there is no point of shifting the headquarters.
Let them decide. It is their prerogative. They want to have camp office, they want to have principal office, but they want to have any other office.
We will file the response.
Let us, the judiciary, we should remain aloof, away from the decisions, assuming those have been taken for political considerations, unless we find firmly that yes, such a decision is directly in the teeth of the constitutionality, constitutional philosophy, some part 3 or any other provision of the constitution. There we need to interfere whether it's a political decision or non-political.
My lord, they have not even filed the reply for the Honorable High Court to take into consideration those things, my lord.
Yes.
Without even availing the elementary opportunity.
And therefore, without even taking the reply, the stay has been granted.
My lord, with regard to the communications, for the reason because as per the communication, the chairman has issued a proposal. Now he is saying, and already the state is saying they are in a financial deficit, my lords. So once on one hand they are saying we are having a financial distress, on the other hand they are shifting the offices.
There is no further explanation.
State of Himachal Pradesh is aggrieved by an interlocutory order dated 9th January 2026, passed by a division bench of the Himachal Pradesh High Court, whereby shifting of the office of Himachal Pradesh State Commission for Backward Classes from Shimla to Dharamsala, from Shimla in bracket Kasumti to Dharamsala has been stayed. Next paragraph. Since the issue that arises for consideration pertains to grant of ad interim stay, it is not necessary for us to state the facts in extenso. Suffice to mention that the Himachal Pradesh State Commission for Backward Classes has been constituted for identifying the caste and communities who are entitled, who would be entitled to certain benefits meant for the backward classes. The chairperson of the commission was appointed on 3rd December 2025, followed by induction of members on 23rd December 25. The state government thereafter took a policy decision to shift the office of the commission from Shimla to Dharamsala in Vaipat district, Kangra, and to maintain a camp office in Shimla. Next paragraph. Learned Counsel for the Appellant State submits that such a decision was taken in public interest, keeping in view the demographic realities, as most of the backward classes, as the OBC population is largely residing in the lower hill districts, broadly known as Kangra and adjoining area. The shifting of commission to Dharamsala will facilitate the access to the commission, will facilitate the commission to have access to the OBC communities, most of whom live in remote rural areas. Next paragraph. In our considered opinion, in our prima facie it seems to us that shifting of the headquarters of an institute is essentially a policy matter where there is least scope of justiciability, save and except when such shifting directly affects the constitutional or civil rights of the public at large. It is difficult to formulate such an opinion at this stage when the state government has not even filed its counter affidavit. As the matter is pending before the High Court, we do not deem it appropriate to make further observations touching the merits of the case. However, there seems to be no justification at this stage to restrain the state from shifting the office of the State Commission for Backward Classes from Shimla in bracket Kasulti to any place in Kangra district, including Dhamsala. For the reasons aforementioned, we allow this appeal, semicolon, set aside the intent order dated 9/1/2026. The appellant state shall be at liberty to shift the office of the commission to Dharamsala or any other suitable place, subject to final outcome of the pending proceeding. That's paragraph. The state government or the state backward class commission may file their replies to counter affidavits within a period of 4 weeks. The writ petitions may file their rejoinder if any within 2 weeks thereafter, to enable the High Court to decide the case on merits. To enable the High Court to decide the matter on merits, to finally decide the matter on merits. That's paragraph. It is clarified that the observations made herein above are for the purposes of interim stay. So the appeal stands allowed in the above terms.
We may be permitted to give a physical appearance in this matter. We may be permitted to give physical.
You want to file appearance? Sure.
Obliged.
Well, it's item 7. This controversy, my lord, can be traced back to a minor ammonia leak that happens in a French fry factory. My lords, as soon as the incident takes place, my lords, when the incident took place, my lessee was in fact in possession of the property. Thereafter, my lords, soon after, the authorities come and shut down the entire plant. I approached the High Court, my lord, for desealing of the premises.
Why didn't you go to NGT?
My lords,
Why didn't you go to NGT?
my lords, I was impleaded, my lord.
NGT proceedings were there, you got yourself impleaded. Now you open a second parallel proceeding before the High Court.
No, my lords, if I may just correct you, if I may just point out this alone. NGT proceedings were so moto initiated and I was only impleaded, my lord, subsequently.
Yourself, so if you had any grievance with regard to the sealing or its import, you ought to have approached the NGT. Skirting the NGT, going to the High Court, isn't it forum shopping?
Well, today I only want one small relief from your lordships, my lord. I only want my right before the NGT be kept alive.
No, you want to go, please.
I'll go before the NGT, my lord. Lordship may kindly clarify that they may not be influenced by the High Court's order.
You don't require any clarification. You are not here before us to seek this clarification. We are not your advisor.
My limited submission, my lord, is that the desealing of the premises can be subject to the orders of the NGT. My lord, tomorrow if the NGT actually, my lord, states that the premises is all the activities are being carried on in accordance with law. Interesting.
So, and.
I have no intention of running the unit unless and until I have the blessings of the NGT.
Sorry.
I don't want to run the unit. I only want your lordships to say that the NGT may not be influenced by the High Court's order. I'm obliged.
The problem will multiply when the other party comes.
Tomorrow if the NGT doesn't find fault with me, I'll have to file another writ petition, my lords, and get a clarification from your lordships once again.
Maybe
Is my
we
only.
will rely upon that we have already, this is a seal of approval of this order.
I'll leave it to your lordships. I'm obliged.
Yes, madam.
These are which matters? These are left out matters.
Yes, my lord. Some matters which remained on that last date, my lords, when my lords were pleased to grant us the absolute bail where my lords are granted interim. These are ED bail in the same matter, my lord, in DMF, wherein the predicate my lords have granted us bail. My lord, the second one is a ground of arrest that we have challenged for Ranu Sahu, and third is a DA case, my lord, in which my lords were pleased on the first day to grant us interim protection because I was already in custody for around period of 2 years.
Are these matters where you came late and we had issued notice on that date?
No, these are matters that were left over, my lords, which could not be heard.
Could not be taken. So I think we'll not be able to take a different view.
In item 9, minutes is a writ petition. 8 minutes.
My lords, I appear for ED in 8 and 8.5, my lords. Sorry, 8 and 8.1, my lords.
So do you have that old chart which we are having on the, Madam Ashwarya, do you have?
In my matters, my lords, for ED, your lordships may record my objection and I leave it to my lords.
All right, yours is item
8.1, my lords.
8.1.
Yes. 8.1 is arrest, my lords. I think there may not be too serious pressing that. That's quashing of arrest.
My lord, 8.1 is we were challenging the ground of arrest. So my lord, if bail is being granted in 8, my lord, then we will not press that.
Yes, so lordship may record that and then I.
My lords, I appear.
Dispose of 8 and 8.1. In this matter, my lords, interim bail was granted on 29th May 2025.
Where is the note?
Is going to be another.
And is also this Ranu Sahu.
So 8 and 8.1 are Ranu Sahu, my lords.
The ED matter.
Yes, 8.1, they won't press. They are. So lordship may record that. And interim bail, my lords, was granted on 29th May 2025.
My lords, 8.3 is also a bail matter of a smaller player.
8.2.
Come one by one. So this 3145.
My lords, that is the ED DMF bail, my lord, on which my learned by the senior is saying that she is not going to press only formal objection. The interim bail of 29.5 can be made absolute. 8.1 I will not press, my lord.
Anyway, 3145 we will allow
My lord.
in the sense that interim bail already granted is made absolute. So this will be same order as.
Yes, my lord. Same orders.
We had earlier recorded Mr. Raju had appeared on that occasion. So same paragraph except that instead of Mr. Raju, Madam Ashwarya will appear. So 3145 is allowed to this extent.
3644 not pressed.
And which one you don't press?
My lord, 3644, my lord. It was in the same matter, ground of arrest we had challenged in the High Court, my lord. Say SLP against that one.
No, 3644.
Yes, my lords.
You don't.
We will not press, my lord, because my lords have granted us bail, my lord.
Say, in view of the fact that while separate order of even date, the petitioner has been released on bail.
My lords.
Former learned counsel for the petitioner does not press this petition.
Most of
them. Accordingly, dismissed has not pressed for.
Grateful, my lords.
So now we are left with, at serial number 8, there are two matters only.
No, my lords, there are more.
No, 8.2 is a writ petition filed by Ranu Sahu, minutes. No notice has been issued. We have not been served, minutes. 8.2.
8.2 is a writ petition, my lord, because I was arrested 3 times consecutively. Whenever my lords used to give us.
We can't issue omnibus direction. It will be very difficult. Tomorrow, if you come assuming, we are not saying about you, but assuming a person, he says, grant me a a preemptory bail order and he commits murder, the authority will be helpless. They will keep on watching there because the Supreme Court has said that no, we can't arrest you. So it all depends upon, we have been rescuing you as and when occasion arises.
My lord, I bow down to that. We only came, my lord, after 2 years, when my lord, on 3/3/2025, in a matter where I was under arrest for around 1 year, 8 months, my lord granted us bail. ED on the same day moved a production, my lord, and then sought my arrest. It is only then, my lords, that because it was becoming something in perpetuity, my lord, because I was getting bail by my lords were kind enough to grant us bail. The next day or the same day, either EOW or ED was coming and arresting us, my
What it
lords.
seems from the variety of cases against you by ED, by Anti-Corruption Bureau, by this.
My lords have been extremely kind to us, my lords.
I think my
Same
colleague should
property.
choose between not pressing or dismissal.
No,
Violence.
my lords, it's writ, my lord. The same issue, same properties is being circulated in all cases, my lord. In DMA.
Maybe obviously because if you have, their allegation ultimately is what?
State.
That you being an IAS officer, you misuse your position, abused your power and earned illicit, right, benefits, maybe through gratification, maybe through shareholding, maybe whatever. These are all set of allegations subject to trial. And you have parked that money in buying some property in your name, buying property in the name of your brother or your family member. So ultimately it is the Indian currency only. They are not talking that you are converting into dollars. It's the same property, same set of allegations.
I am in my lord's hands in this, my lord. My lords may decide it as these are issues that we have raised, my lord. One only thing, my lord, that there were DMs after me, there were DMs before me. Nobody has been investigated also, my lord.
Withdraw this petition saying that you will approach the appropriate form as and when occasion arises.
Permit us to come back also, my lords, if they file another case.
You have been, there is no question of coming back. You have never gone out of the court. You have always been here in one or the other matter. You are always, any litigant who is aggrieved by of an action or whose liberty has been supposed compromised, we never say our doors are closed. You are always,
I leave it to my
will consider as per law. After arguing the case for some time, learned counsel for the petitioner does not press this petition. As according to him, he will approach the appropriate form as and when occasion arises.
My lord.
Ordered accordingly. Now, any other item?
8.3, my lord.
8.4. 8.4.
8.4.
8.4 is a matter where anticipatory bail of Ranu Sahu Malas. My lords were pleased to grant her interim bail on 29/5.
That
in
matter.
Yes, Malas, in DA case.
So here also we make the same, these also made absolute on the same.
Most of that.
My lords, 8.3 also is the same. It's a Manoj Kumar Dwivedi. He's a smaller player.
Yeah,
He may also be granted.
8.3 is
8.3.
Yes, my lord. Manoj Kumar Dwivedi.
So that's also same.
He was granted.
8.3, I don't know.
8.3 is an ED matter, Lord. Mr. S.V. Raju appears.
ED matter, you are right.
Yes. In that matter, he had asked me to take a passport.
He is not better than.
I get it. The interim order is there already.
The same order. All right. ये ईडी का मैटर होगा इसमें मैडम ऐश्वर्या का इनका साथ में he is appearing independently. Raju sir.
Yes, Mr.
Raju along with this young man. 8.5 is also there.
8.5, he was not arrested during investigation. He's an excise officer. And my lords have granted bail.
Excise officers order.
My lords, while order dated 29/8/2025. Malas, he was not arrested during investigation and was granted bail by this court, interim bail. Yes, Malas, interim bail.
Released now.
Yes, Malas.
Say the
Same. I need to verify them.
no, this is Vedram Lhare, na?
Laren.
So we had passed an order on 23rd September 25. Meanwhile,
Make it absolute.
so we made.
Yeah, absolutely.
So for the reasons recorded in our order dated so and so, passed on so and so date, the interim order dated 23rd September 25 is made absolute on the same terms and conditions which we have imposed in the similarly, in the case of similarly placed petitioners co-accused. All right, that is also finished. Any other matter?
Malas, item 9.
Item 9.
9, my lords, I'm seeking 2 weeks' time to file a rejoinder. Their counter has come in only on Friday.
Malas, this is
2 weeks
same
after that.
matter as
My lord,
Ranu Sahu.
hold on, my lords, they filed a counter affidavit. I'll come back.
This is same. He's seeking similar omnibus prayer, Malas.
I want to file my rejoinder, my lords. I don't know why should there be a problem with that.
A similar
Lordships have
matter has
issued
been-
notice, my lords.
Prayers
It
are
takes them
similar
2
to that
weeks
as.
to come back in my this thing, my lords. They filed a counter on Friday.
You can approach the appropriate.
My lords, I've already approached the appropriate forum. I've come not in a direct 32 here. I've come against a 226 dismissal. So please give me 2 weeks, my lords. I'll come back in my rejoinder also. There are some new facts that they've taken. We'll respond back. So after 2 weeks, if your lordships will have.
Bail or
My lords, my
Christian
application
pray that
is rejecting alternative remedy one, and then second saying that you should have either filed a quashing or you should have filed a anticipatory bail. Now, neither of them in my case will apply, my lords, and I'll point out why. I'm just taking 2 weeks' time, my lords. If your lordships will accommodate me only for 2 weeks.
so let me take up on
Great.
Friday. What about 10?
My lords, in item 10, I am seeking a pass over, my lord. Item 10, I am seeking pass over.
Small player,
Maya Warrior. He can also be granted. He is there for the ED.
ED Lordship, I am appearing. I am led by Mr. Raju.
So he is a very small player as compared to.
Yes, but Lordship, if sees the prayer B does not exist because prayer B was not there in the special court's order. So prayer B does, because Lordship, the order that was granted bail said the conditions will be imposed by the special court. Special court has not imposed any condition that is pleaded in prayer B of the IA. So prayer A, I leave it to your Lordship if Lordship wishes, but prayer B does
more
not.
conditions to be imposed, sir.
That all in a very stringent conditions we impose.
Yes, but Lordship, I am
Those
saying,
condition will apply here also.
yes, but Lordship, if only comes to page 5. Prayer B says, direct the petitioner to report to the concerned police station, EOW, ACB, Raipur or any other police station once a month or fortnight. That condition was not imposed by the special court. So the condition that she is asking for waiver of is not in existence. That's what I'm pointing out.
Now, what is prayer number 5?
Prayer, page 5, Lordship comes to the IA for modification of bail condition.
Prayer B.
What is it?
There is an IA.
Report to the concerned police station.
Yes, this condition was never imposed by the special court.
This was never imposed, so this is infructuous. No, sir.
Yes. Lordship will find the conditions that were imposed in page 13.
My lords,
No, but where is this condition imposed by us? In the order of 6th of October.
Yes, Supreme Court by order dated 6th of October said conditions will be imposed by the trial court. Lordship will see that in page 9 of the same IA. The Lordship will see the conditions which were actually imposed by the special court in page 13.
No, but 6th of October is very short order by us.
The 13, 14 is of conditions imposed.
These are condition imposed by the trial court.
Trial,
Yes.
there is no condition of meeting the investigating officer.
Reporting. Which is the condition this one?
Sir, stay outside, stay away, submit affidavit, surrender his passport, and so on, so on.
Yes.
my lords, I
Mechanically it has come.
For the enforcement, after hearing Shri Raju along with so on behalf of the enforcement directorate, from the interim order dated 6th October 2025 is made absolute, subject to the same terms and conditions as have been imposed by the special court, special judge.
Special Judge Dhan Sadan
Displaced.
6th Additional Session Judge Raipur, Chhattisgarh.
Special judge in bracket Money Laundry Act, 6th Additional Session Judge, Raipur, wide order dated so and so.
7/10/2025.
Order dated so and so.
7/10/20.
Grateful, Lords.
Please, Your
Now your matters are over, which Chhattisgarh.
One item is there. Please, Lordship.
14
is still left.
14? Okay, we'll see, just in 2 minutes we are reaching there, 5 minutes. Item 11?
11, I must at the outset apologize. My counter was filed a little late, but I have copies, my lord. I filed a counter for the state.
In item 11?
11.
Counsel for the state of Maharashtra state flat. Counter affidavit has been filed, but the same is not attached to the, is not tagged with the paper book. Registered to do the needful. Next Monday? Next Monday.
Next one, I'm.
Post the matter next Monday.
Very. I'm grateful, my lord.
My lord, one request, my lord, if possible, may be kept on 18th. Monday, 16th. 18th is if possible.
All right, sir, we will comply with your. Yes.
Item 12, my lord.
Item 12.
12, my lord. Charge sheet was laid, my lord, in the year 2023. I appeared before the court, coming up after notice, my lord. I appeared before the court, executed the bond. Subsequently, on an application filed by defective complainant, one more charge was added. Therefore, my lord, my bail bond was cancelled. I moved for anticipatory bail. Sessions Court granted anticipatory bail. The Honorable High Court reversed it. So against which I am there, 2023, my lords. Violation of trademark.
Your anticipatory bail was cancelled. We have stayed that order.
Yes, ma'am.
He wants to make it absolute.
Granted.
My lord, they have not only misused my company's name, they've been selling poison to the public. High Court in its order, my lord, High Court has clearly said, where is that order? That is page number 198 of their SLP, my lord. High Court says that when they went for testing, they were absolutely unsafe for human consumption. My lord,
That's right, that for that, whatever the trial will take place, and if they are found guilty, obviously they will face the.
I say, my lord,
consequences.
the bail was granted only on the ground that overlooking section 467. They said all the offences are, I apologize.
The best course for the state is that, the powers are very well there. They can seal the premises, they can close the premises where it is found that what is being manufactured is basically a poisonous substance. They can always do that. There are other provisions. That does not mean that criminal case will not continue. Criminal case will also continue. But for that preventive measure, they can take other steps.
My lord, High Court has said that you surrender and apply for regular bail.
State, and we hope that the state will.
Madam, I'm pretty for a state, my lord. My only the legal submission is that once they have appeared and took regular bail, then the question of anticipatory bail is not there. They should go and take the regular bail. Who's going to
Bond was
stop?
cancelled. Therefore, we.
Well, we have heard and senior counsels to counsel for the parties. It seems to us that there do not exist sufficient and valid grounds on the basis of which the High Court could recall the order granting anticipatory bail to the petitioner. So, आपको leave करके कर देना कि order satisfied करना. Consequently, the appeal is allowed. The impugned order dated 17 December 25 is satisfied. It is directed that the appellant shall continue on bail, subject to same terms and conditions as already imposed during the pendency of the trial. Next paragraph. It is, however, clarified that the granting of anticipatory bail shall not be an impediment for the competent authority to take other preventive measures against the industrial unit if it is found that the product contains any poisonous or unhealthy substance. We have clarified that, now we can.
Take it. No problem. Black.
Safety law को करना, food safety law में करना,
So under the
FSSAI.
describe the total.
Come from that sector. Next year, producing, that's why I got that. Okay. Please, my lords. Let's, please, my lords. Let's, despite this vicarious liability, my lords, I just explained that I've already undergone 9 months, my lords. If it is considered under section 26, that is violation of conditions of license, the maximum punishment.
Who is opposing from the respondent?
Don't argue that, sir. Don't argue all that drug and cosmetics.
Please, my lords. I'll argue on
With
merits.
regard to your
Kind
complicity.
of medicine your partner is recommending, it is not under the drug and cosmetic.
Yes, ma'am.
Very easy to see.
No, I'm talking about 26 only. But NDP is 26. But on that, my lords, I'm not leaving that for the moment. On merits, my lords.
No, we
Who is
followed
appearing
the
for the
sub-
response? Service they could.
So Dr.
Trademark.
Dr. Malhotra had
Yes, he is true, my lords. And he was running. I'm only a silent partner.
Silent partner. But we are surprised doctors are doing.
But my lords, your lordship, kindly see, there was no animus because in fact they are searched.
In Punjab,
It's a malice. It has to be.
drug mafia includes.
Yes, it's a mafia.
People are making lucrative money. The doctors, the so-called industrialists, the police, and so many people are hand in glove. Unfortunately.
But one interesting thing, my lords, why this Malhotra might have done it, because the search in the pharmacy took place on 28th. Then thereafter, the search here took place on 2nd, next month. So even knowing that the search took place in the pharmacy, these people thought that this is nothing illegal here. Otherwise, they would have removed it. If they had some idea, Malhotra on paper, no person with a reasonable sense will not order for some.
Let us not open our mouth because it's for the prosecutor to move
Absolutely.
the case.
Absolutely.
But this was under the cover of using it as a medication. They were dealing with a Schedule H drug for which even the hospital does not have the license.
Deeply obliged. Return of some early date may be given.
Trustee also.
Deeply obliged.
Notice देना. Notice देना है सबको ऊपर देखो.
पहला फर्दर वाला है सर
Yeah.
14 है ना
Lordship, in item 14, but not one and point, but for the state.
I'm there in one. Password? No, not a password. Not a password. 14 का नंबर है, cancellation. Well,
ये वो दूसरे वाला है सर ना 14 14 वाला बेल से देना सर उसके अंदर सर ये ग्राउंड्स पे बेल मिली है सर डिटेल ऑर्डर है सर वो कहते हैं कि नोटिस इशू कर दो उसमें नोटिस इशू कर दो ये बोलेंगे ना उसको स्टेट ऑफ छत्तीसगढ़
So we'll take up this matter after some days.
at least notice may be issued.
No, no, my lord, I have serious objections to this. This was argued at great length. Your lordship will see the orders. Every contention has been considered.
My lord, that's my whole case. I'll point out in two.
No, I'll also point out.
Notice again delay, my lord. At least
No.
it should be issued. I'll point out that none of my arguments
My lord.
have been considered. And my lord, there are some propositions of law, with the greatest respect to learned judge, my lord, which are not tenable.
It's a very
Your,
detailed order.
your lordship will see.
Detailed
50
order.
pages.
It's not a detailed order.
Can't be not a regular.
How can-
Against a bail order. It should be a ground.
My
for
lord, it is
cancellation.
not a detailed
So
order.
now every order will come on an appeal like this.
59 pages of narration of facts.
Coming in every case, my lord, this is.
Every aspect was considered, my lord, and at length for many days.
I thought it's my petition, my lord. I should be.
We are opposing your petition.
Of course.
By saying this is, your lordship has done, my lord, so many of these cases.
Today, for some
Well,
reason,
this
we are not, we are not saying anything for today for some reason.
Very well.
We'll take up this matter after a week or so.
Yes.
After 2 weeks, my lord, I have some difficulty. After 2 weeks.
My lord, because this man has been released on bail, a vital witness is not attending anymore.
My lord, that
His
in fact
his
is an
best
issue
friend
which
Manav,
needs to
a
be.
chap called Manav Saxena. Well, I'll point out what kind of.
You can bring those, so if any subsequent events.
Yes.
Because 2nd January means now more than 1 month.
Yes, we will bring
If
that.
there are any visible subsequent events, you can place on report. Meanwhile.
One of the main grounds that vitiates it is, my lord, that this man's name was not mentioned in the FIR, therefore it should be granted.
Lord, may I draw your lordship's attention, my lord, Chief Justice. My lord, in 14.2, this is that lady Soumya Chaurasia. Soumya Chaurasia. My lord, she has been granted interim bail in a large number of cases by your lordship. My lord. She has spent 2.5 years in jail in and out. Your lordship asked her to stay out of the state. Now they have registered a fresh FIR in December this year, again relying upon material blood of 2019, and she is arrested. I am requesting.
So, but December is much before we pass this order, last order.
Not fresh FIR.
December means much before.
No. I am. My lord, arrest is in December. She has been arrested now in December. My lord, I am praying for interim bail. My lord, she has been granted interim bail by your lordship over the last 2 years.
But file some petition, Mr. Rohit.
We have filed. It is listed 14.2, my lord. Notice was issued by your lordship.
14.2 and 14.3, Mr. S.V. Raju appears and
This is-
taking a passover.
In that liquor case. This is ED liquor.
14.1 and 14.2.
No, one is unrelated.
This is the 6th time she is arrested.
No,
5 times I have got.
14.2 is a writ petition under 32.
Yes. But I am saying this is, my lord, a evergreening of arrest. How many times, my lord? 22, 24, 25, 6 times the lordship granted her bail.
It's a writ petition. Anyway, there is no requirement to serve.
My lord,
Pick up your matter within a week. You file a petition there. The instant writ petition under Article 32 has been filed
lordships have granted.
by the petitioner.
Notice issue.
Questioning the vires of section 44 of the MLA. However, we find that in substance, the petitioner is seeking her release on bail in a matter in which she has been arrested on, what is the date of arrest? On 16 December 25. In relation to the liquor scam, has been arrested by Directorate of Enforcement in relation to liquor scam. Since the primary relief sought by the petitioner pertains to grant of bail, we relegate her to approach the High Court of Chhattisgarh. It may be Chhattisgarh. The petitioner, for my so advice, may file a petition. Within 1 week.
Yes, immediately.
In 1 week, the High Court is requested to take up the matter on out of turn basis, on priority basis, and make an endeavor to decide at the earliest, but not later than 2 weeks.
I'm very grateful.
But not later than
Very grateful.
The High Court will also keep in mind the various orders passed by this court granting bail to the petitioner and other co-accused. disposal.
14 and 14.1.
My lord, she has also been arrested by EOW now. So, my lord, your lordships, my lord, observation may apply, my lord, there also.
She has been arrested by now, by EOW.
My lord, this was ED, what your lordships have dictated.
Instead of ED, then
This was ED. Now, my lord, after that, she has been arrested, my lord, by EOW on 2nd of January 26.
we think that the petitioner has been further arrested in another case by
EOW,
EOW.
Chhattisgarh.
Economic
Offences wing.
so and so. Then the petition may apply in both the matters.
Correct.
Then we will-
Therefore, very good.
So my lord is placing 14 and 14.1 together on a separate date?
There's no connection, my lord, please.
No, there's no correction, I agree.
You are going against-
14.1 was in relation to the evergreening of complaints, my lord, again and again. Without seeking permission of the court, there was a point of law in that your lordship had.
No, this is the first time I've heard of accused who themselves evergreen, now accusing the state of evergreen.
That is ED.
Yes.
That's ED, sir. You are not in that.
No, no, it's, therefore.
In
what is
14
evergreening?
14 and 41, we can take
Yes.
together. No.
Can it be after 2 weeks, bro?
After 2 weeks or 10 days, give a date.
So grateful.
Both matters are 14 as well?
Both.
14 and 14.1 is filed by you.
Yes, bro.
And that is ED matter.
That is the ED matter.
That is not your case, Mr.
That's
Jatnai.
14.1, but your lordship may keep them on separate dates.
No, 14 and 14, but don't tag them. Don't
tag,
mention as
that's
14.
that's
all right,
14 or 15 like this.
Yes.
And be tagged and listed separately, but on the same day.
So grateful.
Obliged.
Grateful, Lordship.
Please, my lord. Lord, pursuant to your lordship's order, my lord, of 27th of January, there is a fact-finding report, my lord, that the loss caused is only 3 lakh of rupees. And what the penalty sought to be imposed, my lord, is 12 lakhs, my lord. We leave it to your lordship's, my lord.
This item 15, are you referring to?
What kindly have your lordship's order, my lord, of 27th of January 26, my lord. Last order. Issue notice. Meanwhile, interim anticipatory bail is extended. However, Chief Secretary are directed to submit a tentative fact-finding report with respect to the loss caused to the state revenue, including in terms of the value of the illicit transported minerals, which is attributed to the petitioner. It is made clear the continuation of the bail will depend upon.
Well, is there any report filed?
Yes, Lord, we filed that report, Lord. If your lordship has the fact-finding report, he, in this span of 2 months, Lord, he extracted about 4,314 tons of illegally mined this thing, you know, minerals. And the total penalty which the state is to recover from him is about 12 lakh.
According to you, the loss is 12 lakh.
12 lakhs, yes.
7,000.
This is the penalty, Lord, but this is apart from
Loss
the
is
fact.
3 lakhs. Loss is 3 lakhs. My penalty is 4 times, my lord, the loss. That your lordship will
You
get.
can afford to deposit without prejudice to your rights.
Lord, this is only
Lord,
small.
this man is a habitual offender. Your lordship-
Transporter, my lord, get him.
There is sometimes a presumption. The presumption is that the litigant who can afford to engage Mr. Devdutt Kamath,
My lord, I'm sorry.
seems to be having capacity enough to deposit this fine amount.
Lord, he's
Lord,
a
the loss-
repeat offender, Lord. Earlier also, a penalty of 90 lakhs was imposed on him, Lord. Not only that, he was absconding. We had to issue proclamation notices.
Nobody
He's a flight risk as well, Lord. So I was only wondering, Lord, whether we lordships would ask him
Said in the
to, now that the charge
affidavit.
sheet has been filed, and the charge sheet discloses, Lord, the charge sheet now discloses that he used fake e-Ravanna papers, Lord, to transport.
Lord,
this.
I have lot to say on
And-
the charge sheet. After give me a.
No, charge sheet has been filed.
Charge sheet
Yes,
has
my
been
lord,
filed.
charge sheet is filed.
So the petitioner was denied pre-arrest bail, anticipatory bail by the High Court of Uttarakhand, while the impugned order dated, leave granted, the appellant was denied anticipatory bail by the High Court of.
Lord, he was granted anticipatory bail, but only a
Only
time.
for
He
2
was
weeks,
granted
madam.
anticipatory bail,
It was
but only for
voted-
15 days, so that he could seek regular bail. That was the bail. That's the
That
impugned
is
order.
completely contrary to lordship judgment.
The, say like this, the High Court of Uttarakhand, while the impugned order dated 30th December 2025, granted anticipatory bail to the appellant in case number so and so. However, limited the operation of that protection to the extent that limited the operation of that protection for a period of 15 days, meanwhile granting liberty to the appellant to approach the jurisdictional court for grant of regular bail. The aggrieved appellant has approached this court. Then say on 27th January 2026, the following order is then say in reference thereto, a fact-finding report has been submitted by the authorities, according to which the appellant is alleged to have caused total revenue loss of rupees 12,07,927 only.
Lord, 3 lakhs is the loss. Penalty, they say, comes to 12 lakhs, my lord. Loss is only 3 lakhs.
So has caused loss of 3 lakh to the revenue.
No, that is not
along with
our
the
report.
penalty of rupees 12 lakhs only.
Page 6, my lord, of the.
Next paragraph.
No, it's nothing I think.
It is not in dispute that investigation is complete and charge sheet has been filed. So that being so, we are of the view that the appellant can be allowed to continue on pre-arrest bail, subject to however is depositing the amount tentatively levied, the amount tentatively levied, the fine and penalty, subject to his deposit of the levied amount of fine and penalty. The appellant will deposit the requisite amount within 2 weeks, without prejudice to the rights of the parties.
Yes, ma'am.
Next paragraph. The appellant shall be at liberty to challenge the levy of penalty or the levy of fine or the penalty before an appropriate form in accordance with law. Next paragraph. Similarly, the deposit of fine or penalty shall not absolve or exonerate the appellant from the penal consequences, if any, and so all these issues shall be, if any, should be, and thus the trial court will proceed against in accordance with law. The trial court shall proceed in accordance with the law.
Lord, the conditions
So your
imposed,
lordships may
the conditions imposed by the High Court will continue, Lord. So your lordships may, the conditions imposed by the High Court for grant of bail, those will stand incorporated by your lordship's order as well, Lord.
The appeal
On the
is
same
allowed
condition.
for one change order of the High Court is set aside.
Lord, the only request is, whatever your lordships have said,
Is allowed in about terms.
whatever your lordships have said, my lord, your lordships may say that not affect the merits of the case, my lord, because ultimately.
Goes without saying.
Clarified that we have not expressed any opinion on the merits of the case.
Extremely grateful.
I'm grateful.
Item 16.
May please. It said, directed me to inquire about the antecedent of this, the petition. There are none.
No antecedent.
That was the only.
No antecedent. He got money in respect of online fraud, but
The appellant is agreed by order dated 11/12/25 past 12. The High Court of Chhattisgarh at Bilaspur, declining him bail in FIR number 157/2025, registered at Police Station Raipur under section 111, 317 in bracket 2 and 317 in bracket 4, 317 in bracket 5 of BNS 2023. The appellant was arrested on 6/10/2025. The allegations are that during the period 26 June 2025 to 6 July 2025, the appellants were accused in Vishal Bekra operated multiple bank accounts through which online fraudulent transactions aggregating approximately rupees 9.45 lakhs were received. The appellant is alleged to have assisted the above named co-accused by providing a mule account, and he received a share of the proceeds in cash. Next paragraph. Having regard to the nature of allegation and the period spent by the appellant in custody, or without expressing any opinion on merits, the instant appeal is allowed. The influence of the High Court is satisfied, and the appellant is directed to be released on bail, subject to his finishing bail bond to settle the trial. He is to feature the back of the bail appeal. You are still NFP?
No, my lords, I'm in custody, my lords.
No. If suppose you like the jail premises or the jail atmosphere environment, then we can dismiss the petition. We can allow you to stay in jail if you want. Otherwise, we have by mistake granted bail to you. You want to be on bail or you don't want?
My lords, I want bail, my lords.
And then you should go by with a smiling face from court. Why you are so showing as if you are under depression?
Okay.
Thank you, young lady. Thank you. Item 18.
My lord, item 17, my lord.
Just 17 minutes.
My lord, 17, my lord. I am praying for bail, my lord.
17? Thank you. Or 17 also?
Yes, my lord.
Oh, you are the main accused. This is my main
He's
accused.
the main accused, my lords.
My lord, I am. My lord,
इसको bail दे दो.
my lord,
अभी तो छोटी मोटी चोरी केस
Yeah.
है.
The child, same reasons, my lords.
my lord has granted me bail.
अरे दे दी भैया बेल दे दी. साहब आपसे डर लगता है पहले. Item 18.
My lord, bail was denied to me while granting bail to others. For me, my lord, bail was denied because I happen to be closely related to A7. So he is absconding, he applied for anticipatory bail to be dismissed. That is the only reason given. Your Honor, kindly come to pay 31. Long incarceration.
The main.
How much you have made money, sir? As per the allegation?
732 crores.
Only.
A7 is the shell company. Owner
Your
of the
Honor, kindly come to page 31, my lords.
Not
But long incarceration is the only ground.
9 months only.
My lords,
9
10 months now.
only.
Now 10 months, almost 10 months.
For 700 crores, 9 months.
Look
Well,
at
that is
the
what they say. I do not want to go into the merits of the matter now.
Look at the eminent position and the seat of power you have enjoyed. There is a direct nexus between the allegations attributed to you and the position you held for a long time.
But I will.
And you are not an ordinary and small kind of person.
But
And after investigation, there are definite allegations against you of taking a huge amount of bribe and
I will not.
visible in your accounts or in your known sources.
But at this stage, I do not want to go into the merits of the matter. At this stage, but I will argue the matter on merits when they file their counter. Normally, for the present, I would submit. All the other accused, most of the accused similarly placed have been granted bail on the same ground.
We have also granted, bail, we are aware, but not, those were very, very small fry.
No, same thing, same. Your Honor, kindly see, so far as accused number 34 is concerned with the similar or graver allegations. All. Almost all according to the case, all acted.
The order, page 31 of the order.
Not only me. The others also similarly placed, they have been granted bail. Yes, Murad. Yes, Murad. But so far accused number 1 is concerned, closely related to Murad, determining factor, closely related to A7 who is absconding now. Another influential supervisory role, that's all. For the next man, investigation substantially complete, no direct recovery, risk of absconding or tampering not shown, role more facilitative than controlling. Then next man merits. Investigation complete, co-accused with similar or graver allegations granted bail. prolonged detention would be pre-trial punishment. Same. The next member charge.
You are the central conspirator, first of all.
No,
Central conspirator.
Your Lordship,
Orchestrated liquor policy, influenced obvious allocations, promoted blue-eyed brands.
Your Lordship, kindly come to.
Collected
I will.
kickbacks of 50 to 60 crores.
Your Lordship, kindly come to Murat's page, Murat, paragraph 44, page 24. Murat, the allegations against me have been, Murat, almost similar allegations against others also. Murat, charge sheet has been laid. I have been in prison for Murat 10 months.
No,
Your Lordship, kindly see.
allegation against him is 732 crores.
That's right. Your Lordship, kindly come to paragraph 44, Murat, of the order, page 24.
Nagamotu,
My lords.
the shell company in which 750 crore was parked, as per paragraph 45 you indicated, is in your direct control through A7.
No.
This is the prosecution case. Now, if you accept that, you stand clearly on a different footing to A6, A34.
I will show Murat the other accused for whom bail was granted. Murat, the graver offences than me. Murat, they are also.
Wait for some time, Mr.
Murat, for the present, Murat, my submission should be Murat. Murat, let them file counter. Murat, I will take your lordship, Murat, and place records also to show that absolutely, Murat, there is nothing against me, Murat, and these allegations are very minor.
At best, you can make out a case for cancellation of bail granted to some others, but that will not help you in getting bail.
Murat, Murat, that matter is pending before this honorable court. Your Honor, kindly take this along with that. Your Honor, kindly see, Murat, in respect of some other accused, Murat, bail was granted, challenged before the court, pending, your lordships have granted stay of that. High Court cancelled, Murat, your lordships have granted stay. That is also pending before your lordships.
No, those were
That matters been disposed of.
There was question of statutory bail. We said that without going into that question, they will remain on interim bail and the issue will be decided on merits.
Well, if your lordships, Murat, decide to go into the marital matter, Murat, I may need some time. Murat, kindly have it, Murat, this Friday. Murat, I will argue elaborately, Murat. I do not want to waste the time of this on today. Murat, Murat, kindly have it this Friday. I will argue elaborately, Murat, and demonstrate.
How does it matter, Mr. Nagmuthu?
My lords.
Monday or Friday, how does it matter? You can argue today whatever you want to argue.
Murat, today, Murat, kindly consider to take.
We are not inclined to release him on bail at this stage.
Murat, I got some.
If you argue on merits, you are welcome. We can't stop. But please, you will not invite any observations from us on merits also. Today, we are only simply to say, at this stage, we are not inclined. After the examination of some of the vital witnesses who have direct bearing on your accusation against you, liberty to apply afresh before the High Court.
Murat, your Lordship, kindly, at least your Lordship, kindly have it tomorrow. I will argue the matter elaborately. Your Lordship, kindly, for my sake, your Lordship, kindly have it tomorrow. I will argue the matter elaborately. Tomorrow, Murat, at least. Or subject to my Lord's convenience any day. Any day subject to my Lord's convenience. Tomorrow is inconvenient for your Lordships. Your Lordship, kindly have it any day. I will argue the matter elaborately. Any day. I am not asking for any. Any day, Friday, this Friday, subject to my.
Friday will not Friday.
Any day, subject to my Lord's convenience. Any day.
Before Friday, you tell us onward. Day after? Wednesday.
Tomorrow, Tomorrow,
Day after we are arguing.
Day after tomorrow, I'm not here.
On Thursday?
Thursday.
All right, Thursday.
Thursday. Good.
Yeah, that's it.
Now, Lord, Lord, this is a case, Lord, where a closure is ordered of a chemical factory. Now, Lord, this is not a case where the factory is deficient in any manner. We are functioning for 10 years. We are fully compliant. The allegation is that, Lord, we have to dispose of spent hydrochloride acid, which we use for manufacturing, Lord, an intermediary product.
There, Mr. Rodgi,
We're discharging the acid in Narmada Canal.
In the Narmada Canal.
So what has happened is this, Milord. By the Gujarat Pollution Board, I can't use any truck I like. I have been using an approved vendor, Milord, for 5 years. They have made more than 500 trips. There has never been a problem. It has to be disposed of in that man's factory, Milord. That's how the hazardous rules provide. Now, Milord, I accept what has happened. Apparently, this driver on this trip did not take, Milord, the product to the factory concerned for disposal, which has been going on. Apparently, Milord, the allegation is he disposed of in a canal, etc. Now, if that is so, Milord, there can be some penalty. The penalty can't be that you, Milord, throw the baby with the bathwater.
No, we are not saying that
What wrong has I done? I have chosen, Milord, a vendor approved by you. The driver went elsewhere.
The point is, Mr. Lodgi, that whatever mechanism you had for disposal of.
Yes.
That has been found to be faulty.
No, Milord.
It is faulty because they don't have control. Once the material, this liquid goes from your factory premises
To another factory. Yes.
you don't have any physical control on
Yes.
this driver because you have hired an agency. And assuming this truck is caught, we do not know how many trucks went unnoticed.
Milord, I'll answer that. It can't be because the actual live movement of a truck approved vendor under the hazard rules is, Milord, on a website which is alive and, Milord,
Mr. Lodgi, please see.
it is GPS enabled.
It's a question of life for millions of people.
I agree. Milord, I can show you.
It's
Show me.
only source of drinking water in that space.
Milord, I am not saying no. I am saying, Milord, if it has happened, the remedy can't be closure.
We are not saying that. Your remedy will be that you will have to satisfy the NGT that what kind of preventive measure you will take. It will be a scheme.
Show me that. Milord, show me that movement. Perfectly right. I will show you, Milord, that there is a live GPS of every truck with this number moving, Milord, on a screen, going from A to B. When I saw it myself, there was some diversion, Milord, of that truck. That is, Milord, this is how it is done by GPS.
This you can show to the NGT also.
No, I only wanted to say, Milord, this man may be remiss. This is how, Milord, it goes. This man may be remiss. 1 out of 500, Milord, trucks may be remiss. I am not saying no. But the remedy can't be to order a closure of the factory. You may have some penalty, something. I can understand.
We are not saying at all that what should be the proportionate person.
Correct.
You are entitled to argue on the doctrine of proportionality that you can, but you can argue it before NGT.
Proportionality, I agree, Milord. Proportionality is if I have committed something wrong. Milord, I have chosen a vendor. What else can I do?
Under the hazardous rules, Mr. Lodgi, it is product liability.
Correct. But approved by them. What else can a man do? Milord, some penalty, yes, but.
The Honorable Chief Justice indicated to you that it is a question maybe of proportionality in the embargo or the interdict.
If I am remiss.
That is to be examined by NGT.
Once you will submit a scheme to the NGT that yes, this mistake or lapse has happened, but to prevent it and to ensure that there is no violation in future,
Right.
This is my scheme.
And this is what I am doing, Milord, for the last 10 years.
The tribunal will consider that.
Only one more request. Milord, now the order has come. That day the order wasn't there when he mentioned, Milord. The order, Milord, of the High Court has come now. Have a look at that. See the last portion. I want to make one submission there. I filed that order separately, Milord. It wasn't there.
It's impugned.
It is now impugned. Yeah.
Part of the
See page 15. Last portion, Milord.
para 23. Yes.
Yes. Liberty rests with the petitioner to approach the pollution board for seeking
State pollution control.
Yes,
Yeah.
to seek revocation or go to NGT, Milord, and these observations will not come the way, etc. Now, I only want to state, Milord, on 5th of February, I have gone to them. That, Milord, representation is pending.
We can direct them to decide.
Only one thing, Milord. Till then, the closure, Milord, should be in abeyance. Why should I be closed?
That part.
No, even if you decide in 1 week, Milord, your lordships consider a man who's not remiss on his own factory is not remiss, Milord.
You simply tell us that have you approached the state control policy?
Yes, I have approached them on 5th of February. I have placed it on record. And I wanted a stay. That's why you mentioned to my Lord the Chief Justice on Friday.
No, we can simply direct the Pollution Control Board
Yeah.
to decide that matter within a week.
After giving me an oral hearing, my lord, I will show them this.
Of course.
Number, but till then, my lord, there should be no coercive steps. My lord, what is the advantage? I produce, my lord, for anesthesia. I give it to the government. I give it to all that. There has never been, my lord, a remiss position of this factory for 10 years.
You see, sometimes the harsh actions are required to be taken to convey a very stern message to everyone.
I understand
You
that.
can't play with the environment like this. That is only maybe.
But my lord, to paint me black because one black sheep may have been remiss is too harsh, my lord, for a closure. I employ 500 people, my lord. I have never been remiss. There is not a single instrument, my lord, equipment which is not installed. Consider, my lord.
They can consider the main matter.
Just consider this, my lord. Every day, your lordships have cases where there is affluent flowing from factories.
Operating a manufacturing unit at the Dahej in Bracket, Gujarat. The spent hydrochloric acid,
Yes, spent.
in bracket spent HCl, is generated by the petitioner's industrial unit as a byproduct. According to the petitioner, that spent HCl is supplied to an authorized actual user. However, on 29th January 2026, a tanker bearing number GJ-27-TG-6676 loaded with 34.170 metric ton empty of spent HCl which departed from the petitioner's industrial unit, a factory, on 30th January 2026. Was found to have thrown that spent HCl in Narmada Canal. This prompted the Gujarat Pollution Control Board
Not only, only for
take an action under section 33 capital A.
only one interruption, Lord. They gave me a show cause notice asking for a reply in 3 days, but without waiting for that, they closed me the next day.
We also closed, my lord, the other side. The other entity where they were receiving HCl, we found that they have not received HCl. What happens is, for them, it's a byproduct. For another company, it is a raw material.
But Your Lordship may say it's an allegation. I don't admit that he has done this, he has done that.
Pollution Control Board is said to have found from Messrs. Sri Ramnath Chemical
Yes.
that the spent HCl was not received by them. The spent HCl in a roasted truck was not received.
Lord, we dispute this proposition. We dispute this. That it was diverted or that, Lord, he didn't receive it. I dispute it.
Was alleged
I'll show it.
received by them. There is further allegation that it was thrown in Narmada Canal. Be that as it may, the Gujarat Pollution Control Board issued a show cause notice and thereafter has passed an order.
Issued a show cause notice for 3 days, but
Lord, they did not wait for my reply. They passed the order the next day. That is one breach.
To invoked its powers under section 33 capital A of the Water Prevention Bracket
33A2.
33A2
Yes.
of the Water in Bracket Prevention and Control of Pollution Act 1974 and issued a closure order dated 3rd February 2026
To avoid grave injury to the environment.
on the ground of avoiding grave injury to the environment. That's what I want. The above stated order was challenged by the petitioner before the Gujarat High Court before the High Court of Gujarat. However, the writ petition has been dismissed by the High Court by the impugned judgment dated 5th February 2026 with the following liberty. Reproduce para 23. Next paragraph. The agreed petition is before us. At the outset, it is pointed out by Sri Mukul Rohtage, learned senior counsel for the petitioner, that in deference to the directions contained in deference to the liberty contained in para 23 above, the petitioner has filed a statutory appeal.
No, my lord, a representation.
Petitioner filed a reply to the show cause notice come
No,
representation.
actually, my lord,
Sir,
show cause is now
revocation
over. I made a representation on 5th of February before GPCB, on 6th of February.
Has made a representation to the State Pollution Control Board seeking recall of
Yes.
Revocation, no, it's called revocation.
Huh?
Revocation.
Revocation of the closure.
seeking revocation of the closure order dated 3rd February
My lord.
2026. Yes, sir. That being so, we deem it appropriate to dispose of the special petition with the following directions, stroke liberties. One, the prescribed authority in Gujarat Pollution Control Board is directed to take an appropriate decision on the prayer or stroke interim stay made by the petitioner in its representation within a week. Please do. The interim order 2I, the interim order of any nature may be passed pending the final order on the representation, which may be decided. Do we need one order is sufficient?
No, dear Lordship, because that would mean that we have to pass some interim order.
My lord,
We will decide, not finally one.
but for 1 week, please don't close it. That's all I'm saying.
To decide the representation within 1 week.
After giving me an opportunity, my lord.
After hearing an opportunity of being heard.
Personally, yes.
The petitioner's representative,
Yeah.
authorized representative. Next paragraph. The aggrieved party shall be at liberty to approach the National Green Tribunal. So there may be a separate prayer for interim directions before the National Green Tribunal, and in that event, such a prayer of the aggrieved party shall be decided by the tribunal as early as possible and preferably within 2 weeks, subject to the pending appeal. Subject to the outcome of the pending appeal.
Good.
Please.
Good.
Obliged.
Item 44.
No, please, Your Lordship. Your Lordship, I've been in custody for around 269 days, and similar co-accused have been granted bail.
But in your case, notice has not been issued so far.
Sorry.
That's matter.
Notice, no. Fresh.
We have granted bail to your co-accused,
Yes,
but
that's
then we have to issue notice in your.
That's correct, Your
Issue
Lordship.
notice, trustee. Are you there?
I appear on advance notice, Your Worship.
You are for the state.
Yes, please.
Then say, Madam, accept notice on behalf of the state of Chhattisgarh. We have already released the co-accused.
Yes,
Do
yes.
you want to file reply or we can release him also?
We want to file a reply.
You want to file reply? Then do it by Friday. File a short reply. We have our next Monday.
Oblige, Your Lordship.
Counter affidavit with advance copy to content for the petition, post it on to.
Oblige.
May I please? This is also fresh. Now 9 months, 9 years, 7 months, I have completed out of a term sentence of 10 years. Well, the High Court says that period of incarceration is not the sole criteria. Well, if I'm going to complete the entire sentence while my appeal is pending, with great respect, my lords, it can't be that my appeal will be rendered infructuous as far as this is concerned. Please see the custody certificate, my lords, at page 446.
Now your appeal is of 2020.
Yeah, my appeal is of 2020. Out of the sentence that is there, I have already undergone 9 years, 7 months. 10 years is the sentence that is imposed on me. 9 years, 7 months I've undergone. Another 5 months, 6 months, I would have undergone the entire period of sentence. Entire period of 10 years I would have undergone. And the High Court says, my lord, that this is not the criteria.
7 years for 9 years. How can it?
7 years is actual, 7 years is actual, 6 months, 7 years, 6 months. Then they was added a remission period.
Remission is available in this kind of.
Remission is
There are no
available.
remission. It has to be actual sentence only.
Is listed on 11th for hearing.
With respect.
Appeal is listed on 11th for hearing.
See, I thought to decide the appeal.
Solicitor, why not an appeal for converting it to 302?
Because there is,
Huh?
I have filed an application regarding that.
But the victim has filed.
That's also pending.
That, Mr. David.
With respect, but today there is no appeal.
There is an appeal.
There is no appeal. Please see the cause title. There is no appeal, my lord. There is.
No. We are not concerned with cause titles, Mr. David. Is the victim here before us who saying has filed an appeal?
If there is an appeal, it would have been taken up with the same matter. Many.
But we don't wish to comment. Give the number of the appeal to Mr. David so that he is better advised.
I'm not, today.
Please, you get the number of the appeal under appearance.
Which appeal, my lord, with great respect, there is no appeal on this matter.
Out of 10 years or so, whatever sentence that has been awarded by the trial court.
Yes, my lord.
You have undergone actual sentence of 7 years and 9 months or so.
Yes.
Right? Less than 8 years.
Yes.
It is highly debatable whether an offence involving moral turpitude of such a nature.
Yes, my lord.
Will you be entitled to claim any remission?
Yes, my lords, of course.
Anyway,
They can claim
we
commission.
are not saying, we are saying highly debatable.
Because remission is available even in murder cases, but after 14 years, you have to undergo 14
Murder
actual
case
14.
can be, you see, murder case can be sometimes a simpliciter murder.
But this is a murder
So the
case
two
only.
groups are fighting out of certain on momentary issues. Sometimes without any intention, sometimes take place, or it can happen. There are several circumstances.
Remission policy of Delhi government is clear. This is a term sentence of 10 years.
Anyway, that issue becomes academic in the sense, once the learned solicitor is pointing out that your appeal is coming for hearing
On 11th.
on.
11th.
Yeah.
It was listed
So
on
we'll
the
request the High Court, to take up your appeal on day-to-day basis. They are not opposing it. They will argue from their side. Prosecution will also extend full cooperation.
Victims appeal.
No, this is, I'm with great respect.
And
I have yet to come across a case where a person has undergone out of 10 with remission, with remission also 7 years, without remission also 7 years.
Yes.
And that suspension is granted to him.
Mr. Dave, the total period undergone by a convict is undoubtedly a factor that is kept in view while suspending the sentence. But why we suspend the sentence? Only when we are uncertain about the time that will be taken in the final decision of an appeal. Here is a case where the main appeal has been listed for final hearing. What is required to doubt, to remove any kind of cloud on that certainty, we will request the High Court.
It was listed on 3rd. As per the impugned order, it was listed on 3rd, not taken up on 3rd.
Why?
Because
Why must not have been taken up? Because somebody must have pointed out that your SLP is coming before this court.
Pointed it out.
There's a difference. There's a difference.
This is with respect, Manoj.
This
goes to Article
Mr.
21.
Dave, right from all high courts in this country, including the Supreme Court, we have two categorization of two sets of criminal appeals before us, where the accused is on bail. We do not grant out of turn hearing in those matters because we know that there is no crisis of liberty. Bail have been granted. But in the cases where we do not deem it appropriate to release an accused on bail, that's a separate set of category where the appeals are taken out of turn. If your is a case, 2020 appeal might not be ordinarily, it will not come as per turn in Delhi High Court. But because you are there, you have not been granted bail, that's why the High Court is according you out of turn hearing. And we will cement that, we will further request the High Court, making it sure that your appeal is heard.
Appeal, it may be heard.
Lord, another
Well,
thing.
just 1 minute, my learned friend.
Lady
Please,
is undergoing a life imprisonment in the second offense.
So what difference does it make? So I should not get.
Here or not, doesn't make any difference.
Every time the argument is even better. Now, please see if for a 10-year term sentence, suppose it was not 304 part 2, suppose it was 307, attempt to life 10 years I've got. Would it still be that I'm not entitled to remission?
We are not required to look into these aspects. We are not saying, you see, as an accused, You see, this is one country who is so proud of on rule of law that even the most heinous, dreaded criminals, we have been according opportunity of hearing. This country has followed the rule of law. This country has provided a fair trial even to the dreadest anti-nationalist elements, even terrorists.
Assam was,
So even a person, as Solicitor is pointing out, a person who came attacked so brutally on the integrity of this sovereignty of this country, we even provided fair trial to him
the
also.
offense was seen by the world on television.
What is my learned friend? I am not listed on a Kasab matter. I don't know why my learned friend is on Kasab.
In
This is
your
not a
case
Kasab
also,
matter.
oh, no, he is only illustratively telling that in the
This
worst
time
cases
link
also.
me to Kasab. What do I have to do? I was a
You
sitting
have to do
MLA.
nothing, you have to seek an assurance from the court of law that irrespective of the nature of allegations, irrespective of anything coming in media, you are entitled to a dispassionate hearing of your criminal appeal by the High Court, which will be decided without being influenced by here and there anything, which should strictly confine to the evidence on record, material on record. That's all.
So now, may I just answer one question which fell from my Lord Justice Bagchi. My learned friend says he has filed an appeal. That appeal is for necessarily enhancement of sentence. It can't be for anything else. It has to be enhancement of sentence or change, or that it goes under 302.
Why not? Why not? It's
It goes to
302 charge was framed against you, one will be 300.
Assuming against myself.
So there is a lesser offense on which you have been convicted. Why so to the?
Just bear with me for the submission.
Yes, you can bear with you for a lifetime, Mr. Dave.
The enhanced sentence could also be death in that.
May I just indicate why I'm making this submission? If it is my learned friend's appeal, it goes to DB. This matter is before a single judge, it's below 10 life sentence, then it cannot, no, I'm saying if it is fixed on 11.
In appropriate cases, Mr. Dave, this sort of an appeal where there is a possibility of a appeal by the victim for enhancement, not a case for a division bench.
There's no point, Manoj, for 11.
Loses one.
Nobody is arguing this. I don't know why the solicitor has not preferred any appeal in this matter. The CBI is sitting pretty.
This is not a case of any quorum non judice, please. These are all internal arrangements by the.
Are asking the High Court to expedite the appeal.
So therefore, in the case, suppose a division bench of the High Court, suppose prima facie feel that the appeal filed by the victim also should be heard along with your appeal. In that case, matter has to be listed before a two-judge bench.
So it can't be heard on the 11th in any case. Since much submissions were made, it's listed on 11th, hear it on 11th, have it on day to day. The other side is saying, though, it can't be heard. That's what I'm all pointing at. The only thing I was pointing out.
Can be taken up on some.
So, Manoj, 10 years, assuming that he goes through his 10-year sentence, Manoj, his appeal would be infructuous. And if their appeal is dismissed, he's undergone the entire sentence.
Kind of whatever doubts you have in mind about listing, that we will clarify here. Both sides.
I'm saying, Manoj, if
both sides are present before us, so
in 9 months, 7 months are not enough. If 9 months, 7 years are not enough.
As well as their.
We were not even charge sheeted for murder by the CBI. It was a club trial, therefore.
We are not charging.
Look, may I just say,
Initial
this.
So I'm only saying, Manoj, 9 years, 7 months undergone. With remission, another 5 months I have to undergo. I will undergo that period. There is nothing else that is left. Whether the appeal is heard or not becomes an academic question. Only if their appeal gets allowed.
There is no criminal appeal becomes an academic issue. Even in those cases where unfortunately the persons died while pending the criminal appeal, because the family is still entitled to seek vindication of innocence. If there is an innocent person falsely or erroneously convicted by the trial court. So these are nothing to do. Completion of sentence, anything. These are not the circumstances.
Out of 10 years, 9 years, 7 months in custody, or 7 years actual custody, is more than 7 years.
We appreciate your contention. Therefore, request the High Court. Request the High Court to decide your appeal.
If I had come in any ordinary case, Manoj, I would have got bail. With respect, I'm just saying so, Manoj. When it came, the other matter came before your
jail for
last 1 minute. My the solicitor is not. There is no notice is issued in this matter. Now, because that other matter, when it came, we said that this is Justice, it fell from the Honorable Chief Justice that you are not released in that matter. Therefore, we are staying that matter, in the bail in that matter. When we come in this matter, the solicitor says, in that matter, you are in custody. So how does it matter? Somewhere I have to start getting bail, or I'm going to be just in arguing my appeal or pursuing my appeal. And now the complaint.
We have already explained that in a case of conviction
On merits also.
and pending criminal appeal, what are the parameters normally we follow on uniform basis in all high courts and including the Supreme Court.
Yes.
Where the accused is inside and has not been released on bail, he or she is entitled to an out of turn hearing of the criminal appeal,
Yes,
so that at least before completion of the sentence, the matter is heard.
My lord.
That is the principle followed. In your case also, there cannot be any exception. You are entitled to whatever you are entitled to law, you must get it.
Yes.
Therefore, you are entitled to an out of turn hearing that the High Court is according. We will also make sure that you get it.
But that process is not available, my lord, because now the complainant feels that I should be convicted under 302. So his appeal first has to be.
Mr. Dave, for deciding your
EC 365.
For deciding your appeal, we cannot gag the right of a victim. If at all there is a right in law.
Mine also, my lord.
Yes, therefore balancing has to be done.
For 9 years, 7 months.
We are absolutely right to do, but there has to be a balance of rights.
I've undergone more than half of this actual sentence. Actually, I've undergone more than half, my lords. Kindly consider this. In which case, for term sentence, this is not a life imprisonment. Life imprisonment, I can understand the High Court has some leeway. Your lordships may have some leeway that it's a life sentence. There is no term there. But in a term sentence, my lords, your lordships always takes into account the period.
It is a term sentence of a person who has been convicted and sentenced to life imprisonment in another case.
Yes, my lord.
Isn't that a relevant consideration for
Because it is
suspension of sentence?
when that matter came up, my lords, the same argument was there that please stay.
Really, one will color the other.
So, my lord,
If there are, why do we speak of criminal antecedent? When it comes to a question of multiple cases against an individual, courts are generally circumspect in granting pre-conviction bail.
Same incident. It is not a separate.
No, it's definitely not the same incident.
Exactly.
It's the motive.
Incident,
It's the motive.
Allow me to.
The rape case is the motive for this crime.
In this case, here the person died in police custody. Person died in police custody. I was.
Two police officers have been convicted.
Yes, my lord. Then I have been with 120B. I was in Delhi. Those are the findings. I can show you.
Let us not comment on the merits.
Mr. Dave, any argument touching the merits from your side will invite a reaction from our side unnecessarily. And you know this matter that unfortunately it's not that we are not sitting in ivory tower. We know that there is a media trial also going on, which we do not really approve. And the way Mr. Prachap outside the court, he goes to the media. If you are a counsel, you have no business to go there. Don't forget, I have saved you in profession. Your license would have been suspended. Your exemplary costs were imposed on you by the High Court. I saved you thinking that you will believe in professional ethics. You have no business to go to media when you are appearing in a case here. If you find that you are indulging in this kind of drama, then you will face the consequences also.
Can I just say?
As a Chief Justice of India, I can't tolerate these things.
Let's kindly see what the other side.
You are arguing here, you are conducting a parallel trial outside the court. This is not acceptable.
I was just informed.
We are only warning you today. You take this warning in the right earnest. That's all.
Can I also say this, that please tell this to the other side also.
Right now.
What they have side? I never went and gave interview with the
Now
other side.
we have conveyed our message, and anybody knowing that how I function, I hope that people will believe it and follow it.
May I just say
Then may I only suggest.
Do not invite any
Let
consequences.
the
That's
DB
all.
take a call whether his appeal is maintainable or let the
the
DB.
other side also.
You have a right to oppose. He has a right to
No,
argue.
I'm saying let the
You will argue in court. That's all.
because the division bench, since your lordships are asking for expeditious, let the DB first decide whether his appeal is any merit in it or not. Then call for my appeal.
The way that you will argue before division bench of the High
Believe
Court,
that-
not before us.
Expedite, then I'm only praying don't expedite this simpliciter, my lord, my matter. Because it will be tied up with the division bench matter.
Right out. The petitioner, say leave granted. The appellant is agreed by and order dated 19th January 2026. Passed by the High Court of Delhi declining his prayer for suspension of sentence and consequently release on bail in criminal CRLA number 539/2020. The declining his application done, application under section 389 in bracket 3 CRPC, seeking suspension of sentence and so on. The above stated criminal appeal has been directed against a judgment dated 4th March 2020 of the trial court, by which the appellant was convicted for offences under sections 166, 167, 193, 201, 203, stroke 21, stroke 21, 212, stroke 323, 341, 304, 120 capital B IPC, and sections 3 stroke 25 of the Arms Act. We just make sure that correction in this section. He was consequently sentenced to undergo a rigorous imprisonment of 10 years.
Yes, my
10
lord.
years.
Highest is 10 years amongst all of them. The highest sentence amongst all of them is 10 years.
Terms, maximum of which
He
was
was a maximum tenure of maximum RI for 10 years, though different sentences were awarded for different offences. Those separate sentences were awarded for different sentences, offences.
And all directed to run concurrently, my lord.
Next paragraph. It seems that the appellant, besides arguing, besides making an attempt, a case for suspension of sentence and release of bail on merits, also vehemently urged before the High Court that he has already undergone an actual sentence of 7 years and 9 months out of the total sentence.
With remissions.
7 years, 6 months, 29 days with actual. My learned friend is not aware since I'm in custody, and 9 years, 7 months with remission. So 7 years and 7 years and 7 months of actual custody.
7 years or 7 months of actual sentence. Anyway, that's a matter of calculation.
No, it's there, my lord, at
Next paragraph.
46.
The High Court has, by the impugned order, one more line. The appellant also urged that some of his co-accused had already been released on bail after suspending their sentence, while orders dated 22nd September 2023 and 17th October 2023. The High Court, however, while impugned order has declined the suspension of sentence and consequential release on bail, entirely observing that the appellant is already serving a life sentence for the rape of the deceased minor daughter in a connected case, semicolon, that his previous application for suspension of sentence was dismissed on 7th June 2024, and there are no new exceptional or compelling circumstances, etc., etc. Next paragraph. The agreed appellant is before us. Next paragraph. At the outset, it is pointed out by Sri Tushar Mehta, learned Solicitor General of India, representing the Central Bureau of Investigation, that criminal appeal, criminal LA number 539/2020 of the appellant's criminal LA number so and so is now listed for hearing before the High Court on What is the date, otherwise?
11th.
On 11th February 2026. 2026. He thus submits that the High Court can be requested to take up that appeal, to take up and decide that appeal on out of turn basis. Can may be requested to take up and decide that appeal on merits, on out of turn basis. Next paragraph. At this juncture, counsel for the
Complainant.
victim states that the complainant side has also filed an appeal challenging the trial court judgment dated 4th March 2020 on various grounds, including on the question of quantum of sentence. Next paragraph.
Milords, which
In criminal LA number 539 of 2020 and decide the same as early as possible, but not later than 3 months. But not later than 3 months. Next paragraph. As regard to the criminal appeal, if any, filed by the complainant party stroke victim, we grant liberty to the appellant in that case to approach the High Court for taking up of that appeal to for hearing. Full stop. The High Court is requested to firstly take up that matter within 1 week and subject to the objections maintainability, etc. If the High Court finds that the said appeal to all issues can be decided together. Maintainability, etc. It will be in the interest of justice that both the appeals are heard and decided together. Heard and decided together. If such a recourse requires the change in composition of bench for deciding criminal LA number 539 of stroke 2020, Honorable Chief Justice of the High Court will do the needful in this regard. Anything else you want?
there are 8 connected appeals which have to be decided with this 539 of 2020. They are all co-accused. So it's not my appeal. There are 8 connected appeals.
Connected appeal of other
With 539 of 2020, the present appeal. So they all have to be decided together.
If there are, next paragraph, if there are other connected appeals, those two also be taken up and decided along with the lead appeal, along with the lead case.
Then if it is not decided in 3 months, Milords, then where do I go? So
If
then I'll
it
be
is
back
not-
for.
Incidentally, I am not retiring in 3 months. My brother or both in any case will retire after me. So there nothing is that unforeseen circumstance we should see.
I have hope, Milords. I will be back before your lordships. Grateful.
Milord, bail matter. Trustee also.
Issue notice.
Yes,
Advance.
Would you like to accept notice?
Accepting.
Then so accept notice. Counter affidavit can be filed within 1 week. Counter affidavit, or like 10 days.
2 weeks.
2 weeks. 2 weeks post the matter on so date for further consideration.
Get me that.
The question is V में आएगा. Extra 6.
23.
Unicorn, I think. Twenty-three. We just follow 23. Lordship, it's specifically refer for the.
This writ is not maintainable. Kindly have the prayers, my lord. If he has a grievance, then he can approach the High Court, my lord.
Uniform standard operating procedure governing freezing.
And that is already on.
Accounts linking cybercrime investigation. How can such a direction be issued? Sir?
Lordship, the thing is, after the last
It has to
order.
be decided on case-to-case basis.
Lordship.
Where we find that yes, freezing is absolutely unwarranted, we can go, the court can interfere, and that why should we entertain this?
Lordship, there is a subsequent development after filing of this order on a 16 January of the last order. Delhi High Court also issued this similar.
That matter is also today.
That's a suo motu petition.
No, is it listed today?
Yes.
Okay. We'll hear it up here.
Yes. Lordship, just consider the order passed by the Delhi High Court in a similar matter where the Home Ministry come with the standard, they've already issued some SOP. So if SOP is there, then just let it be.
High Court of Delhi High Court judgment before us.
My lord, I am also in the matter 47, similar matter, my lord.
And then one more part.
Judicial High Court is UP, my lord, Allahabad High Court.
My lord, these accounts are being frozen across the country, my lord, and there are so many matters.
Because.
And there is urgent need, my lord, to intervene and to.
You want us to uphold this freezing of accounts?
No, my lord, I am saying
don't invite
unfreezing should be a mechanism, and the 106 is being violated, 107 is being violated. Magistrate order is required, my lord.
Having heard and consulted.
Kindly issue notice in this matter. This is very urgent, my lord.
Judicial Solicitor of India on behalf of the respondents, Union of India, we see no ground to entertain these petitions.
Multiple states are doing in the same account, my lord.
Accordingly dismissed, however, with liberty to the aggrieved persons to approach the jurisdictional high courts on case-to-case basis.
Lordship, before concluding my. I just want to point out one thing.
Everything coming under 32, as if there is no other.
This is being misused by the law enforcement authorities quite a bit.
Absolutely.
Kindly, it is required, my lord.
That they must do something very.
I am in Mumbai. My account is frozen for 4,000 rupees from Jammu Kashmir, my lord.
Then go to High Court, approach the High Court.
So that's the concern of the entire petition, that if I'm standing in.
There has to be proportionality, my lord.
Complaint filed before.
Every person like this start coming in the 32, what will be the end?
More than multiple states involved, my lord's intervention and the law has to be settled, my lord.
We will, don't worry, we will do that. We are right now.
Kindly issue notice and allow us some relief, my lord.
Question of issuing notice in these matters, where you are suspected to be involved, where the question of issuing guidance at your instance.
47, this is my customer, it's a consumer matter only, 4,000 rupees.
Yeah, thank you very much, thank you.
Kindly have a look at page 60, just 1 second, my lord.
If you don't see anything, please go to High Court and show.
It will be, no, my lord, can give, just see my customer is there.
Yes.
And they are misusing this. After 8 days, they are filing this complaint.
The banks are hands in glove. This is what the report shows. We don't want to say anything because it will cause serious prejudice to all of you. The banks, their officers are hands in glove in the matter of digital arrest and the cyber crime of looting this money. It's not extortion. It's a.
My lord, but I am suffering.
Brazen loot.
Yes, Lordship.
Bank might be involved, but I am suffering, my lord.
Lordship is absolutely right.
What
There is
can
a
we
bank
do?
are involved, but in this case, those are not directly compared.
Therefore, please go to, that's why you said case to case basis. If you are a victim, you will tell the court. If you are, if you are clean hand, you will tell the court that I have nothing to do with, court will pass an order.
We are not concerned with the transition itself.
Thank you,
And
thank you
therefore,
very much, thank you.
Lord, there is no FIR, nothing, just the misuse of the I4C mechanism.
Yes, yes.
Kindly issue some guidelines on this for the
We
defreeze,
will,
my lord.
we will not issue right now, we will see at the time of final hearing.
And my entire business is gone, my lord, because my account is completely frozen, my lord. I am a small time professional operating out of
go to
Mumbai, registered with SEBI,
Yes,
my lord.
item 24. Lunch. Yeah.
May I request that 24 may be stood over?
That would be the no.
Lord, may I request that 24 may be stood over to tomorrow or any other date? There was some misunderstanding. I thought this was the matter where notice had been issued and
Next Monday, Mr. Singh.
there was some miscommunication on my part. Can I request if your lordship?
No, you wanted to place on the additional
We
document.
placed those, but I thought this was the matter where notice was issued. I mixed it up because no reply was there in that matter. So if your lordship could keep it either tomorrow or Friday, or whichever date your lordships.
Friday, we are avoiding Friday.
Or Monday, there was just some miscommunication on my part.
Want on next Monday, we can take.
We have already filed the documents. I had some misunderstanding about which matters listed.
We will say like this.
Monday, if your lordship would keep it.
Mr. Singh and Senior Counsel informed that additional documents have been filed. The registry directed to tag the same, post the matter for further consideration on Monday.
Deep privilege.
May it please, ma'am. Item 26.
26, your lordships have already.
We have allowed that matter.
Despite your lordship's order, every day they are filing
They are
cases.
still
in
filing.
Kolkata, my lord.
Then if we issue notice and you remind us, then we'll impose some exemplary post.
I'm grateful, my lords.
How much the amount in dispute?
My lords, the loan amount was 1 crore, out of which we went to DRT and we paid substantial amount.
Issue notice to the respondent returnable on so-and-so date. The respondent bank will also show cause as to why contempt of court proceeding and exemplary fine post be not imposed on it for filing complaints at. The complaint has been filed which place?
My lords, Kolkata, my lords. Kolkata.
Has been for filing the complaint at Kolkata instead of Nampalli, Hyderabad.
Correct.
Basti.
Till then the proceedings may be stayed, my lords. Till then the proceedings may be stayed, my lords.
You serve them next week. What is the next date?
My lords, the next date I have to verify, my lords. I have to verify.
Meanwhile, further proceeding before the Calcutta so-and-so shall remain stable.
I'll do that, service, my lords.
Bengal SI.
Item 48.
Grateful.
Yes, my lord.
Huh.
My lord, may it please your lordships.
We will take up along with those matters. We will take up along with other matters. Everybody now start filing separate cases. We will take up along with the other cases. Coming 2 o'clock.
Marat.
One matter, my lord speaks today as item number 36, where the Calcutta High Court directed the tribunal.
Wait for the turn, wait for this.
Can he take up this matter at any point of
We
time?
will see, we will see.
Yes.
Item 39 first, digital arrest matter.
Please, your lordships. I have got a brief note of lordships consideration.
Yes.
Just to give a status report on that, an update. May also hand over the complete status report.
Actually, behind you.
Threshold of 10 crore may be on the higher side, Learned Attorney. Individual losses, I mean, the individual loss of 10 crore.
Yes. But then,
No, but then, you see, there are people, senior citizens, for them, any amount of running into few lakhs, particularly in a case like one of the retiree couple, where which prompted us to take suo moto. There the loss was 1 crore something.
that's right.
But so look at that, for them, the entire life saving.
That's true. Nobody has any, the government is very keen. We should put all these schemes in action mode as early as possible. But unless we complete this exercise, it will be like working in darkness. So I think it
SOP initiative we appreciate. That's
yes, the SOP in fact is very exhaustive. And there are some Rajasthan High Court and Kerala High Court, some judgments have come. We are trying to look into them. As much as they can add on to the SOP, we'll try to add on to them. But I don't.
You can apprise us if the high courts are also entertaining. We don't want any parallel proceeding to come.
That's true. That's right.
That we can transfer those.
So the SOP as of now, I think is fairly comprehensive, and let it take shape by giving putting it in action mode. And therefore, your lordship to kindly, in terms of the status report, kindly turn to page number 9 of the status report,
Oh.
As of now, I think in view of the progress being made, this limited direction would suffice. I had a word with the learned amicus, and we value her input being given to the government, and she will continue to be associated with the deliberation. So page 9.
That's it.
This will go a long way in now trying to expedite the entire process of deliberation. There's also, I think, since I suppose the learned amicus would share her views with me, and we'll try to, I said, add quality by adding her inputs into that.
My lords, I have filed a written submission pursuant to the status report. I've tabulated, there are two status reports that were filed, one by MHA and the other by MEITI. The first one being of 13/1/2026 and the second of 29/1/2026. I have tabulated it and I have shown what are still pending and that which has been addressed at least at a preliminary stage. And we will, I'll continue to, I would say,
taken you into confidence.
Reached out and requested me to be
Yes,
part
to
of
be
the
the product
deliberation.
of
very good.
It would be my
That's very fair.
duty to contribute. I will be most happy. My lords, I would only want to put this first, and it's recorded in the meeting also, which I had attended. This is a consensus mediated process, and all the departments are coming on board keeping that in mind. There have been extensive discussions. They have been cooperating. But the only thing that I have requested, and that's what my note encapsulates, and that is that the action that needs to be taken pursuant to some of the lacunae having been pointed out, that still remains to be done, and some timeline may be fixed by which they will do that action. And that would also help us to then.
Timeline
for the departments to revert.
Reporting compliance, banks.
Now, if you'll also see this 1-2-page note, we have broadly hinted at what timeline is possible.
The matter will remain pending. Today we are at the stage of formulation of policies, rules or regulations. Once that is done, then definitely, and those are made implemented, then we will have the status report with regard to that, what is the actual action taken at the.
Yes.
The government is very keen to expedite it as early as possible. There's no difficulty at all about it.
Say, on continuation of the previous orders, including the 16th December 2025, London Attorney General for India, is the Sri R. Venkat Ramani, London Attorney General for India,
Let me note.
has placed on record a compilation containing status report on behalf of the Ministry of Home Affairs, Union of India, along with documents R1 to R5. Annexure R1 is two copies of the second meeting of IDC held on IDC is interdepartmental committee held on 2nd February 2026. Annexure R2 is a copy of the detailed inputs in respect of the submission of BOT, R3 is a copy of the detailed inputs and supporting material in respect of the submission of RBI. R4 is a copy of the input shared by Meet Y in form of status report, and R5 is a copy of the SOP for NCRP CFCR FRMS, custody and restoration of money and grievance redressal. It is pointed out that after forming an interdepartmental committee, don't say after, it is explained that an interdepartmental committee has been constituted. First, the Central Bureau of Investigation has identified the threshold of losses of rupees 10 crore or more for investigation of digital arrest cases. 2 such cases have been identified. 3 such cases have been identified in Gujarat and Delhi. And state governments have accordingly been asked to accord permission. So we direct the state of Gujarat and NCT of Delhi to accord the necessary permission within 1 week. Within 1 week. Next paragraph. It is pointed out that the banks are using their own AI/ML tools for fraud risk management. About 26 out of 53 banks are stated to have also adopted Mule Hunter AI. Most importantly, Reserve Bank of India and Indian Cybercrime Coordination Center, Ministry of Home Affairs are in the process of finalizing MOU for sharing suspect registry data to enrich mule account detection tools in bracket preventive and responsive dash data for cyber criminals and mule accounts available. Lincoln helps black fraudulent transactions, and to help in blocking fraudulent transactions. We will appreciate if the draft MOU is finalized. How much, Learned Attorney, how much time it likely to take the MOU, this MOU?
It'll take about 3 or 4 weeks. 4 weeks time at least.
Is finalized within a 4 weeks or so.
4 weeks time.
Next one, you parabolic liquid. Similarly, RBI has drafted a standard operating procedure prescribing actions by banks for placing temporary debit holds on amounts, stroke accounts, to prevent money mule activities and cyber-enabled fraud.
Next page. There are 2 SOPs if you lot will make.
Yes.
Yes. One you lot should notice in page 1 and page 2. IJ, serial number J.
This is to be.
And that's what is referred to in page number 9.
So this D is to be implemented.
No, sir.
J has to be implemented.
The mule account money is kept.
The reference in page 9 is to serial number J.
There is no serial number J in this. Which one? Which one? This? There is no serial number J in this. This one?
CRP-CFRMS, custody and restoration of money and grievance redressal has also been approved on 2nd January 2026.
Yes, and at page 9 of the IA,
We
the report status
consequently
report, we
direct-
request the court to implement that.
consequently, we direct that both the SOPs.
It's essentially MHA's SOP.
MHA. MHA is only one.
On J, sir.
MHA is only this one.
No. MHA.
Okay, this will comprehensively address because some high courts have issued some direction. Rajasthan High Court. But this takes care of all that. What I suggested to the.
SOP at serial number, MHA's SOP is only serial number J.
That's right.
So, we accordingly direct the Ministry of Home Affairs to formally adopt and implement the above stated SOP dated 2nd January 2026. And the same be issued across the country for adopting a uniform process to strengthen inter-agency coordination to ensure the timely restoration of defrauded funds wherever possible and enhance
By all the participants.
We don't know which high court. There's only one concern, because people go to high courts. High courts have been issuing some direction, they're also framing some guideline. Therefore, let this order be sent to all the
First, Mr. Attorney, we give directions to the participating entities, that
Correct.
is your police, banks and financial institutions, as well as the adjudicating authority.
That's right.
Under the auspices of all the high courts. Because they have to frame their rules. Some of the high courts have framed rules
Very right.
that without registration of first information report, also the attached money can be released.
Absolutely. But I thought in case people go to any high court need not undertake the exercise all over again in same guidelines.
For adopting by all the participating entities a uniform process to strengthen interagency coordination
Including the adjudication.
direction to the High Court or High Courts. This will be adequate in the next paragraph. The High Courts, all the High Courts will ensure
That the adjudicating authority.
adjudicating authorities within their respective jurisdictions
Ensure compliance of this.
comply with the above mentioned SOP.
Ensure compliance, because High Court to ensure compliance.
Ensure compliance of the SOP. Then say, it was also pointed out by one Attorney General that
As far as those items in page 2, those future action, that will form part of ongoing deliberations.
that the Department of Telecommunication has drafted the telecommunications in bracket user identification bracket close rules 2025 as well as the draft telecommunications in bracket radio equipment possession authorization bracket rules the comments from stakeholders stroke general public have been invited. These rules are being formulated to prevent one eye biometric E-KYC and the issuance of number of SIM cards in one box. Besides, to route international calls as local ones via voice over internet protocol, etc. So these rules can be notified immediately.
They are asking for 2 weeks.
Or
2 weeks.
let these rules be notified within 2 weeks.
I think a little more time is to finalize.
Ask for 2 weeks.
I know. I told the committee.
All right,
I would like to probably look.
Only 3 weeks. 3 weeks. DOT has also implemented centralized international out roamer in bracket CIOR in October 2024 for addressing the issue of spoof international calls to prevent, which helps identifying calls made by genuine international roaming subscribers.
The spoofed international system, which helps identifying.
I know.
Helps identify call for genuine. Probably both आ जाता ना तो उसमें आता ना कि spam. उसका है. The Ministry of Electronic and Information Technology.
Only one copy given to chief justice. No, I see. I think there was a small the copy which I hand over. it was probably meant for my reading. It's gone to your lordship's hand. I think it makes a lot of sense that way.
But it is helpful.
All in the brackets are all meant to instruct me.
Oh, okay, okay. We don't mention this preventive or anything. We will simply set the rules only. But it helps in issuing the time direction. The anyway,
Hotel setup करने के लिए।
G के बाद
Change.
G is already में
हाँ
424 में हो चुका है।
हाँ नहीं नहीं
Can I hand over another copy?
I would like to get the one with the notes.
ये same thing यहाँ पे next paragraph. Ministry of Electronics and Information Technology is directed to develop and finalize a portal for reporting the complaints under section 43 of the Information Technology Act 2000. That will be done within how much time?
It will also require some time. That will require some time, just. That will also require 4 weeks. Let it be around the same time, 4 weeks. And if you're able to expedite it, I'll come back and report.
Let the needful be done within 4 weeks.
Yes, yes.
Let the needful be done within 4 weeks.
उसके बाद ठीक है सब ठीक
Rest is fine. But the so far as the future course of action is concerned, it is pointed out that from our direct the CBI to expedite a registration of the identified digital arrest cases for investigation. RBI is directed to examine the recommendations of the delayed transactions at the end of the issuer bank and take an appropriate policy decision in this regard. The Ministry of Electronics and Information Technology is directed to follow up with intermediaries for time-bound compliance, for which necessary meetings with the concerned agencies may be held. We don't mention any particular thing. Similarly, we direct the RBI, MHA, and Department of Revenue to examine the possibility of to consider the desirability of suspending the suspicion transactions and debit fees under section 12 capital A capital A of the PMLA. Such a recourse, however, will be adopted by following the prescribed procedure in accordance with law. The above, the RBI, DOT, and Ministry of Electronics and so and so, along with Department of Legal Affairs and Ministry of Consumer Affairs, may also jointly hold a meeting to evolve some framework for victim compensation in digital arrest cases. It will be appreciated if a pragmatic approach is adopted and a pragmatic and liberal approach is adopted in this regard. Let a fresh status report, next paragraph, let a fresh status report in respect to the above directions be furnished. Post the matter after 4 weeks on so and so date.
Look, there are a few clarifications. Firstly, in the future actions, DOT is not being covered. In the future actions.
Take the mic.
My. Look, then DOT, in the future action, DOT is pending actions have not been covered, my lords. Firstly, they were to create a dashboard which will include the ISP, TSPs as well as POS, so that the issuance of SIM cards cannot be subjected to fraudulent or additional issuance beyond the caps that DOT itself had mandated. That aspect is not covered in the note at all.
I think
Further,
there are two sets of rules. One rule is meant for this one.
no, not for the dashboard, my lords. The two sets of rules will be external facing. This has to be internal facing, because this will have to be a functionality that DOT, TSPs, and POS will have to do together, which has nothing to do with the user framework. The two rules are pertaining to user framework.
Tell them to examine this aspect.
My lords, the second thing,
The status report refers to it at page 3 bottom. We'll examine that.
my lords, the next thing is DOT has the mechanism to impose penalties. That we have raised the suggestion that that should also then include compensation. Penalties has to be commensurate with the loss caused due to the negligence or willful misconduct of a TSP or a POS, and that has to accrue to the benefit of victims. That again is not addressed. The similar thing with respect to RBI, this Honorable Court has noted repeatedly the way the systemic rot or application has happened. But RBI, whilst imposing penalties, imposes nominal penalties against banks which are violating its own circulars, which is not commensurate with the loss that accrues because of the violation. For instance, my lords have recorded that Mule Hunter as AI tool has been implemented by 86 banks. Mule Hunter is developed by RBI. RBI's own circular mandates that banks have to evolve AI tools, which goes beyond Mule Hunters. Yes.
Kindly turn to page 13 of the report.
The mandate was not just to implement RBI's Mule Hunter, but to develop AI tools which will include velocity checks. And that is what I had submitted earlier also, my lords, that where a digital arrest victim transfers funds which are unnaturally high, even that can be detected using AI tools and can be paused, or it can be a trigger which will then ensure either pausing of the transactions at the issuer bank itself or at the receiving bank's end. That itself becomes a trigger. That has not been addressed.
Give a note to the parliamentarian.
My lords, this has been raised at the committee meetings, and they will have to revert on that. But since my lords are saying that the status report will have to include this, this may also be added, my lords.
Just give a note that during.
Lords, kindly turn to page 10 of this status report, annexure R1, action taken by RBI. At the bottom of that page, the following discussions were held and so, and cyber-enabled frauds. RBI informed that of 26 out of 53 major banks have adopted the Mule Hunter AI.
That is my submission. We are not just talking about detecting mule accounts.
1 minute.
It goes
and
beyond
that.
that.
And clarify that Mule Hunter AI is supplementary and not mandatory. The Honorable Supreme Court directed use of AI/ML tool generally and not any specific solution. Many banks have their own AI/ML tools for fraud risk management. The detection efficacy of Mule Hunter AI varies across banks from approximately 25% to 90%, and concerns are noted regarding high exposure bank. It was noted that RBI and 14C I4C MHA are examining a draft MOU for sharing suspect register data to enrich Mule account detection tools. So I think it will go forward.
My lords, this is my submission, that all of this pertains to mule accounts, not to velocity checks.
One thing is there are in situ circulars with regard to reporting compliances.
Yes.
No.
That if RBI can strengthen the compliance of the reporting duties of the bank.
Exactly. Therefore,
with regard to suspicious transactions and suspicious accounts.
And my lords, if the
Perhaps help
RBI
at an
ombuds,
early detection and thereby some remedial.
Milord, in every case of digital arrest, the submissions that have come point out that the RBI ombudsman has not really taken into account the kind of situation in which the scam has happened. They merely say you have voluntarily transferred, and that was the first submission that RBI made at the committee also. So the fact that the victim transfers voluntarily is part of the scam. But that cannot be held against them for compensation or for remedial action.
I would suggest
And
all
but,
these
my lord,
concerns. What?
the requirement of banks to develop AI tools and implement them goes beyond finding mule accounts. That is my submission, my lords. And that is RBI's own circular, which forms part of my first submission.
That matter may be better left up to the central bank.
My lords,
Maybe
and therefore,
best left to the central bank.
my lords,
to
my
develop
submission is that RBI should
better tools.
implement
They
it,
are showing
enforce penalties if there is a violation. Merely having a circular will not ensure implementation unless there is a penalty that
We are in the process of consolidating it, so do you have a complete clarity on how it really works? So of course, certainly RBI is going to look into it. And
See, there will be certain gray areas where probably with a view to whatever maybe, we will not say that it is their compulsion, but they will not like to pressurize the banks to adopt certain things. They may not like to pressurize. But that does not mean that we will also finally agree to that. We will see that what is to be left for to be done by us.
My earnest request.
if only RBI detects that there is a complete, yes.
If RBI does not take any stern policy decision, even at this stage,
Yes.
when the the information in public domain, official or unofficial, suggests that definitely more than 25,000 crores rupees
Yes,
of
I
this
know.
country has been siphoned. So one of the figures sent to me, it talks of 54,000 crores plus, 54,000 plus crore of hard-earned money of these victims has been siphoned, taken away. That's why I was telling before lunch in some other matter that it is not extortion.
I heard that.
Brazen loot.
I heard that, yes.
And this is absolutely robbery and dacoity. Now, if the banks, if it happens either because of the collusion of the bank officials or if it happens because of their negligence or their perceived action of not annoying the customer. So that means that a kind of a tacit appeasement of the customer. It is not. The banks also need to realize that a customer, if suppose there is an account of a corporate entity, every day the transaction of lakhs of crores is taking place. There is nothing like doubtful in that transaction. But a retiree who is only withdrawing rupees 10,000, 15,000 per month, and suddenly from his account 50 lakh, 70 lakh, 1 crore is being released. Why your AI operated, there's some app in the bank will not peep alarmingly that this transaction needs to be rechecked.
I understand that. That's why this note says on average, but about 75% is successful. So where it has not been able to work for a variety of these reasons, I think RBI will address that question.
Because we hope that they don't invite a direction, and if the RBI can introduce some.
No, morning
has to be a very robust mechanism. This definition of suspicious transaction is the central point for consideration by the banks, whether they are private financial institutions or public sector.
have the circulars as to what is the suspicion.
Yes.
It's a huge network that has developed over a period of time.
Mr. Attorney,
So on the mule account that are
problem is the banks are more into a business mode, and naturally so, with ideas of profit earned. And in doing that, what they are becoming, either innocently or maybe connivingly, the platforms through which there is a very swift and seamless transmission of the stolen proceeds of crime. You see, your report says 52,969 crore to be misappropriated from April 2021 to November 25.
But if you not see the drop, And now after
This is more
the
than-
past 6 months,
This is more than the budget of several.
I'm
several
talking
states.
in terms of the ability of the various banks. I've seen the curves. So it varies from bank to bank. In some banks it is completely, it has dropped down considerably. Yes.
Mr. Attorney, that is where the central bank is the
Exactly.
nerve center. It needs to give points to the banks which have better reporting compliance. We cannot predict policy, but it's
certainly.
for them to formulate
Certainly not.
safe policies.
In their over anxiety of making business, they must understand they are trustee of this money. The people have deposited it only because they have trust in them. And if that trust is defied,
I saw some information in the morning between private banks and PSU banks. Some private banks also have been failing regarding their commercial, concern. So it all depends on what instrument, probably universal.
Their annual reports show only profit leverage. They do not show compliance leverage.
Some PSU banks score a high on
Compliant is not shown.
what is happening is that these banks are, in due course of time, they are becoming a huge liability on the public at large. The courts have become their recovery agents. They lead into granting recklessly loan amount to these fraudsters.
That's a story.
All the so-called.
That's a different story.
And then you have NCLT and a battery of the quasi-judicial system only to recover money for them. Why?
Yeah.
They should be punished. They should be in
That's
fact put behind the bar if they are indulging in this kind of thing. Their managements.
That story will certainly take into account.
Now they don't care to even check these transactions. People are high and dry.
I'm sure with the RBI getting into the matter and then developing.
See the professionalism or quality of banking which they are showing, then there is something inherently wrong with their way of functioning.
Look, and where the RBI itself has shown some of the banks to be negligent. The RBI ombudsman should necessarily then consider a victim's petition in light of that negligence on where should the liability lie. But that is not being done, my lords. Today, the victims are not too clear about where their remedies lie. Therefore, if there is a direction to the RBI ombudsman to entertain.
Why, Madam RBI ombudsman, whenever this suspicious transaction take place, see, our is a country, we are so advanced in technology.
Yes.
First of all, you have to have only AI based. They don't require extra staff for it. What they require is only an app, which will detect that this is the trend of the transactions in a particular account. You are not closing that account. You are only stopping it, only for re-verification.
That's right.
Immediately from the bank, a message should go to that here is alarming message. And simultaneously, most important thing is that message must go to the nearest cybercrime police station.
That's happening. All that SOP takes care of all of that. SOP takes care of each one of these minor details. Kindly turn to page 52 of the report.
This suspicious transaction must be reported to the cybercrime police station.
This SOP will address all of them. That's why I said once the SOP is put in position, you'll see
It will take up after 4 weeks. Meanwhile, you study all these.
I'll also have a review. Look, there are two corrections. At H1H, the Ministry of Electronics, MeitY, has said that they are developing a portal for reporting complaints under 43. It's not clear why they want to invoke 43. Firstly, 43 is civil penalties. It will have to be 43 read with 66 IT Act. But that goes into hacking, virus attacks. It would just create confusion in the minds of victims. The request or the suggestion was for either a separate portal for digital arrest victims or for financial frauds with clear headings for digital arrest and various other forms of financial frauds, or in the main NCRP portal itself to have a separate vertical for financial frauds and for digital arrest. 43 seems a little bit of a miscalculation there or misapplication.
This work is in progress.
That goes into issues of hacking, virus attacks, distribution, denial of service attacks.
You see, that portal also, to my mind, once you create a portal, then they will shift onus to all the victims.
That's
that you have
But
not reported.
NCRP is already there in that sense then. So why another portal which goes into all the other kinds of cybercrimes?
No,
What if we read with
let's
lead to others?
make some progress and find out where it doesn't work.
All I'm saying is this may be modified to say, let there be a separate.
Let us not do it today.
Either financial frauds or digital.
Give a set of suggestions to him.
My lords. And one final correction, my lords, at 2E, my lords had noted about the examination possibility of suspension under 12 AA PMLA. It may also add 106 BNSS, my lords, equivalent of 102, because PMLA may not be applicable
covered in the
to
SOP.
cases.
Covered in the.
There in the SOP.
My lords, since there is a direction from my lords on PMLA, that's
We
why
have directed
The other
the
side
SOP
has
to be
also
adopted.
started coming before us. We are
have-
afraid of that.
that balance is what we are trying to.
We had Article 32 saying that is.
My lords, that balance is what we are hoping the SOP will bring in.
We have
Since
consciously
BNSS is
mentioned.
being applied indiscriminately and freezing of accounts taking place throughout the country.
My lords. But in a way, 106 BNSS and 12 AA PMLA capture what the Scams Act of Singapore effectively provides for, my lords. So one issue that arose was, do we need an equivalent law of Scams Act? We don't need that. Existing provisions can be applied in similar vein.
That can be crossed later on, but
Yes.
the existing provisions be really given effect.
So let us see that what comes out and then what is left out, then we'll see. Examine that part also. We post this matter of, give a date on.
And may I request for an NMD date, my lord, since the matter will be heard at length.
The turn may or may not come, that's why we are purposely keeping on Monday.
My lord.
Even not on Friday also.
My lords.
The things on Monday. On a Monday after 4 weeks. Immediately after 4 weeks, whichever the earliest Monday, fix it on that day.
May well have your lordships leave.
Don't file individual matters, you tell the learned micers or to the learned attorneys, we'll see what is to be done.
May your lordship leave also to make a request. Item 36, there's an IA regarding the CAT Bar Association. The Calcutta High Court has virtually said the functioning of the tribunal. Item 36.
Items?
There are two interlocutory applications there. One is IA number 42091. That is for implement in the main CAT Bar Association. Then IA number 42093, where we seek a stay of the High Court's direction. The High Court says the tribunal will not function. And then, in fact, in another matter from Kerala High Court, somebody filed a co-warrantor petition saying members are appointed in terms of the Tribunal Reforms Act will not continue to function. So I probably give a lordship that writ petition number also. I think both these matters should be transferred here. A lordship should hear these matters.
No, we will hear that, but why benches are not constituted on it anyway?
Today was the day the tribunals are not functioning.
Yes.
Court said you will not function. Kindly see the interim order passed by the High Court. 4th of 29, they issued notice, and 4th,
So what is the order passed?
there's an order dated 4th of January, 4th of February.
Where is that order?
Can I hand over a copy of it?
Lord, kindly come to page number 163 of my IA application. IA number 42095 of 2026. The High Court directed tribunal should not be functioning.
36.
36.
At page 2 of this order,
Just a minute.
paragraph
Why-
number 2.
Why the CAT bench is not holding
Page-
court in Port Blair?
Kindly turn to page 2 of this order.
The impugned order is page 160.
Paragraph 2 at page 2, therefore pending disposal, we direct circuit bench will not function.
Wait the order, कहाँ रख लिया आपकी files?
We handed over a copy of the 4th.
Lord, IA number 42095.
Kindly, 4th February order, page 2. Para 2. The High Court proceeds on the footing merely because the tribal reforms had been struck down. Members appointed to various tribals will also cease to hold office.
Which paragraph?
Paragraph 2 at page 2. Pending dispose so and so will not function.
Direct the.
Only
That cannot follow.
on the top, it is decided that the circuit bench is known as in the eyes of law. Since
The High
provision
Court-
in terms of which
The High Court proceeds on the premise
have been struck down by the Honorable Supreme Court. The time, energy, and money spent in proceeding with the matter would stand wasted. Therefore, pending disposal of this issue in the present proceeding, we direct that the circuit bench of Central Administrative Court Blair will not function. Why the High Court?
No, this is absolutely against
the
the
High Court may just explain.
Constitution
sir.
Amendment of 323A and B of the Constitution of India. And our larger bench decision also there in terms of the L. Chandra Kumar judgment reported in 1997, 2 SCC page 261. The L. Chandra Kumar said all
No,
the.
the effect of, if at all, the effect of the judgment of this court is
Yes.
that instead of 4 years, their tenure will be 5 years.
That's right. Therefore, the question.
Assuming.
You're right.
So that means that they will rather continue.
Yes. Can you clarify this in a stay of this order?
Exactly.
madam?
That's the most pragmatic way of looking at it.
Say, having been brought to our notice,
Yes.
the matter by learned counsel for the petitioner bar association, as well as by learned attorney general for India, we stay operation of the order dated February 4, 2026, passed by Division Bench of the High Court at Calcutta, in bracket circuit bench at Port Blair, in MAT/5/2026, area number 1, serial number 6. Consequently, we direct the chairman of the Central Administrative Tribunal
Yes.
to depute the circuit bench
Yes, madam.
at Port Blair
Which supposed to commence today because of the stay order.
forthwith to enable that circuit bench to hear the matters
Yes.
on day-to-day basis.
Would it be in order if Lord should transfer these petitions here so that I find, as I said, Kerala High Court is entertaining
Yes.
certain petitions. Therefore, we're going to have problems all over.
Since the matters reforms of different tribunals is pending consideration before this court, we deem it appropriate to transfer MAT
255 in Madras Bar Association. It says the appointments prior to 2021 will continue. Their appointments will not.
But the rules of formal appointment.
Yes, very.
In this regard, we have used para 155 of the recent judgment of this court in so and so, so and so. So, having regard thereto, we deem it appropriate to stay operation of the order dated 4th February 2026, passed by the so and so, so and so. वो जो पहले लिखा था. Next paragraph. We also deem it appropriate, since the matter the reforms in tribunals is pending consideration before this court. MAT/5/2026 pending before the High Court at Calcutta.
circuit bench at Port Blair,
This is before the circuit bench only,
which is pending before the circuit bench at Port Blair. Calcutta High Court circuit bench at Port Blair.
before circuit bench at Port Blair. As also, which is the matter in Kerala?
There's a writ petition number 46504 of 2025. I'll give the list.
Are ordered to be transferred to this court. Transferred to this court.
But till such time, I also pray before your lordships.
We request the other high courts, we request all the high courts not to entertain petitions with respect to the constitution, continuation or composition of the tribunals of the national state tribunals, to the extent the issues are pending consideration before.
But I also pray one submission before your lordship, the High Court overlapping the jurisdiction of the tribunal entertaining.
We have stayed
Grateful, Malad. But both I application may be allowed, Malad. Yes. I also find on.
Service matter that the High Court is justified in entertaining it. The only thing is that issues are pending before us. Therefore, we don't want any parallel.
Yes, yes, Malad.
It is not that the High Court is without jurisdiction.
Can they fix a specific date, Malad? Any date, lordship, can be fixed, Malad?
What is left, otherwise we have transferred the case better and we set aside the order date.
That's right.
We set aside the order date before.
That's right.
Matter, and
Yes, yes.
so then list on so and so date after transfer, after 8 weeks.
Grateful, Malad.
All right, thank you. No.
Grateful, Malad.
Yes, next item. Now, the pure matter, Mr. Diwan.
Yes, grateful.
Person present before. So she's going to not make that the submission back that's up your change.
You can't hear, sir. Just a minute, wait for the turn, please. Which item are you referring to? Which item number are you?
I'm in 40 point. I was in 40.2 where I'd handed over.
My friend is talking about 40. Mr. Diwan is 40.2. I'm 40.1. I think Mr. Diwan was on his legs last time. I thought Mr. Diwan could start.
Just a moment.
Before. This is the sufferings, the harassment on the ground of non-citizen. How could the election commission accepting such objections?
Your assistant, Mr. Diwan? You're with him?
Complete that. Someone objecting to that,
We have already pointed out last time, even without arguments, we have told them to rectify it. Wait for a minute. So let us advert to the last order, what we passed, and let us see what is the complaints.
Because the last order is on 4th of February 26.
4th February, that's it.
Your Lordship was pleased to issue notice in certain writ petitions. And thereafter.
Para 5, I think, Mr. Diwan. Para 5.
Yes, para 4 and 5. Yes.
Oh, para 5 is only for listing the other matter, then the main order.
No. There's the 3 petitions which are captioned where your Lordship was hearing us. Just above para 4. There were these directions, there were certain observations your Lordships had also made. So if I may be permitted, just continue with that note. I'll bring your Lordships up to date with the further developments that have occurred over the weekend. And we'll just make our short submissions.
That no application for judicial is being taken unless the applicant discloses own identity and address. And the ground cannot.
Sir, if all of you will start arguing together, then we'll not be able to hear. One by one, we will hear all the matters. Yes, Mr. Diwan.
Yes. Now, Manoj, may I just request the court to take up?
It just been consecutive. 14.6 is the repeat. Organization calls another something. Find an IAM, including certain, praying for certain beliefs, which I think respectfully deserves your option's attention.
My
Let
lords,
Mr. Diwan go on.
my lords, this petition, I appear for the state.
Yes.
This is supposed to be a public interest petition. This is an organization that takes care of temples. What interest they would have in overseeing an election is a moot point. But that's the first point. That's the first point. And
Persons who go to
and the second
temples also
point-
go to polling booths. to
Yes,
vote.
of course.
Yes.
Why
My lords, and the
aversion
second
for
point,
temples?
may I just say
Why
this?
this aversion for temple?
No, may I just also,
That's not the right way.
may I also just say this, my lords? Your
But
lordships,
sir,
your lordships
Let-
last order.
Problem is that in none of the matters we are permitting petitioner side to argue. It is happening there with Mr. Diwan also, it's happening with Mr. Giri also. Let us hear one by one.
Yes,
We are,
that's
One thing, my lord.
we are not shortage of time, we will hear. Mr. Giri, what is your matter?
Item number 40 was our matter, my lord. Well, item number 40. There are certain problems which are happening every day, my lord. We are trying to draw your lordship's attention.
See, if you people will not maintain discipline, then you must know the nature of your chief justice. I will throw out all the matters, will adjourn the cases and will stop the hearing. If this is the way of you people.
Where will you go, my lord?
Interrupting, we are hearing concept for the, we are starting the argument, somebody starting speaking like this. Is it the way to argue in court? Are you sitting in a grain market or you are in court number 1?
I just request the court master to hand over that note. We have given it last time as well. Justice Ajaria, we have given extra copies also today.
Where is that note?
Yes, it was given last time, but we've given furnished an extra set as well. This was the note which was circulated on the 4th of February. I think I'll just mention 2-3 things and then rapidly try and just make my points. You may have a marked copy from the previous occasion. You may. But in any case, this one is a fresh. So, Manoj, may I just, your lordship has that cover sheet? Correct. So this, Manoj, I just want to apprise Justice Sanjaria on 2-3 points.
Yes.
We had, yes.
My brothers are not here.
Just very, very quickly, there's a, as your lordships know, there's a special intensive revision of the electoral rolls as far as West Bengal is concerned. This case essentially deals with that. There is a time that process will end on the 14th of February. So there is tremendous urgency, my lords, with respect to the specific directions which we seek. There are 4 or 5 heads under which we will be making our submissions and suggestions. On the last occasion, on 4th of February, there were certain observations which were made by the bench, and we therefore, pursuant to that, have handed over. I'll bring your lordships up to date on that. That's the general conspectus. There's just 2-3 figures I want to give your lordship. The first is, sorry. Yes, the first figure, which is actually not in my note, and which you may just note, is that the draft list, the draft electoral roll, which was published, has approximately 7.08 crore electors on it, the draft list. Please note that figure. The second figure is that out of these 6.75 crore, I'm sorry.
Approximately
7.08 is the draft list which was published around the 16th, I think, of December 2025. Out of these 6.75 crores, approximately 6.75 crores are mapped. By mapped, what it means is that each of these electors was mentioned in the 2002 list, so they are mapped, or they were identifiable through some family member, etc., some relation in the 2002 list. So 6.75 are mapped. Now, we are really focusing on this particular 6.75, sorry, and just to indicate, 32 lakhs were therefore unmapped. 32 lakhs were unmapped. I am primarily focusing on the mapped, and my first submission, which we had made last time, was that 1.36 crore of the West Bengal electors were found through a process which was known as logical discrepancy. Your lordship will recall that. So that was a computer program which they ran.
Where is that order where we dealt with briefly about this mapped, unmapped and logical discrepancy?
Yes, your lordships have dealt with it on the 19th January order.
19th January.
If your lordship has 26838 IA.
IA 26838.
Which page was it?
IA 26838.
Which page was it?
Page 30. 40 points.
Your Lordship has it, page 38.
19 January, para 2 of the order.
Yes, may I just place it? It appears that approximately 1.4 crore individuals have been issued notices for the purposes of document verification. These notices are broadly categorized into three parts: mapped, that is the category of voters who are linked with the 2002 SIR; two, unmapped, the category of voters who are not linked with the 2002 SIR; and three, the third category involves logical discrepancy accounting for approximately 1.36 crore voters. Now, Millards, just a pausing here. These are all mapped. 1.36 crores are all mapped. The documents brought on record by the parties indicate that within the category of logical discrepancies include, inter alia, a mismatch of the father's name, a mismatch of the parent's age, a difference in the parent's age of more than 50 years, a difference in the grandparent's age of less than 40 years, and those having more than 6 progeny. With a view to enabling the persons who are, as of now, included in the category of logical discrepancies, we deem it appropriate to issue the following directions. The names of the persons figuring in the logical discrepancies may be displayed in the Gram Panchayat Bhavans, public places in every taluk, and block office in every taluk subdivision, as well as in the ward offices. Two, persons likely to be affected are permitted to submit their documents and objections through their authorized representative. Such an authorized representative can even be a booth-level agent. There shall be an authority letter in favor of such representative, whether signed or thumb marked, and documents and objections may be permitted to be submitted by the Panchayat Bhavans or block offices. The Election Commission of India shall issue instructions for providing an additional 10 days' time from the time of displaying the list in the Panchayat Bhavans and block offices to all persons who have not yet submitted their claims, documents, or objections to do so within the extended period. The state government shall provide adequate manpower for Election Commission and the state elections for deployment of Panchayat Bhavans block offices to handle documents, objections, and hear persons likely to be affected. In this regard, we direct the district collector to meticulously follow the instructions issued by the Election Commission of India or state government for deploying adequate staff and forces to ensure smooth functioning. The Director General of Police, West Bengal, Superintendent of Police, Collector are instructed to ensure that there are no law and order problems at the location and that the entire activity proceeds smoothly. All affected persons may, in addition to being given an opportunity to submit documents, materials, or objections, also be heard at the time, either in person or through the authorized representative accompanying them for the purpose of making an appropriate decision, and the official will also receive the documents. At the hearing may also certify the receipt of the documents and the conduct of such a hearing. This para 10 is important. The Madhyamik Class 10 admit card, which discloses date of birth of the candidate, may be submitted as part of the Madhyamik pass certificate during the hearing. Your Lordship.
Well, my brother will now.
Yes, now, Your Lordship, I'm very obliged. Yes, absolutely right. So, Millards, this was the background. Now, Millards, I'll just go to my point by point. Now, if Your Lordship just takes up my note, please just go straight away, if Your Lordships would, to page 4 of the note.
Page 4.
Yes, Your Lordship has, sorry?
Yes. Submission
Yes.
para 7.
Yes, paragraph 7. Right. So now this was the first set of points. A majority of the logical discrepancies, more than 50% of 70 lakh, are cases of minor name mismatches or spelling variations. For example, Roy and Ray, Ganguly and Ganguly, Datta and Datta. A sample set of discrepancies is enclosed at page 8. Now this, my lords, we had projected on the last occasion. Your Lordship may just go to page 8 of the note. Yeah, 50%, my lords.
So if you read your para 7A.
Yes, 7A.
Conjunction with para 2 Roman 3.
Yes.
Our order of 19 January.
Yes.
That means out of approximate 1.36 crores.
Yes.
70 lakh people are those where this mismatch or some.
On names. And these are mapped individuals. Well,
so last time,
yes.
Last time we said that because of the non-availability of sufficient manpower,
yes,
the Election Commission was compelled to take up persons from the outside the state.
Yes, special officers. Yes, yes.
Something.
Micro observers. Yes, yes.
But during the course of hearing last time,
yes,
verbally,
we indicated that we would. Yes. We have given them the particulars of 8,505 officers. We've arranged it, and I'll just hand over. So just give the note.
Because what will happen is that suppose a person from Delhi,
yes,
or Rajasthan or Punjab origin, suppose he goes there,
yeah,
he will not be able to understand this mismatching.
Yes, so that's one thing. And the second element is, of course, also, my lords, on respect of jurisdiction, which we'll come to. But if your lordship just takes up this supplementary note, which I've just handed, just to respond to the, yeah, just give this. This is exactly to answer your question. Give it to the other side. Give it to the other side. Page 6, my lords, page 6. Please go to, yeah, this is the email of 7th of February, which was on Saturday. In terms of the observations made by the Honorable Court during the hearing of the captioned matter on 4th of February 2026 and under instructions of the government of the state of West Bengal, please note that West Bengal is ready and willing to make available 8,505 number of Group B officers.
This mail is being sent on 7th February.
Yes, it was on the weekend, my lords. It was on the weekend, but we had to get the available officers. All the particulars are given. Because we have not burdened the record here with the individual names, but they have been supplied with the individual names.
Have you sent the list of these 8,000 something?
Yes, yes, yes.
Have you received this list?
Yes. No, my lord, your lordship will see the district-wise.
In the same note, kindly see the next page.
Yes, the next page.
This is what they say the detail.
District-wise indicative list of number of Group B officers who can be made available, and we've particularized the names. The names are given and were sent.
I'm afraid, my lords, no names were given. This is all that we have received at 12:30 in the afternoon on Saturday.
See, because how, that is the whole problem.
Yes.
The officers with their full nomenclature, designation and particulars.
Yes.
The names will have to be sent, then only they can take them temporarily on deputation, kind of.
Yes, yes, yes.
Statutory deputation.
That will be furnished. We've given the particulars because we asked them kindly confirm the same at the earliest, whereupon the requisite particulars of these officers shall be shared.
Only number is given, not the names.
No, the names are fully there, fully compiled. If your lordship sees the email at page 6 of this note. Kindly confirm the same at the earliest. So we furnished the district-wise particulars and we said that you please just confirm the whereupon the requisite particulars of these officers shall be shared. For further action, so they can be immediately deployed, my lords. These are all made available. Yeah, you give it to them.
Never made available, my lords. They want it.
Sorry.
See, we don't want any dispute on facts.
Yeah.
Because then we will have to ask the chief secretary to file an affidavit that has he sent the names to the, because commission says.
No, my lords, I am told that we were awaiting the confirmation. The names are compiled and they are ready, district-wise and designation-wise, as your lordship indicated.
Group B, all Group B.
They are all Group B.
Till 12.
Yeah.
The mail is being sent around 12 o'clock.
Yes.
The names are not.
The advocates to the advocates.
For the government, the lordship wants the numbers which I can offer for this. Micro observers.
No, but
Got the numbers.
Singhvi,
It's not micro observers. Dr. Singhvi, it's not micro observers.
You know, state government officers who are supposed to be sent.
Yes, so therefore, Group B officers.
And ideally, on 4th February, when a statement is made before us.
Yes.
On 4th itself or on 5th itself, they could be sent the names so that these are the officers.
Some confusion. No.
Lords, we took a little time to compile the names. The state took a little time. By the time that then these advocates sent it across.
But even till today, the list has not been sent. Names
The list is available, my lord.
We send them from AR to AR to confirm. Just note two things, Balus.
Mr. Diwan, there is a difference. If you will see the scheme,
yes,
it's not the names available. It's the question the officer will have to go and report to the district electoral officer or the state election commission.
Lords, the request was that the request was that you please confirm to us and we will immediately provide the particulars because the only.
But not required their confirmation because this was the statement made before us during the course of hearing.
Yes.
So you were only supposed to comply with what you said before us, sending the names of 8,000 plus whatever officers you want to send.
Yes.
That here are the officers in terms of the observation.
All right, so we'll
As
furnish
rightly
that.
mentioned in the
We'll immediately furnish the list. There's no problem.
Number one, this is the entire list. I don't want to load this here before the court. This is the list. But
Singhvi, the lists were not supposed to be sent through the court.
no, Malas, it's not. It was that explanation I'll give. But just see the note of 2 pages for a minute. Malas, they are saying that they didn't know about it. Just give that note. Please give it for madam. Please give this note first. Madam, this note. I'll just take 2 minutes, Malas. Because impression is given that we were not ready with the names. My lord wants Malas Gazette Class B, because one of the earlier
Has to
name.
be, because unless you will give the details of the
Correct,
officer.
correct. Now, just give me 2 minutes on this, please. Just come to para 5 of this note. I'll just take a few minutes on this note and then I'll tell Lordships.
Yes.
Till 4th of February, I have deployed rather, 80,681 BLO appointed by the ERs in terms of ECI notification, the rejoinder, etc. Forget it, I've given the actual pages, where BLOs would be appointed at the first instance among any Group C and above regular serving employees of the state government enrolled as an elector. 8,524 ARROs appointed by the ECI with a notification dated 29th, 26th, 18th, etc. dates are given. Being
That's
employees
right,
of
that
the
every
state
state
government.
does it.
These AREOs are majority from Group B, rest are from A and C. They are typically, this is important because what Lordship got earlier were craftsmen and teachers as well as painters. PDO, Deputy Secretary, BDMO, Inspector, ICDS, Revenue Inspector, BLRO. 294 EROs appointed being Group A employees of the state government. They are officers holding respective offices in terms of ECI notification, being officers who have completed 9 years of continuous service, equivalent to SDM, SDO, etc. rank. ECI has wrongly contended because West Bengal did not provide SDA rank officers, it was compelled to appoint 8,000 micro observers. When these MOs, these officials are of much lower rank, including art and craft, teachers, master craftsmen, customer, no idea of local culture, no idea of local management. ECI has raised objection to appointment of non-SDO, SDM levels as ERs. They are the letters of ECI. By letter dated 17th of October, I clarified to the ECI that officers of only the ECI notified designations have been provided, which are approved designations by ECI in previous elections, and no new designations not used earlier was considered for appointment of EROs. 294 represent all the 294 assembly constituencies.
Yes.
Then Malas, just turn the page. Certainly Malas, para 6, your Lordship will just note, all these offered as so-called micro employees or micro observers are Malas, very remarkable categories and from PSUs and central government employees having no connection with the local culture of West Bengal. None. I have highlighted 3 quaint ones, Malas, master craftsman, art and teacher, customer assistant, but even the others are Malas of PSUs. They are not local, they are only central government PSUs and central government departments.
So what is wrong with that, even if the central PSU? Question is very simple. Micro observers are from outside. So whether they are PSU or the central government employees.
Then let me answer that. My Lord is right. They are, look at the level, Malas. They are clerks, they are customer assistant, they are master craftsmen. Malas, the person has to do the job of a BLO. My Lord will see what the one size fit all will not work here, Malas. These are not people who are in any manner versed. Look at my categories, Malas. The people I am giving, BDO, Deputy Secretary, BDMO, Inspector, that is the point being made. A, rank-wise very low. B, Malas, training-wise inappropriate. And then, Malas, last 2 paras, 7 and 8, approximately 1 micro observer per arrow has been appointed. Such micro have been appointed from central PSUs and other organizations. They have no connect with Malas, West Bengal. They have not served there. They don't know how to handle it, Malas, straight away. If you put a clerk there, Malas, then in any event, the state, I was reading, then was para 8. In any event, I am now making, I am meaning the state government, Malas, available equivalent number of such further Group B officers across the state.
Yes.
Approximately, I am told it is 8,100, subject to correction. 8,500 or 500. Equivalent number. An indicative district-wise list, etc. Now, Malas, I understand that these were sent through advocates on record.
Your para 8, now in your today note prepared, you are saying that now you are making available them. So obviously, now this is being acknowledged also, that nobody has forwarded this list of 8,500.
Apparently, it was forwarded.
By now, the
Yes, very well.
had it been, say, sent on 5th of February itself, on 4th when we heard the matter, by now they would have taken a decision, we would have called upon them that you please tell us.
See para 9. Well, I can't, suddenly, my learned friends are also making arguments here in court only. The ECI never requested the state, never earlier, to make available further Group B officers. And the question of failure to do so cannot arise. Only the court at the Honorable Court at the last hearing made a suggestion. That's how it can only be between then and now.
Yes.
And Malas, they can perform the roles, Malas, the roles which are required, which I have itemized at page 4, etc. All I am saying is, Malas, this is a correct way of doing it. They have never involved us. They have never asked us. They have never, I mean, suppose I could send it so motu, but that would hardly have any meaning. Your lordship did observe this orally last time, and we have promptly put it on record. That is as far as the numbers go. I have other things to say on other issue, but this is only on the micro observers point.
So your lordships may take it that now that list of 8,500 has been now handed over of individual officers because.
No, it has not been sent. Probably up till now it was a proposal to send it, but now in any case you can send it. We can ask, examine in particular.
We've handed it over just now because we were waiting for their response. But now.
Nothing has been.
Formulate this point.
I'm afraid nothing has been handed over to us when it comes to the names. When you're talking about 8,000 and odd names.
Taking time to reach you.
Yes, I agree.
No, sorry.
They have just given it.
Just ask one of your junior to see that whether the names, designation, place of posting, contact number, anything is given.
We will check them, Millets.
Because these were the basic thing required.
We've also given copies for the court.
Behind the on top.
This one, yeah, this one.
No, it's kept behind. That.
Oh, I see. It's kept on the table behind the justice company. Correct.
Purpose of notification is going to contact them, Mr. Diwan. And or have they been instructed to report to the local district election officer?
As soon as they do it, we can immediately issue instructions. It has to be done because it can't be that people in this number are just excluded even though they are mapped because of some name discrepancy, because that's our essential point.
How many are there?
Certainly it be expedited. And that is
he gave 8,000.
this one.
8,500. This is 8,500. 8,500.
This issue was never raised before the last time.
We'll take that one. Now I'm talking about the note.
So can these persons report to the concerned EROs by tomorrow?
Yes, yes, yes. Yes.
So, Mr.
If
Ravi,
required.
first of all, because of this, unfortunately, these are again incomplete kind of particulars. We do not know what does mean this SAG2, ACS, head clerk in which office?
This is competition, assistant competition.
Department is mentioned.
This is road division clerk.
All right, all right.
This is SAG is.
So the department is also mentioned.
Yes, sir. DPO is drawing and dispersing office.
So first of all, your EROs, the designation is ERO, no AERO.
No,
This will be.
they are micro observers.
They are micro.
Report to whom? They will report to the
They have to report to EROs and AEROs.
ERO,
AERO.
AERO.
The irony here is that, Millets, before I could get into any other detail, EROs and AEROs are, as they have supplied Group C officers, etc., they are subordinate to these Group B officers who are supposed to be advisors. They can only micro observers. They have an advisory role, nothing else.
These AEROs
Yes.
are all state government officials.
Yes, Millets.
They are state government officials.
Yes.
And their designation is
Lower than, most of them, lower than these micro observers. I'll explain this, Millets. Millets, we wanted.
lower than micro observer, lower than the officials list now being given.
Yes. They're all Group B officers. May I just explain this to me, Millets? To your lordships.
AEROs are either Group A or Group C officers.
We wanted all Group B officers, 300 of them.
Yes, sir.
They have given us only 80 of them.
Yes,
The remaining, they have given Group C an assortment.
How many 80 are Group A officers.
Group B millets. Group B officers,
Now-
80,
now
not the remaining.
800,
No, they are about 300.
8,000 Group B officers.
Yes.
AERO are already appointed.
Millets, when we want them.
AERO.
Yes.
They are only going to assist.
I'll answer. Just millets, if they are quiet, I'll answer everything so that they could answer me. Rather, whatever the issue that I've raised.
No, no. You have one AERO, you have one AERO in every constituency.
Yes, millets.
No, can I just solve this, fellas? These are all BRO, these are all Group B officers, this list, this big list. They will all report to EROs, all of whom are Group A.
No.
294 constituencies, 294 EROs, all are A. All of these are B.
The very unfortunate thing, Dr. Singh, they are refuting in your presence only that they are not Group A officers.
No.
Millets, out of 300,
They are B, they will report to A.
out of
They are
300,
No.
let me complete millets.
Is there any officer of the state of West Bengal to whom we can catch hold? The problem is that somebody is irresponsibly.
No, of course, fellas, he has to be here.
What is his designation? Please come bring him in front.
Of course he is.
So, Mr. Chief Secretary, you are here.
Former Chief Secretary. He is now the Principal Secretary to the Chief Minister. He was the former Chief Secretary. So he is.
All these 294 are Group A only.
I am afraid.
Group A.
This
All the
completely
294 are
incorrect.
Group A only. And all the 294 constituencies are Group A only at the ERO level.
The problem is that we are basically, when we are stuck, we are stuck. We will not proceed further. Now, the gentleman has been Chief Secretary, now he is advisor to the Chief Minister. So, who knows better than him, after all holding the executive head of this, the state civil services. Now, can you, what's your good name, please?
Sir, Manoj Pant.
Mr. Pant, can you please tell us that 300 names which were required to be sent for the purpose of AERO? How many of them are Group B? How many of them are Group A? Or how many of them are Group C employees?
Sir, all EROs, 294, they are all Group A officers. Either of the rank, all are of the rank of SDO or SDM. They have completed 9 years or more service in the West Bengal civil services. And some of them are IAS officers as well.
EROs?
EROs.
Or AERO?
EROs, electoral registration officers.
Now,
294.
in every constituency, there is one ERO.
Yes, every
Right?
constituency.
And how many AEROs?
8,524 AEROs are there.
Approximately in one constituency of assembly constituency, how many AEROs are required or normally deployed?
3 to 4.
3 to 4.
Sir.
So, say approximately in your state, you require, how many assembly seats are there?
294.
294. So let us take it 300.
Sir.
300 multiplied by 4.
300 multiplied by 3, around 3, sir. 900.
All at 3. Then you require 900%. 900 AEROs. How many names you have given in the AEROs?
8,524, sir.
Now you are giving.
No, this is previous. These are AEROs, sir, who are already appointed, who are working under EROs.
What is their rank and designation approximately?
Of the ranks of Group B officers, 65%, and yes, and Group, otherwise all are Group A and Group C officers.
All are Group?
Group A and Group C.
No, 65% is Group B.
65% are Group B.
How many are Group C out of them?
Only 10 to 12% would be, sir, right?
Only 10%.
Sir. Actually, sir, AEROs are there to assist the EROs. And the,
So ECI has notified the AERs.
and these AEROs are notified by Election Commission of India, sir. After notification only, they are appointed as AEROs.
Now, is it likely to be an anomalous situation in case out of these officers, those who are now sent to assist or advise?
Assist.
Assist, that some of them will be senior to than AEROs?
Not the EROs, sir. EROs are all Group A officers of West Bengal Civil Services Executive or IAS officers.
They can report to the EROs.
They will report to the EROs.
And they are only assisting, my lord,
in the
to
process.
ensure that no names.
In any case.
May I answer that, millets? What they're telling is that, millets, they're all Group A officers, etc. We have written 5 letters to them saying EROs are quasi-judicial authorities. Please provide us either SDMs or SDOs who are revenue officials who have been experienced in passing orders after adjudication, etc. This is what we wanted. What they have done, Millets, they have given us 64 of them. The rest, they have only seen the pay parity. For example, engineers from all walks of service. They have given us saying these are group 1 officers.
No, they are
But
not-
we wanted.
They are not servants or the revenue officer.
They have nothing to do with the whole thing. They don't have any process at all. Miller's objections raised and they have to pass a speaking order. That has to be challenged in an appellate forum. For that purpose, 5 letters were written. Please, these are the officers we wanted so that they could adjudicate and then the rest of the process could take place. They have said during elections, these people were deputed. During elections, they don't pass orders. In SIR, they need to pass orders.
Election duties are something different.
Entirely different. Now they say these are all approved categories. Approved categories in the context of elections, not SIR. We are specifically asked 5 times. This is the role they have to play. And they have not given. Now, Millets.
And
Yes.
let us now try to solve this where
Yes.
stalemate must go.
Yes.
Okay. One thing we would like to very clearly that whatever orders, clarifications, interim direction may require, we'll have to issue. But we will not allow to create any impediment in completion of SIR. It must be very clearly understood by all the states and the state authority. Now, just to remove this stalemate, now that you have got another bumper draw of this 8,000 something officers, whom might be some of the officers are those who have dealt with in their services. Either they are, say, like subdivisional officers, civil SDM as they call, or they might have held the position as DRO, revenue officers, or whatever designation nomenclature they have.
May I just add only one thing here, Millets? Let them provide the nature of work they have been discharging. In the list, a revised list they could give by evening, vis-a-vis all these 8,300 people, what is the functions they have been discharging? If they draw from various walks of life, we need to know what they are because my lords may can appreciate.
If you like head clerk, upper division clerk, inspector.
Department, yeah.
Yes, ma'am.
Land and Land Reforms Department. Mr.
Yes, ma'am.
Naidu, please
Yes.
go to the second last column.
Yes.
The department is specified.
Yes.
You see L and LR. That
Yes.
is Land and Land Reforms Department.
This is the department, but the role that have been playing there, we don't know.
So you see the designation, law,
Yes.
LDC.
Yes.
That's the lower division clerk.
Low division clerk.
Sure. So they do office work.
My lord may kindly appreciate. Now we are coming to first Millets.
In any case, ERO and AERO, you have already notified.
Yes, yes.
Unless you find them, some of them not really up to the mark in the sense that they do not have the quasi-judicial experience and they need to be replaced. And suppose you have some officers available here in this list
Yes.
with whom you can replace, you can do that exercise. Number 1. Number 2.
May I just interject?
That's very appropriate,
With your
Millet. That's what
permission.
our intention is.
Millet,
Now
with
they
your
have
permission,
provided
may I just
8,000 Group
interject
B
here?
officers.
May I just interject?
EROs and
We are
AEROs we
not
can have
seeing
from that pool.
replacement of about EROs and AEROs, Manoj. That's been notified. We are only concerned with the micro observers
No.
who are being
I'm afraid that's
substituted.
not correct.
So that's all this is
I'll answer.
for them.
We are coming to that point.
Yes.
The second point will be that because this anomalous situation of senior or junior might arise.
Look, these will be only assisting or replacing the micro observers. Now look at what the micro observers there.
May I answer that, Millets? My lords have very felicitously observed that from this pool, I can as well replace EROs and AEROs because I want SDMs and SDOs. They cannot have any objection. Once they have provided a pool, Millets, I wanted competent officers. I can give one illustration. When somebody defies my order, yes, please, let me complete. I can answer.
That is nothing unfair in it.
Yes.
Mr. Diwan.
Yes.
Because once the officers will go, they are all on deputation with ECI.
Yes, yes.
Election Commission can decide that.
Look, Manoj, if they want to draw on this pool for replacing an AERO, I am not going to stand in the way. My respectful submission is that these micro observers, because the whole, what's our apprehension? I'm going to come to that. What is the purpose of this name mismatch? It's just to purge the
We'll come to
entire
that.
voters,
We'll come to that.
electors. That ought not to be allowed on a mass scale.
That's our anxiety.
We'll come to that, Millets, when we cross the bridge.
Yes.
We are coming to that part also.
Yes, Millets.
So first you can do that. There is
Yes.
no difficulty. You can replace your AEROs whom you find that they do not
And
have,
EROs also, who are not SDMs or SDOs.
whom you find that they do not have enough experience of performing this kind of quasi-judicial.
Precisely.
I'm not saying it's a quasi-judicial, but kind of quasi-judicial duty.
Exactly.
Because they have to apply their mind to the objections, pass a reasoned order.
Yes.
Right? That
Yes.
is one done.
That's one thing.
Now, second thing comes to this micro-observer.
Yes.
Yes.
Micro-observer is basically a team created by you for the purpose of assisting the ERO and AERO, right?
Yes.
Assistance for what kind of, what is the nature of that assistance?
I'll explain, Millets.
Yeah.
Millets, these micro observers, they sit during the process of hearing and they notice all the objections given or documents given, everything, etc. Then from the ERO or AERO, whoever conducts the inquiry, they collect them, they scrutinize, and on the website, they say they are perfect, you may consider. If they are not perfect, please relook into that. This is the advisory role they play.
This decision, to take this final decision that these objections are say perfect, that the name, there is no mismatch, actually it is a correct name. This decision will have to be taken by the ERO or
EROs.
ERO.
He has no role to play.
So they are only assisting them.
Exactly.
It is something that order we will have to pass them, but both
Now,
sides we are hearing.
let me submit, Millets.
Right?
Now let me submit.
So,
Now I'll submit, Millets. So once they all come to me, they needed, as we did with the earlier batch that's presently there, EROs, that's micro observers, they need at least 10 days training to be given. That's what we have done. They needed to be trained with regard to document perusal, the scrutiny and all these things. They have to do that one. Now, Millets, the hearing was over. Out of 1.51 crores, barring 14 lakhs, the rest hearing has been completed. The present batch, they were present during the process and they are scrutinizing that one. Now, Millets, if somebody has to be there, they can only supplement because they were the people who were present during the course of hearing. Now they are scrutinizing the documents. If I have...
even in those cases where the process of filing documents is complete, say 1 point something crore you are saying, the documents are yet to be scrutinized in those cases also.
But hearing, they had the advantage of being present and collecting them.
Fine. Okay,
Yes.
Fine, understandable. But the documents, final yes or no, with respect to acceptance or rejection of those documents is yet to be taken.
Yes, Minister. In the process. May I submit in the process? It may be done in a day or two.
Obviously, in the process. So if these officials, they which are being now sent, if they join tomorrow morning to your
Yes.
official, let them also go through those documents and give their assistance to you.
May I submit, Minister? Yes, I'm coming.
enhance
Let's not
the
jump to
quality
that
of-
one. I'm just coming. Yes, Minister.
It will enhance the quality of the decision making process.
Yes, Minister.
Because somebody,
Precisely.
decision is to be taken by the ERO and AERO.
Yes, Minister.
By taken by me and my brother.
Yes, Minister.
Arguments is your side.
Yes.
So instead of argument, it will not be an adversarial kind of adversary. Here somebody will say, I know Bengali, I know this reason, I know a little bit knowledge about this area. Here somebody, instead of DUTTA,
Yes.
somebody writes
Yes.
DATTO. Right? This is only something. Somebody may assist you and it might be a very convincing argument for you. You may accept.
Actually, Millets, for my lord's kind consideration, will give illustrative cases where we have flagged it saying that one, there is logical discrepancy. It's not been divorced from any common sense. We have found that where it is irreconcilable, we have employed a software which can as well identify the spelling mistake and it has ignored it. It has ignored it. Only when it comes. Please. Yes, let me complete. Yes, Millets.
Ground reality.
Yes, ma'am.
What is happening is there definitely may be logical discrepancy, but also with the application of the software, there may be a much wider net to which notices are going.
Yes, Millets.
It's creating a bit of a...
Could I send Millets a list?
that
Two lists we have prepared.
Yes.
As an example, we have prepared two lists. My lords could see where it's been flagged as to the discrepancy, where it has accepted, notwithstanding the minor variation.
Saying a difference of 50 years for grandparents
Yes, Millets.
would be a logical discrepancy.
Millets,
2020
yes.
being a reproductive age.
Yes,
Will 50 be a good window?
My lords, we kindly appreciate. All that we wanted is when it comes to mapping, whatever the details available in 2002, if you replicate them here, no questions asked.
We cannot restructure it. But
No.
program that you have put for the your software to work.
Yes, my
In certain cases may have a policy challenge.
Yes, my lords.
You're saying that the
That's why,
difference
my
of
lords.
20 years between parents and a child is a question because in India it's all cannot be an underage marriage. But these are not real ground realities.
Millets, actually, what we have done is that, Millets, each
Probably
elector
I
was
have
quiet.
has to be in this, referring to this age or gap in age is maybe that you are trying to identify that actually, if they are actually found to be really grandson and grandfather, then you can't have any objection. The only thing that this is only one of the tool to identify whether actually they are grandfather and
Actually, Millets,
Or
actually,
using this screen.
Millets, actually, it's only tip of the iceberg. I'll give an illustration. About 200, in two instances, 200 voters have traced their mapping to single parent. Is it possible? Yes, we have given the statistics.
ECI after.
Yes, Millets.
We have seen that there are persons with 50 grandchildren. Definitely you have a right to issue a notice.
We have, that's what we have done.
Person having 5 children, 6 children, you are issuing notice.
Millets, what has happened, Millets? My lords, may I appreciate one thing. If 2002 mapping corresponds with this one, no questions asked.
Yes,
about
questions-
5.6
questions
crores.
asked.
Millets,
Questions asked, sir.
when 5.6 crores has passed the muster, we have got
Notices are for mapped people.
mapped incorrectly. May I submit, Millets, with great respect, mapped incorrectly. Had there been,
Traceable to mapped people.
had there been syncing perfectly, no questions asked. Once it's been incongruous,
Perfectly, there the tools that you have applied to the software appears to be very restrictive tools. They are eliminating natural differences.
yes, Millets, could my lords have a look at the papers we have given as the examples of where it's not been flagged, where it's been flagged?
Is indicated. Surnames are of various forms. Roy, Ray.
Millets,
These
let
are
me put it, let me put it this
There
way.
is a common practice of Kumar being a middle name in Bengali households.
Yes, Millets.
So you have a Topon Kumar Rai.
Yes,
Topon Rai. Now the omission of Kumar in notice is being given.
Yes, Millets. May I submit, Millets? The whole thing has arisen on one concept.
नोटिस कर दिया त्याचा पण नाव आहे शुभेंदू नारायण सिन्हा.
Notice.
2003, your name is Yaya. You sent to Dori. How the hell is it the same?
Because they translated it and they did a CSV.
So you're telling me the
translation.
actual Bengali is very something else?
Yeah.
So check and say, give examples, right, sir? Check these names. And
This K. Krishna, Bala Krishna, it's bad translation. And notice, it has to be that. Baki must be a duck name, not a pet name. Yeah, the reality is.
we have to give against the explanations for past events.
I just submit, Millets. Kindly have a look at my notes. Since an issue has been raised, Millets, kindly have a look at my notes. Page 39 of my notes.
May I just complete my brief submission?
Yes, yes, well, surely, we are only trying to find out that if we can,
Please notice also.
no, if you want to make submission based on that.
Millets, since they have said, making a mountain out of this molehill, Millets.
Well, so I think we
have
should be
been-
heard first
Yes,
on this.
Please, let me complete, then you can have your say.
Now, on the continuity of what was argued on the previous date of hearing and what has emerged today.
Yes, Millets.
The last date of hearing was, they were since objecting to the micro observers brought from different.
Let them complete, Millets, I'll answer.
Yes.
No, we are not on that point. We are simply on the point which you are right now saying, that now these 8,500 something people are there sending. Let them report tomorrow. Let them also join the team of that assisting.
They need to be trained, Millets. Before that, the precondition is they need to be trained. Without training, they can't. They can't make head and tail of it because they're not experienced in that field. They have to be trained, Millets. By the time, the whole, my lords may appreciate, it's a time bound one. I need to just finish by the deadline. And then, my lords, if they have to be trained in the next 10 days, it's not that we're doing it for the first time for them. The previous batch too had 10 days.
Mr. Naidu, outsiders, officers who are not aware about the local conditions, you might require to train them, that they have to understand. Here it's not the question, you are not depending on them in the sense that you have to take a decision as per their advice. Decision your officers will take. You will simply say that this is the matriculation support certificate. Here it is saying that some, say, let us say P. Narayan Sinha, and the son is written only Prashant Sinha. Father is Pratyaksh, suppose Narayan Sinha, the son is only Prashant Sinha. So somebody can point out that yes, in the, as per the certificate, he happens to be the son of so and so. Maybe that the son does not write Narayan. That's all. Then you can think that whether what is the decision to be taken.
Well, if I'm not contradicting, let me submit humbly that an untrained professor is less skilled than a trained clerk. Sometimes they have more knowledge because they're practically hands-on experience. Here, we'll take them, we'll see their profile, we'll see their suitability. We have this migration, as lordships have permitted when it comes to EROs and AEROs. Remaining, if they are good enough, they can be trained within short time, and then we can employ to assist in the process. We're not excluding them, but we need to have the list. We'll scrutinize them, find the suitability, then we'll earmark which people we need to have. Because we have already had about 6,500 people. If they wanted to supplement, that I need to have. So that, let's let them provide the details. Now they have done that one.
It is coming to you today itself.
Yes, Minister.
Let them report tomorrow morning.
Yes, Minister.
Then you can have some, whatever bare scrutiny about their profile.
I need to,
Then
Minister.
you can immediately associate them. You see how worthy they are.
May I submit, Minister?
It is something today we are saying on judicial side that you require 3 years practice to become a judicial officer.
Yes, Minister.
There was a time when we said, no, you are not required. You come pass out law, you can.
Experience proved otherwise. That's why my lords have reimposed that.
So these things will continue to vary. You see them for how, to what extent they are useful to you. Simultaneously, you can start imparting training also. Training in the sense that you will sensitize them that this is how you have to scrutinize the document. That's what the training. You do that also.
Then next thing, we need to give them ID. We need to give them a portal access. All these logistics need takes place, Millets. My submission is that, Millets, let them report tomorrow. We'll scrutinize. Kindly have it either day after tomorrow or the next day. We'll come back and we'll report the position. If they are suitable, we are drafting in only to assist. Let it be, Millets.
May I just complete?
They can't just give it now and say that tomorrow they start functioning.
Okay,
so let it be. In 48 hours, we'll get back to your lordships, whatever feedback we could have about their suitability.
I'll just state my points now because we are pressed for time. So I'll just state my points. My primary position is that as far as these so-called logical discrepancies insofar as name is concerned and name mismatch is concerned, the default position ought to be that these people cannot be excluded. There has to be, sorry.
Mr. Diwan, principally we are saying that if somebody only because he spells the name with a different words.
Please add, Millets, please make a direction to that effect.
We cannot issue a direction because this will amount to preemptive direction to them to interfere in their functioning.
Millets, but I want to show you what they have said. I'll just take your lordships on that. Because these are on the 2002 list. Yes.
Notice is something different. Taking a decision is altogether different.
Sorry?
Taking decision is altogether different.
No, I understand.
Notice has been issued based upon some AI app or whatever it is.
Absolutely.
Now the person comes, look here, how have you doubted my identity? I am same thing.
Yes.
How can you doubt my identity?
Yes, correct.
So let us see after this verification of these documents.
Yes.
How many these notices are dropped?
Yes.
Suppose only 5%, 2%, 1% are left as doubtful cases. Your argument will also be in a different.
Yes, you're right.
But if suppose in 80% cases, these objections are turned down, the argument will be the same as you are arguing today.
All right. So fair enough. So Millets, then in which case? Millets, first of all, I agree with the observation made. That's a sort of a logical manner forward. I have no quarrel with that. They can come back. The issue, I should. Just a second.
No.
I should just mention one point because it may not dovetail with the timeline and the sequence which your lordship has indicated because we are trying to adhere to this. 14th of February, they are declaring the final list. 14th of February. Now with 10 days training, there's going to be no time to train these people. So the fait accompli which we are going to find is that on the 14th of February, there will be a final list. We won't know the exact points which your lordship said, whether it is 80% have been accepted or 90%, or there's been a wholesale rejection. There will be no question of pursuing an appellate remedy, because thereafter, as your lordship knows, that once there's a final electoral roll, there will be, and a notification follows, say, for the elections. That's the end of the day.
We visualized the situation and we made some arrangement in Bihar case. It's not that first time we are dealing with it.
Yes.
This kind of scenario situation had arisen in Bihar also, and we had introduced some.
So we don't want a mass exclusion, my lords. I think that's the sentiment also this court's concern. Now, my lords, may I go to my second point? So, my lords, as far as name and these other mismatches which your lordships have correct regarding number of progeny and the age, according to us, if so long as it's just a minor number which they eventually post screening come up with for deletion, it's one thing. But if it's going to be a mass exclusion and a purge, then it's an exercise where, my lords, the computer is a bit of a tyrant, is my respectful submission. That on the basis of some program and on the basis of some bias, you exclude people. So, my lords, that is my first set of submission.
Only speculative, Mr. Diwan.
Yes, but, my lords, my apprehension is, all right, fair enough, my lords, I made my point. Now, my lords, go to my next point. So, this is, my lords, as far as the micro observers are concerned, I want to make just 2 points. The first is, just take up, if your lordships would, my lords, there is a rejoinder. Just have a look at the rejoinder affidavit that I have filed. 2 documents I want to show you.
Which one?
Let's take it on.
Yeah. Your lordship will just take up my rejoinder on 2 pages.
In Dola.
339, 340.
In Dola Sen.
Filed on 7th Feb.
I give copies here. Oh, your lord, so, my lords, maybe I can be quicker. Your lordship has the note which I handed over last time. Your lordship has that note, correct? So it's the same document in the rejoinder. Please go directly, if your lordships would, to page 19, 19.
19 of today's note.
No, last time's note, my lords. We have now placed it on affidavit as well.
Yes,
Your lordship has page 19. Yeah, appendix 4.
19 is this.
Is appendix 4.
Yes. Your lordship has.
Handbook.
Now, this is the Observer's Handbook published by the Election Commission of India. Your lordship will find that on page 20 as well. Now, please see the role of micro observers. This is very important. Now, this is their own manual which I'm pointing to. Please see page 21, if I may just place it. Micro observers. The employees of the central government PSUs are appointed as micro observers. The micro observers are expected to observe the polling process on the day of poll. They are assigned duty in the polling station. They shall be part of the polling team and shall be seated in the polling station. They are to be present in the polling station before the mock poll starts. They shall report about the poll day in a given format. Report of micro observers. Micro observers are to be trained by the observers 2 days before the poll with the help of the RO and posted in the polling stations which are critical. Therefore, an arrangement is required wherein micro observers are stationed at a central. So now, my lords, this is their manual. Now, how if this is a micro observer on a polling day? I'm sorry.
This election, this manual.
Yes.
This observer's handbook.
Yes.
Is pertaining to the conducting the elections for SIR.
Yes, but that's the point. There's no other role for a micro observer, my lords. There's no statutory basis. Now see.
Once the micro observers are appointed in an SIR process,
yeah.
Mr. Diwan, that we will have to give this responsibility or this power to the ERO.
Yes, absolutely. No problem. The ERO can certainly exercise this power, but not a micro observer. Now, why the apprehension?
Micro observer, you are right. Micro observer cannot take a decision.
You're right. I'm obliged. Now, my lord, just take up my IA 26838. Just take up IA 26383.
Those who take decisions
IA
have been crying foul, saying that, please give us competent officers.
Just a second.
EROs
Just go to
and
page
AEROs,
106.
they have never provided. On a non-issue, they would like to make the whole attention. Ultimately, the orders are passed by EROs. And we wanted competent officers. Even in this list of 8,300 millets, I don't think there is any SDM or SDO.
Your lordships may just go to page 106.
Please kindly direct them to provide these officers who ultimately pass the order.
Will you get
I'm
8,000
just
SDMs?
completing my micro observer. I'm
From-
just completing
from
my
the-
point in answer to the Chief
From the
Justice's
government,
observation.
from the government rank and file only we want.
Yes, please
Not
just
from
go to page
outside.
106.
And they don't provide that one.
Will you just see page 106?
And we'll give the statutory base also, Mills, for micro observers.
You'll have to make 8,000 districts in Bengal if you want 8,000 SDMs.
Your Lordship has, my lords, page 106. It's a screenshot
Yes, yes.
of 26838. Your IA 26.
We'll
Justice Ancharia has.
left and
Now just go to the last, to go to the bottom screenshot, my lords. ECI Net login for micro observers. Elector present for hearing, yes, no, and action. I agree with your lord.
There is,
Sorry.
wrong document has been given here.
Petition,
This is the rejoinder.
petition, rejoinder.
Dolas and rejoinder.
Can you explain why, point out what is the document?
Oh, sorry. I.
The screenshot gives, I mean, it suggests that the micro observer has been given authority here to agree with the decision of the ERO. Just please see this. How can you have a application like this?
Millets,
Just
that's been
look at this.
changed, that's been changed, that's been informed. They're just flagging on that one. That was long back changed. Now they have got to
This is
only click
gross.
one button. We have provided that one too. An argument of prejudice without any substance.
Yeah, this is their own application over here.
We have changed it.
Changed it.
So if, so let us see, I think, anyway, we can, sure.
Show me that.
Yes, please see the last screenshot. It's on page 106. And at the foot, there's a heading, ECI Net login for micro observers. Elector present for the hearing, yes, no, action. I agree with the observation of the ERO or AERO. And I do not agree with the observation of the electoral, of the electoral officer or the additional ERO.
And the ERO is a.
That, you see, Mr. Diwan, is something like some lawyer arguing that, all right, I endorse the view of the.
No, but when this is, when this is given,
Millets, to cut short
this is
the whole
given
controversy.
across
Cut short the whole controversy, Millets. Kindly have a look at page 76.
That is the reason lakhs of cases have
Kindly have a look at page 76, Millets.
been kept pending lakhs of cases.
Millets, would my lords have a look at page 76 of my note?
Milord, let me
That
just
will
complete
answer.
now. Milord, I'll just complete.
Page
So, Milord,
76 of my note. Let me counter that. That's completely a false statement. Kindly have a look at page 76, Millets, of my note.
What is the note?
Kindly 76.
Yeah.
Page 76 of my note, Millets.
But why are we going to and fro like?
This is the role the micro observer plays, and we have given it. Kindly see, Millets. He has to click either of them. Does it amount to any way he's vetoing or taking a decision? Just have a look at it, Millets. 76. Submitted documents need to be reviewed. Go to the next elector. He could press either, but it doesn't bind the ERO. He has to take his own call. That's why we insisted that let there be a competent officer as an ERO.
But this is creating an extra election authority, my lords.
When I have got plenary
So
power,
anyway, I have now
need to
completed
have
my
the
point.
staff
I
as
now
I
go to my
desire.
next point. Milords, I go to my next point. Now, please just take up my rejoinder and just go to page 308, please. 308 of my rejoinder. It's a thick one, which we have placed. Now, this is a separate point. Your Lordships, I think we're looking at it.
Where is that rejoinder? Was it given earlier? Yes, rejoinder.
Yes.
Starts at 307.
Yes.
Starts at 307.
The document itself, my lords,
Starts at 307.
begins at 307. Justice Bhatia. Now, this is dated 22nd January.
No, this is with the 7th February.
Yes.
Yes, that's the one. Correct. If your Lordship is pleased to go to page 307.
307.
Your Lordship has it?
Annexure Y.
Annexure Y. Right. Now, this is what they published or issued on the 22nd of January after your 19th January order. Your Lordship may just note that. Now, please go to page 310. 310. They have a list there of acceptable identity documents for self, father, and mother. Your Lordship has that at page 310. So, this is the list which they publish. Now, please go, if your Lordships would, please go to page 312. Now, see the directions they're saying. Common observations as to why cases are doubtful and liable to be rejected. Your Lordship has that caption. So, these are general instructions being issued. Observation. only Aadhaar and so-called family register SECC enumeration data submitted to be rejected and decided thereupon. So the default position in their instructions is that even if you have a family register and Aadhaar, you have these two items, still the general direction is to be rejected. Now look at the next one. Aadhaar and admit card. Now your lordships had mentioned about the admit card specifically in your 19th January order. Aadhaar and admit card submitted, no other document which proves linkage to either parent's date of birth, place of birth, if born in between 1st July 87 and 2nd December 2004 or thereafter, doubtful and to be rejected. General instructions. Look at the next page, 313. Birth certificate, admit card, caste certificate, or self-submitted by born after 1st July 1987. No other document which proves linkage to either parent or place of birth, doubtful and to be rejected. And look at 6. Birth certificate, SIR extract of either parent, but name doesn't match of either parent. Name mismatch, no other document to be rejected. And ERO, AERO, BLO be under scrutiny. So wholesale, even if a person has 2 documents, leave alone 1, their list, as your lordship sees at page 310, is 1 document. 1 document. They are wholesale issuing general instructions, my lords. So you're going, this is the idea is not to include, the idea appears to be to mass exclude.
Mr. Diwan.
I'll answer all these things, my lords. I'll answer, my lords.
Yeah.
We are not done yet, my lords.
Yes, yes.
I also want to make submission. This interruption goes on. Some people maintain discipline, the others go on interrupting.
My lords, this preaching should stop from my friend.
Now, my lords, I'll just complete.
Don't interrupt.
Now, this was circulated. I'll complete. This was circulated. This was circulated under a WhatsApp message. This entire PowerPoint at page 326 on 23rd January 2026, after your lordship's order of 17th January. And the reason I mention this is that in their reply affidavit, they make an evasive denial saying you haven't produced any document in support of your claim. So we had to annex this particular document. Now, my lords, your lordships may just pick up my note, my lords, the note which we had submitted on the 4th of February. Just take that note for a moment. Which one, which way? And please go directly to page 22. Yeah.
Last word.
Yeah.
Last
Yeah.
word.
Now, this is suggestive of the extra legal role being given to these micro observers. Look at page 22 from their dashboard. Your lordship has appendix 5 written on top. Well, just my previous note, which your lordship was following.
Page 22.
22, appendix 5.
Appendix 4.
Your lordship has it? It's a table. It looks like this.
So many documents.
But I had handed in a note on the last occasion and then we replaced it.
Yes, you can refer to now.
Your lordships on page 22 have appendix 5?
Yes.
Yes. Now please see their dashboard. Notice delivered by BLO, yes. ERO, AERO action found okay. Role observers observation pending for observation and micro observers observation pending for observation. So our serious apprehension is that even after the ERO and AERO has found it to be okay, you are giving the trump virtually to the last say, to the micro observer. So this doesn't seem to be a fair manner of proceeding.
See, the ERO and AER also, that
found okay.
That means they are expected to wait for the observations of these two subordinate officials and then take a call.
But where's the question of taking the question I say is, where's the question of taking a call?
Taking a call in the sense that you have two opinions, assuming.
Yeah.
One says that these documents are genuine. The other says the document, no, this cannot be relied upon.
Yes. Yeah.
ERO is the final authority to take a decision.
Yes, absolutely. So, my lords, please, my lords, a direction to that effect that the ERO is the final decision to take a call on this. And that will
never has it been in controversy.
The process, my lord.
It's ERO who is the final authority. And ultimately, he takes a decision.
What's about that?
It's a non-issue, my lords. Ultimately, he takes a decision. That's why we have written 5 letters. Please give us competent officers
that is
with experience. They never provide. They themselves say that we have given Group C officers. Now they said this is the duty.
If all of you agree, we will pass a short order, short but little giving explain.
I have one submission, just one
No, I have
submission.
one submission, my lord. Kindly.
I,
My lord, I have one
I
submission.
waited for Mr. Devan to
My lord, I have
finish.
one submission.
Just my, just 1 minute.
My lord, I have
My
one
submission is only this. In the spirit of what fell from your lordships, that these 8,000 names are being given, they will carry out the exercise, etc. In the spirit of that, since 14th February is coming as a deadline, that final list cannot be published. In my view, if the final list is published, then the entire thing is a fait accompli with the exclusions. So as far as the
lord, I have
1.36 crore have been excluded, they will remain excluded and we won't have anything to say at that.
My lord, I have one submission. Just kindly allow me. my lord.
Lord, can I make a?
Point is this, my lord. This point is this. I am not restating their points. The point is this, my lord. Bundle of objections are being filed by some individual without disclosing their names, identity. Fair enough. But at the time of hearing, the objectors must remain present at the time of hearing. Otherwise, how do I know
We are
whether
going to regulate their internal functioning, so.
no internal no, my lord,
Law says,
kindly see the
To all of you in a 32.
my lord, kindly see the rules. Kindly see the rules. My lord, can I read
Lord,
the
can
rules?
I make a?
Item number 42, I raised
Lord, I-
provision.
Lord, I am in a different writ petition, my lord, where I have a contrary point of view.
in item number 42, I raised a little issue, my lord, regarding Aadhaar card. My lord, I know that your lordship
My
judgment
lord,
is reserved.
kindly, my lord, just I read
I
it.
know your lordship judgment is
Just
reserved
I
in
read the
item
rules.
42.
Just I read the rule 20 of the, my lord, the registration of elected rules 1960. The register officer shall hold a summary inquiry into every claim or objection in respect of which notice has been given under Rule 19 and shall record his decision thereon. 2. At the hearing, the claimant or as the case may be the objector and the person objected to any other person, when the opinion of the register officer is likely to be unresistant to him, shall be entitled to appear. Therefore, an objector who is filing 1,000 objections without disclosing his names, like an anonymous complaint.
I'll straight
I
away
must
answer
know
this.
when I have been asked to appear, who is that objector who has given the objection? Is it completely false objections but only for the purpose of, my lord, the harassing us? This is the, my lord, this thing is going.
I'll answer straight away, my
Item
lord.
42, my lord.
That's completely off the record.
Anonymous complaint.
It's never been an.
Lord, could your lordships?
Sorry, item number 42, I have very limited issues, my lord.
Someone is
I don't get a chance, my lord, to make a submission. What do I do?
putting his address like this, 5/1 West Bengal. And he is asking to delete the name on the ground of no Indian citizen. Whether the election commission will have any authority to decide who is a
That,
citizen.
we are not commenting on that.
My lord's
a non-adversarial suggestion.
This is the way it's being done. It should not.
May I make a non-adversarial suggestion? May I make a non-adversarial suggestion? I'm 40.6.
Effectively, what has happened, my lord, the police has got 2 persons who was carrying in an ambassador nearly
don't make
nearly 1,500.
Item number 40. In item number 42, I have limited issues.
My lord, a non-adversarial suggestion. My lord, I'm in 40.6. My lord, the statute contemplates this. The SIR, the problem which is arising on both sides is there's a looming deadline and there's a problem. My lord, the Act itself provides 21.3 that you can carry out the SIR, and the proviso says that there's no time limit given. Proviso itself provides that if till then the existing electoral roll remains. I just leave it to my lord.
In item number 42, my lord.
We are 40.
Issue, my lord. Item 42, my very limited issue on Aadhaar card. But I know that your lordship, there is reserve. But what happened in Bengal, my lord, the election commission has included Aadhaar card as item of 2012. The ground rate is what, my lord. During the submission of the claims, the electoral officer cannot.
Mr. Devan has already indicated that. Mr. Devan has already.
Yes, Mr.
My lord, can I, my lord, the writ petition number 1216 of 2025. My lord, that was a writ petition filed by an association stating that the election commission must be more involved in the deployment of safety and for the safety of the officers, my lord, in the course of conduct to the SIR also. Now, my lord, the question of conduct of elections comes a bit later. Now, my lord, I have filed there is a detailed additional affidavit which has been filed by the Election Commission pointing out that they have taken steps, but it has not proved to be adequate and sufficient. And therefore, what they say is that they are in touch with the government officials, but they have not been able to get the adequate number of security forces deployed. Now, my lord, there is also an indication, my lord, in the affidavit that there has been large-scale, my lord, burning of Form 7 objections in several places. Now, what ultimately, my lord, it has come to, insofar as the Election Commission is concerned, is that, my lord, they have given illustrations of, my lord, wholesale exhortations by members belonging to one political party, my lord, stating that these objections will not be permitted. Now, my lord, at one point of time, they even go on to say that it will not be possible to consider the objections unless, my lord, the objections are placed on record, my lord, before the officer who's considering them. Now, my lords, therefore, we have filed an IA, my lord, in this, and we have these are the reliefs, my lord, which we have
We have already issued directions on 19th January.
No, my lord, the directions are what we have stated, my lord, in this.
No, directions are to the Director General of Police, to all the Superintendent of Police, to
Correct.
all the collector.
My lord, apart from
The
that,
Election Commission find that despite those directions, the
Yes.
light order
Yes.
is not being well maintained.
yes, my lord, could your lordships, my lord, these are the
It's your Election Commission not powerless.
no,
We have,
no,
we
my
have
lord,
filed a detailed counter.
And the
yes,
process is
and
over.
detailed affidavit.
Bringing
my lord,
to
what we have
notice
just a moment,
the
Mr. Naik.
defiance and
My lord, these are.
This process is over, my
My
lord.
lord, I'll just complete this. My lord, this is what I have prayed for, my lord, in the IA. Let the Election Commission take note of it. Lordships may consider it. Let the state also say what they want to do. First direction would be a asked for is direct the Election Commission to extend the time for filing claims and objections by a period of 14 days because our objections have been burnt wholesale, my lord, in several places. It will go to, my lord, it will go to the advantage of those persons who have claims as well. But this time frame, my lord, if it is 14th of February, it proves to be completely inadequate. The second, my lord, we have also said, because this Election Commission is not getting sufficient cooperation from the local police, what we have said, let them respond to that. Direct the Election Commission to deploy central paramilitary forces and depute police officials from other states to the SIR centers to ensure their impartiality. Problem is, my lord, my learned friend has been
to
saying
my argument.
that the object
It's just contrary to my argument.
That's what
My learned friend's
Lord,
argument is
Lord, I am appearing for Union of India.
I have taken confidence by repetition.
Therefore, one
Lord,
gentleman.
if my argument was the same as that of my learned friend, I need have simply said that I adopt his argument.
Both of you are on the same page that there is more time necessary for verification and preparation of the final.
Yes.
You also say,
Yes.
objectors.
The reasons are
they
different.
say for the purpose of.
Correct, my lord, correct. Therefore, my lord, whatever it is,
And my lord,
let
the
the Election
statute,
Commission
my lord, the
respond to this
statute does not
and say
contemplate a time.
that they are extending the time.
Statute itself does not contemplate.
Statute doesn't contemplate, but that is done by the
And your lord-
machinery.
Yes, but my
your
lord, the
lordship's
SIR.
order.
Timeline, nothing
My
is
lord,
finalized.
Lordship's
Miller,
order
900
dated
voters.
91 covers his
500
concerns,
doesn't
my
cover.
lord. It covers.
It's a different, it's a completely different thing.
Comprehensively.
No.
Right now.
The
It
state
has
government
filed
doesn't
a response.
One aspect, my lord, if
doesn't
your lordship
want
permits.
anybody to
Filed a response. my
get
lord.
some more time to file objections.
Lord, can I, my
Filed a
lord, mention
comprehensive
something?
response.
Very
Addressing his
choice is
concerns.
that you want us to pass the order in court or we go inside and.
My lord, can I have 1 minute, my lord? My lord, I appear for Union of India.
You can also join.
No, my lord, I'll make only one or two statements, my lord. I'm not long. In Mr. Giri's petition, Union of India is joined as a party. Lord, there is already one detailed affidavit filed by the Election Commission of India a week before, and one affidavit is filed yesterday. My lord, one constitutional body intimating the highest court of the country, your lordships may see the contents. Lord, it is really, really alarming. Your lordships may take cognizance of it and may not pass some remedial directions.
That's what I want to take your lordships to that affidavit,
count.
additional affidavit filed by the.
Please go through that affidavit, my lord, otherwise it could be.
Somebody must
Give you linkage to all the.
But I join,
miscarriage of
I
justice,
agree with
my lord,
Mr. Shankara Narayanan. There must be some discipline in these matters.
In this petition, we should be made party. We are arguing here. We have not been made party.
Powerless. They should have, they can always ask for the, whatever central forces, paramilitary forces, state police, more state.
Well, let's
My lord,
wait.
kindly see the affidavits, my lord, it's
Let's
not
wait
just
state
central
government's
forces.
response in their rejoinder
Why
is,
it's not just
police is
central.
my subject, state subject, you have no control.
Correct.
They refuse to register FIRs when I have requested.
That is
And some officers, AEROs violated the directions. We have said that they should be replaced. They have not done that one. Certain
Your
good
lordships
officers,
are-
they
the
have
directions are,
transferred.
my lord,
We have
the
said,
violation.
don't transfer them.
Yes.
They said that you have no control. We have given every instance, every day, the leaders.
My lord, there is
whoever that-
wholesale burning of
You would
Form
be
7
killed.
objections.
You would be killed.
FIRs are not
We have
registered.
seen all the videos.
There is violence on the street. In SIR hearing, there is violence on the street.
And no safe
What do we do?
officer there.
Violence is instigated by leaders, my lord, that is really unfortunate.
Counter and an additional response.
Even CEO is not spared. Millet.
Please take that.
That has
Please
been
take that up,
lodged.
my lord.
Please go through that
We have
affidavit,
filed
my lord.
everything.
My lord, a
Along with the
message will
counter,
have to
we
go.
have filed all the complaints.
It's counter, my lords.
We have filed all the complaints.
My
My
lords,
lord,
may
a
I just
message must go that
government's
Constitution
counter?
of India applies to all states.
My lords, may I just take you to page
My
3?
lord, leaders of a political party exhorting that objections
Lords,
may
we
be,
can't
objections may be,
one
no,
over
you
Mr.
can't.
Giri.
Therefore, please let me complete it. Let me complete
Cannot
my
be
submissions, Ms.
anything,
Guruswamy.
Especially
Leaders of
constitutional functionaries.
political parties exhorting that objections be burnt. There is,
My lords,
there is, my lord, pervasive violence on the street.
We have provided-
Objections are not being heard. Quasi-judicial function is not being discharged. My lord, if there are claims, there are objections. My learned friend says there are 1,000 objections. Therefore, my lord, they want the objectors to be there. Let them be there.
crore.
But if they are, if the objections are being, burnt, Form 7 are being burnt, my lord, how will those persons come there? They are being destroyed.
1 crore objections.
My lord,
have been
all
heard. Page
anonymous
three of the-
Constitution must apply to all states in the country.
May I just take you to page 3 of your
That
counter?
message must go, my lord, that message must go. With
My
all
lord,
humility at my command.
in a place, my lord, in a minority constituency, just 1 minute, my lord. In a minority constituency,
The objectives will appear.
my lord,
You burn the objectives also.
just kindly say,
Millet.
in a place, my lord, where the minority remains, my lord, if there is 1,000 voters are there, 950, their names in the logical discrepancy, again in the objection. How it can be possible, my lord?
My lord, there is
How
one
it can be
application,
possible?
my lord. My lord, there is my IA in item 40.2, my lord, my IA for
All right, thank you very much now.
No, my lord, can issue notice in that way, it is fresh IA, my lord. And in fact, my lord, it is on behalf of the Vice President, Akhil Bharat Hindu Mahasabha.
Continuation of the ODD.
Before passing any order, please go through those replies and take care of the situation. That's the only thing I'm requesting.
See the state government's response.
Yes,
It should be made part of there.
Mamata Banerjee, my lord, that is, my lord, unheard of in the Indian constitutional history that she has come forward and filed petition before this honorable court and
What
will
is
also
that-
appear.
what is the unheard in it?
No, my lord,
That's
never
what
thought in
the
the
faith and
Indian
trust in the system,
constitutional
that's all.
history, never
She is having a right to file a
come
petition.
against the constitutional body.
There is nothing to
What is that? She is having a right to file a
Against
petition,
constitutional body,
like an ordinary citizen.
So we want that, please don't politicize these
No,
issues.
that's
We are-
why, my
we are
lord,
not
and
very
my
fond
lord,
of this.
my
Right.
lord, in entire, my lord, West Bengal, the demography is changing, my
February
lord, and we are in
2026. Now please stop.
petition.
4th February 2026. We have heard a battery of senior counsels on behalf of the state of West Bengal, its chief minister and other petitioners in the connected matters. Similarly, we have heard Naidu learned counsel for senior counsel for the Election Commission of India. Mr. Learned senior counsel for the on behalf of the Election Commission of India and other learned senior counsels representing the parties. Mr. Tushar Mehta from the Solicitor of India has also assisted us in the matter in the petition in bracket civil number 1216 of 2025, and he has made a pointed reference to the affidavit filed by the counter affidavit filed by the Union of India.
Which man?
Election Commission. Election Commission.
Counter affidavit
Two affidavits by the election.
by the Election Commission of India. Next paragraph. It may be noted at the outset that in the previous date of hearing, that is on 4th February 2026, Ms. Mamata Banerjee, the Chief Minister of the State of West Bengal, also appeared along with her senior counsel in a writ petition number so and so. The writ petition filed by her, mention the number of that. During the course of hearing, when an objection with regard to deployment of micro observers by the Election Commission of India was raised, it was pointed out by senior counsels representing the Election Commission of India that despite repeated requests, adequate manpower was not provided by the state government. Instead, in manpower of the certain categories of officials who were competent enough to discharge the quasi-judicial stroke assisting duties were not deployed, were not being provided stroke deployed by the state government to the Election Commission of India for completion of the SIR process. On this, the Chief Minister of the state made a statement that she was willing to provide the adequate manpower, the government of state government officials who are competent enough to perform these duties. Next paragraph. In purported compliance to the statement made before this court, we have been shown during the course of hearing that on February 7, 2026, the Chief Minister, the advocate on record, in writ petition number 129 of 2026, informed the senior counsels for the Election Commission of India on February 7, 2026 at 11:50.07 a.m. The state government is ready and willing to make available 8,505 numbers of Group B officers of the state government and or its instrumentalities for the SIR exercise in West Bengal. Next paragraph. When we inquired from Shangduan Senior Counsel, the mail, the Election Commission was asked to confirm whether about the requirement was required to confirm the need of such additional Group B officers, whereupon it was stated, that the requisite particulars of these officers shall be shared with the Election Commission of India. Next paragraph. During the course of hearing and on being inquired, it was fairly stated on behalf of the state of West Bengal, the Chief Minister of the state, that the list of list containing particulars of 8,505 number of Group B officers was not sent to the Election Commission so far, as they were awaiting the consent of the Commission in terms of mail dated February 7, 2026. So, however, during the course of hearing, a list of list of 8,505 group strictly to the Group B officers working in different departments of the state government, has been handed over to Shri Naidu, learned senior counsel presenting the Election Commission of India. That list has been also placed on record before us. Next paragraph. In order to streamline the ongoing process of SIR and also with a view to address some of the apprehensions being expressed by different stakeholders, we deem it appropriate to issue the following interim directions. 1I, the 8,505 officers whose list has been and while reiterating our directions issued on 19th January 2026, we deem it appropriate to issue the following additional directions. 1I, let the state government ensure that all the 8,505 Group B officers whose list has been handed over today in court, report for duty to the district electoral officers, EROs, tomorrow by 5 p.m. The Election Commission of India shall have the discretion to replace the direction number 2. The Election Commission of India shall have the discretion of replacing the EROs, AEROs.
To use their services.
No. First we are saying replacement. Replacement of the existing EROs, AEROs, and utilize the services of the officers who have now been placed on deputation with the Election Commission of India.
If they are suitable.
If so,
Micro observers.
if the election
Not
commission
ERO,
is satisfied
micro observers.
with regard to their qualifications,
UROs are senior.
placement of ERO or AERO only.
Essentially, EROs, Millets. Millets, the problem is this. In the whole list, there are no SDOs, there are no SDMs. If they are all department clerks, etc., having seniority to have the grade, Millets, we will ask them if necessary, they have to provide.
Micro observers.
Well, 8,000 is the 8,000
Five
micro
times we have
observers. They are
written.
replacing the micro observers.
Out of the are those
Anybody is found suitable, Millets.
subject to their suitability for the quasi judicial or semi quasi judicial responsibility. 3I, all the rest of the 8 officers, officials from the list of 8,505, the Election Commission, after brief scrutinization, after briefly scrutinizing their biodata or work experience, may shortlist them equivalent to how many micro observer you have?
8,500.
Over 8,000.
We have got 6,500 Millets.
May shortlist these officers equivalent to the strength of the micro observer already engaged. These state government officers, officials may be imparted a brief training of day or so for the purpose of for the purpose of providing assistance to the EROs, stroke AEROs, along with micro observers who have already been engaged. Next paragraph. It is made clear that the responsibilities assigned, stroke to be assigned to the micro observers or the state government officers, stroke officials shall be only to assist the EROs, stroke AEROs in the decision-making process. In other words, and as rightly stated by the Senior Counsel for the Election Commission of India, the decision will be taken by, the final decision will be taken by the EROs only, Next paragraph. Since with the engagement of new set of government officers, stroke officials, for the purpose of scrutinizing the documents which have already been submitted and where even the hearings have also taken place. Shall we run through that? Since the process of scrutinizing the documents submitted by the affected persons in the response to notices served on them is likely to take more time, and as suggested on behalf of some of the petitioners, we direct that at least 1 week more time beyond 14th February 2026 will be granted to the EROs, stroke AEROs for completing the scrutiny of the documents, and taking an appropriate decision. Next paragraph. As regard to so on behalf of the petitioners, a reference has been made to certain documents to suggest as if the micro observers are the final authority. This aspect has been clarified on behalf of the Election Commission of India that the micro observers as well as the government officers, stroke officials who will be taken on board for assisting the EROs from tomorrow onwards, shall only be assisting the prescribed statutory authority for the purpose of taking the final decision. Next paragraph. Mr. V.B. Green, Senior Counsel in writ petition number so and so has pointed out. Mr. V. Green, Senior Counsel in writ petition number so and so, as well as the Solicitor General of India has referred to the counter affidavit.
Counter affidavit and additional affidavit.
Mr. Naidu, Senior Counsel for the ECI, have referred to the counter affidavit filed by the Election Commission of India in that writ petition. It is alleged in paragraph so and so that despite making complaints by the authorities of the Election Commission of India, no FIRs are being registered against the persons who are suspected to be involved in burning the records of objection and or indulging in other alleged unlawful activities, burning or alleged unlawful activities.
Lords, I'm sorry to interrupt, my lords, we have responded in
This is
parent
being,
to the state.
just a minute, please.
Yes.
Though this is being strongly refuted by Dr. Menka Goswami, Senior Counsel,
Yes,
representing the state of West Bengal in that petition, we are reminded of our order dated 19th January 2026, in which a categorical direction was issued to the Director General of Police, Superintendent of Police, and the collectors in the state of West Bengal to ensure the maintenance of law and order. We therefore showcase the Director General of Police to file his personal affidavit in response to the allegations made by the Election Commission of India in its counter affidavit in the said petition. we make it clear that in case don't say anything. We will take a final call with respect to the powers of the Election Commission of India in this regard. But before doing so, we deem it appropriate to accord an opportunity to the Director General of Police to explain on his part. Next paragraph.
This one, no. This one, yes.
In relation to the documents.
Persons to whom notices have been served shall be entitled to rely upon all or any one of the documents referred to by the Election Commission of India
In the SIR notice.
in the SIR notice, and all such documents shall be considered by the EROs while taking a final decision.
About order written 9 January.
Including the documents referred to in our order dated 19th April, all the documents, including those referred to in our order dated 19th January 2026, shall be considered by the EROs while taking a final while passing order in response to while passing order on the objections received in response to the notices served.
And
May I
Lord,
only-
and the objections
item 40.
filed in Form 7, below. And the objections filed in Form 7.
To that extent, they will be wrong to say admit card. Admit card along with mother certificate. Then only it becomes relevant document.
May I add one thing, Millet?
Lordships are extending the time for filing claims. Could your Lordships are extending the time for filing claims? Could your Lordship say claim stroke objections, my Lord? Because both go together.
Similarly, the ERO shall be duty bound to consider the objections, if any, received from the person as per the statutory scheme. As per the statutory scheme, whether or not such persons come forward for person hearing. It goes without saying that the genuineness of the documents filed along with these objections can be scrutinized, verified in the same manner as the documents to be submitted by the objectors to be submitted by the affected person. Affected persons.
Millets.
Anything.
Item 42 may be tagged item 40. Item 42.
Millets, I need to add one sentence, Millets. Yes.
Objection is filed as non-citizen. That cannot be gone.
No, we will not.
Millets, may I add one thing?
Item 42 may be tagged with the item 40.
I have 1 minute.
Within the.
Item 42 may be tagged item 40.
File an objection.
May just-
Electors means within that constituency.
Millets, may I just say for one
Not
thing?
from the other constituency. Miller, statute makes such a provision that electors only, my lord, kindly see, Miller.
My lord, item 42.
Will be considered.
Miller, kindly hear that, Miller, objectors.
May I just have 1 minute?
Objectors
My
only
lords
can be
have
the
indicated
electors.
the
Electors
top
of that
ranked police
constituency,
officer must file an
not from the other constituency.
The top ranked
That
police
is under the
officer,
act itself.
Any elector.
Millets, the top ranked police officer must file an affidavit.
Any
My
elector of
lords have
that
directed
constituency. I am
in the
saying that
context of my counter.
Words, that constituency.
Millets,
There are also
counter
two
and
counters.
additional counter,
This is
because we have
counter
stated
filed by the
in the
state
additional
government.
counter, all the subsequent events also.
My lords,
Counter
the
and additional.
state has also filed
This
a
is-
counter.
Additional
Lords,
affidavit.
in
Actual affidavit.
40.6, my lords, the state has also
Millets.
filed a counter
The
affidavit.
second thing, Millets, there are instances that they are under deputation to me. Some erring officials were there. We have pointed out, we have taken action, we have recommended that should be implemented. That's not been implemented. They should implement whatever we
That will not be a
wanted.
landlord, bro. That will be the state, that civil administration.
Millets, we have
EROs
given
were
instances where
not
they
decide
refused.
uninfluenced by any of these
Millets,
observations and
Millets, we
directions.
have asked certain officers who have acted illegally to be placed under suspension. They have simply ignored. And on the other hand, when we wanted certain officers to be on the duty, they have transferred, though they are under my deputation.
Mr. Pant, you verify this fact.
Yes, Millets. And the last one, Millets, and the last one. My lords have said those documents have to be verified in the manner permitted by law. Documents issued by the competent authorities.
That's right.
That's all,
Yes.
Millets, we want.
That's right.
That needs to be issued by competent authority, otherwise that leads to conflict.
Obviously, otherwise somebody will. ask
Yes,
to
Millets,
have
anybody,
right, a surplus
yes.
right, that
This is
not-
ECI requirement.
My lord, intervention application.
I would respectfully submit the EROs to decide uninfluenced. my lord.
To place some officers to take disciplinary action or to place them under suspension. We hope that your state government remember the law on this point and you take.
Given instances.
Sir, we have already responded.
Let
to
Chief Secretary also file an affidavit.
We have given instances, not airy fairy.
In any case, you relieve those officers from duty.
We'll do that, Millets. We'll take it into our hands and do something.
The election commission जहाँ पे है ना, shall be at liberty to replace the officers who have been found, who have been prima facie found to have erred in performing their duties.
Great.
My lord, on the
Deeply
intervention application.
Lord, would your lordship observe that the EROs are to decide uninfluenced by any of these?
Said so. Yeah,
You remember that PPT, my lords, where
We have had it
PPT
twice.
is an academic
that they are
exercise and
only
a training.
They will only.
Millets,
No, but
PPT
this
is
applies-
Item 42 may be tagged under 40, my lord.
It is
Identical matter.
action is by ECI.
Item 42 may be tagged with.
Influence law.
My lord, in item 40.2, my lord, notice may be issued on the.
My lord, item 42 may be tagged with item 40, my lord. Item 42 on same point, can tag with item 40, my lord. Item 42, I have raised a question on the Aadhaar card, my lord. 42, well, can you tag with 40, my lord?
Will.
My point is, my point is, some,
The speed with which all these West Bengal writ petitions are coming, I will issue the registry instruction not to entertain any.
my point is, my Justice Bhakti said me that my point is covered. I have some other point.
Sir, can you hear me?
Item 32, my lord, can I mention something else?
State of West Bengal is itself is before us. This constitutional umbrella is before.
But this point has not been taken, my lord. This point has not, my point is very short, my lord. During submission of my claim that the electoral officers cannot, my lord, upload the Aadhaar card as a single document. This is my point.
All right, thank you very much. Thank you.
But item 40
Can I mention, my lord, one matter? Item 32.
Item 32.
Item 32 is the matter of the hospital where we want to lay the road,
Thank God you are not
approach
talking
road.
about election.
my lord, kindly 42 may tag with that 40, my lord.
32, what is 32?
Can it be on Monday high up on board, my lord, if your lordships can?
For the hospital.
Lord, item 28 is for settlement.
Kindly keep it high up on Monday.
32, Mr. Mehta, you want next Monday?
Yes, my lord, the entire hospital is ready, but we are operating only on OPD because ambulance approach road is not constructed.
My lord, item 28.
Next Monday.
Lord, item 28 is
And
settlement.
kindly tag, my lord, kindly tag it. Kindly 42 tag.
Show date. That show date will be running between this very week by Monday adjust.
Lordship, please.
And kindly tag it, my lord, 42. Kindly 42, item 42 with 40, only tag it, my lord. So identical issues, my lord, there.
We have tagged, sir. We are hearing your matter also.
Kindly, within 40. I want to tag, come within 40, my lord.
I have heard you also today, please.
Yes, my lord. Kindly make it 40, my lord.
Next date again, we will hear you.
My item number 48.
Item number 48, my lord.
Really?
Item number 48. We are not against.
Those who have, all right, those who have not been able to exhaust today, we will exhaust them next day.
Obliged to your lordship.